How is it? The routine function.
Page wise, page number 1, page number 1, serial number 1 to 3, page number 2, serial number 4 to 10.
Only character request panel.
Page number 3, serial number 11 to 17.
ECR ಬರ್ಬೇಕು ಅದರಲ್ಲಿ ಲಯಬಿಲಿಟಿ ಚಾರ್ಜ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ECR ಬರ್ತಿಲ್ಲ
I hearing it. Then we'll go for TCR. I dispose of the TCR. Next.
Page number 4, serial number 18 to 22.
Have you intimated the other side? Have you intimated the other side? Madkond bani. Madi. Amele.
Serial number 23 to 29.
Number 27 I think for applying peak time on that outside also.
Have you intimated the other side? Name Venkish. Intimate ಮಾಡಿದಿರಲ್ಲ Learner Council serial number 27. Learner Council for appellant 6 short accommodation least after 2 weeks. Serial number 25. As per request of the Learner Council for appellant, refer the matter to Lokadana. But the regular routine course of Bandaga attend ಮಾಡ್ತೀವಿ.
Page number 6, serial number 30 to 33. Page number 7, serial number 34 to 40.
Serial number 37 definitely. The other side is also referred to Lokadana.
As per request, refer the 38. 37. Refer the matter to Lokadana.
Page number 8, serial number 41 to 44.
My lord, serial number 43, my lord. Serial number 43. Kindly next week, my lord. I am out of station.
ಒಂದು ನಿಮಿಷ ವಕೀಲರು ಒಂದು ನಿಮಿಷ. As 41 as per request. Is the matter next week. Yes, ವಕೀಲರೇ.
43, my lord. 43. I am out of station, my lord. Kindly next week.
As per the request of the Learner Council for appellant, please the matter next week. 43.
Obliged, my lord.
Page number 9, serial number 45 to 49.
45. ವಕಾಲತ್ ಹಾಕಿದ್ರೆ deep time ಇದೆ.
You are for R1, na? As per request, please the matter next week.
Number 1, order of matter, serial number 1, A. Venkatesh.
My lord, I am appearing for the appellant, my lord. Paper publication file ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಮುಂದೆ ಅದು ಬಂದಿಲ್ಲ ಅಷ್ಟೇ my lord.
ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
27 ಆಗಸ್ಟ್ 22 ನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ my lord.
ತರಿಸ್ಕೊ ನೋಡೋಣ.
ಆಯ್ತು ಸ್ವಾಮಿ.
Number 2, DJ Kumar.
My lord, I am for the appellant, my lord. A week's time may be granted to pay the PF for the second time.
As per request, a week's time is granted for Learner Council for appellant. Next.
Number 3,
This
respondent number 1 is a husband. Respondent number 2 is a wife. Respondent 1 is represented by GR law firm anta. They can be a director.
It cannot direct. Two individual persons, ganda anti ganda over representation idare avrige notice koda. It is the discretion, personal liberty. You cannot take
1 week.
as per request. 1 week.
Number 4, AM Mukesh. Number 4.
My lord, RR collected matters, my lord. 2 weeks time I granted to take steps to all cases, my lord. 4, 5 and 6 continuously, my lord.
Last time or time ತಗೊಂಡಿದ್ದೀನಿ.
ಇಲ್ಲ second time ಬಂದಿದೆ, my lord.
As per request, least after 2 weeks.
Please, my lord. Oblige.
Number 7, is Sitaram Rao.
8066 of 2007.
8066. The learned counsel for appellant submit that needful will be done during the course of the day. Office to verify and proceed further. List the matter along with MFA 8066 of 2017.
Number 8, Arjun. Number 9, Nagaraj Lecture.
Office may be directed to.
But I'll take notice for R2, my lord.
Notice may be directed to.
I'll take notice for R2. I'll take notice for R2.
P. Vijay Kumar takes notice for R2. The learned counsel for appellant is directed to serve the sufficient set of copies to the learned counsel for respondent number 2. Please the matter for admission after 2 weeks. Vijay Kumar our notice ತಗೊಂಡಿದ್ದಾರೆ ಅವ್ರ ಕೊಡಿ copies ಎಲ್ಲ.
Number 10, Timpala.
The learned counsel for appellant submit that needful has been done to verify and proceed further.
12, O Mahesh.
Pay for the appellant, my lord. Shara for R6 is not forthcoming, my lord.
Which number?
Sir, there is no such number ಅಂತ ಹೇಳಿ written ಆಗಿದೆ notice.
I'll take steps, my lord.
Steps after 1 week.
Number 12.
Appellant in this case, my lord. My lord, this act only policy, the appellant's risk is not covered. I am not liable to pay any compensation to appellant. Let the records will be called for, my lord. I have tendered evidence and I have produced the policy copy.
So you are disputing the liability itself.
I don't get any liability in view of the Supreme Court judgment in Balakrishna case.
Call for TCS.
Number 13, Ailesh Balan.
I appear for the appellant, my lord. Paper publication ತಗೊಂಡಿದ್ದೀನಿ R2 ಗೆ.
In notice to respond number 2 is duly published in Kannada Daily Times Karnataka dated 27th July 22. The respond number 2 called out absent, service is held sufficient. Is the matter for admission.
Number 14, Harish M. It is Grania.
Point 1. Inform my friend to get the correct address.
No such address into Bandhi as per request of the learned counsel for. You have filed NOC power. So Harish M round off agbeka. The office is direct. Verify ಮಾಡ್ಕೊಡ್ರಿ. As per request of the learned counsel for appellate list of one.
Hearing on the application matter, number 15, Vimalaya.
Girimalaya appear for appellant Miller. 11 days delay in filing appeal.
Yes, ಏನ್ ಹೇಳ್ತೀರಿ ಸುಮ್ನೆ heard the learned counsel for a respondent, appellant as well as respondent. I-1 of 18 is filed for condonation of delay of 11 days in filing the appeal. Considering the ground surge in I number 1 of 18, the same is allowed by condoning delay of 11 days in filing the appeal. PCS ಬೇಕಾ? Only quantum. Other quantum idru nature of ಏನ್ ಇತ್ತು ಅಂದ್ರೆ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. Pain and suffering put together 20,000, food and nourishment, medical expense 11,000, income 18,000, loss of future earning 93, medical expense 10,000, amenities ಕೊಟ್ಟಿಲ್ಲ. ಯಾವುದು TBI and fibula?
Both the fractures operated and open definitely which was done. After complete treatment, it's a permanent disability to the extent of 45% to the right lower limb and 15% to the whole body.
Oh, 15 TBI and fibula 15% to the whole body. Very interesting. 15% ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. To whole body ಅದು TBI fibula bone ಗೆ whole body 15% ಅಂದ್ರೆ exorbitant ಆಯ್ತದು. Then you cannot get more than that at any cost. ಏನ್ ಬೇಕಾದ್ರೆ ಆಪರೇಷನ್ ಆದ್ರೂ ಅಷ್ಟೇ ರೀ. TBI and fibula they are to be considered as common single bone only. ನಿಮ್ಗೆ ಒಂದು 10% ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ. No sir, no. 8% ತಗೊಳ್ತಾರೆ ನಾರ್ಮಲಿ. 2016 ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 6,000 ತಗೊಂಡಿದ್ದಾರೆ. 9,500. Correct.
Loss of earning during treatment
ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ.
Regarding future medical expenses, my lord. There is evidence of the doctor. She has to undergo one more surgery for removal and for that she has to
For removal of implant ಅಷ್ಟೇ. ಅವ್ರು ಹೇಳ್ತಾರೆ 20,000. ಪ್ರೈವೇಟ್ ಡಾಕ್ಟರ್ ನೀವು ಒಂದು ಮೆಡಿಕ್ಲೇಮ್ ತಗೊಂಡ್ರಂದ್ರೆ 1 ಲಕ್ಷ ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ ಅವರು. ದಟ್ ಈಸ್ ಯಾವ್ದೋ ದುಡ್ಡು ಎಲ್ಲಮ್ಮನ ಜಾತ್ರೆ ನಡೀತದ ಅಲ್ಲಿ. Amenities ಕೊಟ್ಟಿಲ್ಲ, ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ಅಲ್ಲ ವಿಲ್ ಗ್ರಾಂಟ್ ಇಟ್. ಒಟ್ಟು ಎಷ್ಟು ಸಲ ಬಿಡಿ ಅದು. ಅದಕ್ಕೆ ಡಿಸಬಿಲಿಟಿ ತಗೊಂಡಿದ್ದು, ಅದಕ್ಕೆ 10% ತಗೊಂಡಿದ್ದಾರೆ. ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಬಿನ್ 8%, ಅದಕ್ಕೆ 10% ತಗೊಂಡಿದ್ದಾರೆ ಅವರು. By the consent of the matter is listed for hearing on it, by consent of the parties it is taken up for final disposal. The appeal is filed under section 166 of the any act by the claimant, 173(1) of any act by the claimant seeking enhancement of the compensation awarded in emission number 8348 of 2016 on the file of 22nd additional small court judges and 20th additional CMM and MACT Bangalore SCCH 24. There is no serious dispute regarding factual matrix of the case. Admittedly, on 16/12/2016 at 2 p.m., the petitioner was proceeding by the side of the football on Honsanhalli Anchetti Road near Ganganhalli village of Kodihalli Hobli, Kanakpura Taluka, and at that time, the rider of TVS XL motorcycle bearing KA 41 EG 3578 dashed against the petitioner, resulting in the accident. The petitioner sustained fracture of tibia and fibula of the right leg. She claims to be permanently disabled and hence she filed a claim petition under section 166 of INU Act, claiming compensation of rupees 20 lakhs on account of injuries sustained by her in the road traffic accident. Next, the tribunal, after assessing the oral as well as documentary evidence, has awarded a total compensation of rupees 1,93,000 with interest at the rate of 8% per annum under following heads. Being aggrieved by this award, the claimant appellant is before this court seeking enhancement. Heard the learned counsel for appellant, claimant, and learned counsel for respondent insurer. There is the records. The learned counsel for appellant claimant would contend that the tribunal has taken disability on lower side and further income was also taken on lower side. He would further submit that the compensation awarded under head of future medical expenses on lower side and no compensation was awarded under the head of loss of amenities in the life. Hence, he would seek for enhancement of the compensation. Per contra, the learned counsel for the respondent insurer would support the judgment and award asked by the tribunal. Having heard the arguments and perusing the records, it is evident that the claimant had suffered fracture of tibia and fibula of right leg. The tribunal has considered the disability at 10% to the whole body, though it is argued that the medical evidence disclosed the disability to the extent of 15% to the whole body. The tribunal has taken it on lower side. However, no material evidence is substantiated, and considering the nature of the fracture, the disability taken by the tribunal at 10% is just and proper and does not call for any interference. Next, the tribunal has taken the income at 6%, 6,000 per month. Admittedly, the extent has occurred in the year 2016, and this court is consistently taking the income at 9,500 per month in respect of the extents occurred in the year 2016. Hence, the tribunal has erred in taking the income at 6,000 per month. The tribunal has properly applied the multiplier 30(1)(3), considering the age of the claimant. What is the age? Where the age is? He was here. Have you produced the Aadhaar card to disclose the age? Have you produced it? ಅಂತ ಕೇಳಿದೆ ನಾನು. The age was considered as 45 years by the tribunal, which is not under serious dispute, but the tribunal has taken and has applied the multiplier 13 as regards age between 41 to 45. Multiplier 14 is applicable.
21 and court has come to conclusion. Material evidence to show the age of petitioner, document available on record is ration card. Disclosed the petitioner was aged about 45 years on 8/3/2016. Into the accident of Galen another considering that Malani she was aged about 40.
Where it is referred?
21. Next page in the tag in the ಅರ್ಜಿದಾರರಿಗೆ ಮೂಲ ಕೆಳಗಡೆ 10% ಒಳಗಡೆ disability ಇರ್ತದೆ. So there is a loss of income to also. As per the hospital and police record, her age is 45 years at the time of accident. In this regard, she has not produced any material evidence to show the age of the petitioner. The document available on record, that is ration card, discloses that the petitioner was aged about 45 years as on 2013. Accident was in 2016. 45 ಮೂರರಿಂದ ಅಲ್ಲಿಗೆ 48 ವರ್ಷ.
ನೀವೇ ಹೇಳ್ಬೇಕು. See, she was shown to be 45 years as on 8/2/2013. That is issuance of ration card. Then she should be aged about 3 years added 48 ಆಯ್ತು. ಮೆಡಿಕಲ್ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಿಮ್ದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲ, ದೆನ್ ಆಧಾರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ. ಮತ್ತೆ ಅಲ್ಲ, ನೋಡಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಅದನ್ನ ಟೆಂಡರ್ ಮಾಡಿಲ್ಲ ಎವಿಡೆನ್ಸ್ಗೆ. ದಿ ಏಜ್ ಮೇ ಬಿ ಸ್ಟಿಲ್ ಮೋರ್. ಆಧಾರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ನೀವು. ಟೆಂಡರ್ ನಾಟ್ ಟೆಂಡರ್ಡ್ ಇನ್ ಎವಿಡೆನ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಹೇಳ ಫೈಲಿಂಗ್ ಬೇಡ, ಟೆಂಡರ್ ಅದನ್ನ ಎವಿಡೆನ್ಸ್ ಟೆಂಡರ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಅದು ಕಟ್ ಮಾಡ್ರಿ. ದಿ ಟ್ರಿಬ್ಯುನಲ್ ಆಫ್ಟರ್ ಅಪ್ರಿಸಿಯೇಟಿಂಗ್ ದಿ ರೇಷನ್ ಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಬೈ ದಿ ಕ್ಲೇಮಂಟ್ came to the conclusion that age of the claimant is more than 45 years as on the date of the accident, and hence multiplier 13 is made applicable. This finding is based on documentary evidence and hence does not call for any interference. Under such circumstances, loss of future earnings would work out 9,500 into 12 into 13. Mr. 1,48,000 round figure. 200. The tribunal has awarded next. compensation of 40,000 under the head of pain and suffering, which does not call for any interference. However, a tribunal has not awarded any compensation under the head of loss of amenities, and considering the nature of injuries, I propose to award rupees 25,000 under the head of loss of amenities. 25,000. The tribunal awarded rupees 20,000 under the food and nourishment, conveyance and attendance charges, which does not call for any interference. The tribunal has also awarded medical expenses to the tune of rupees 11,419 and based on records which does not call for any interference. Next, the tribunal has awarded 18,000 under the head of loss of income during treatment period, taking the salary at rupees 6,000 per month. Considering the fact that the notional income is taken at 9,000 per month, the loss of income for 3 months would 9,000 would work out 28,500 as against 18,000. Under the head of loss of future running, the claimant would be entitled for 1,48,200 as against 93,600 awarded by the tribunal. Next, the tribunal has awarded future medical expenses to the tune of rupees 10,000. The learned counsel for appellant would contend that it is on lower side considering the evidence of the doctor. But however, considering the fact that total medical bills after treatment itself work out to be 11,419, the question of awarding 20,000 as claimed by as deposed by the medical officer under the head of future medical expenses does not arise at all. And tribunal has rightly awarded rupees 10,000 under the head of future medical expenses. As such, claimant would be entitled for total compensation of rupees so and so. Chart mud pain and suffering 40, loss of amenities 25, food and nourishment 20, medical expense 11,419, loss of income during treatment for 3 months 28,500, loss of future running 148,200, future medical expenses 10,000. Hence, claimant would be entitled for rupees so and so as against 1,93,000 awarded by the tribunal. As such, appeal is to be allowed in part and the future interest since you have not challenged it, I'll not change the interest 8% awarded by the tribunal, but as regards the enhanced amount, it will be 6. Appeal needs to be allowed. The appeal is allowed in part. The claimant is held entitled for total compensation of rupees so and so as against 1,93,000 awarded by the tribunal. Next, the enhanced compensation of rupees so and so shall carry interest at the rate of 6% from the date of action till the date of realization. The insurance company, respond number 1, the insurance company is directed to deposit the entire enhanced compensation with accrued interest within a period of 6 weeks. The entire enhanced compensation shall be released in favor of the claimant. Delay. Heard the learned counsel for respondent. Where is the records? I-1 of 2019 is allowed. I-1 of 2019 is filed for condonation of delay of 340 days in filing the appeal. Considering the grounds urged, I-1 of 19 is allowed and delay of 340 days is condoned subject to denial of interest for the said period. Dismiss agida claim petition. Matte bande illalla avaru. List the matter for admission after Disposal of the matter to the trial court was not intimated by an advocate. Dispute? Huh. Yeah, so you mean to say that when a client has engaged an advocate, wholesale duty of the advocate to get the matter disposal and go to approach the client and intimate him and pay the awarded amount? Most worst negligence. Is it not his duty to follow up his case? ಮತ್ತೆ advocate ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ he is supposed to wait for a reasonable period and he should be regularly in touch with his counsel. ಮತ್ತೆ ಇಲ್ಲಿ ಹೆಂಗಾಗಿದೆ ಹೋಲ್ಸೇಲ್ ಅಡ್ವೊಕೇಟ್ ಒಂದ್ ಕೊಟ್ಬಿಟ್ಟಿವಿ ನೀವ್ ಏನ್ ಮಾಡ್ತೀರಿ ಮಾಡಿ ನಮ್ಗೆ ಇಷ್ಟು ಕೊಡಿ ಅನ್ನೋ ಲೆಕ್ಕದಾಗ. Yes. Merits meg I am not hearing it. Yes, delay in heard the learned counsel for learned counsels appearing for parties. I-1 of 2019 is filed for condonation of delay of 947 days in filing the appeal. It is argued that the counsel has not intimated the disposal of the matter to the claimant appellant. However, it is the duty of the claimant appellant also to approach his counsel to ascertain the stage of his matter. He is also equally negligent in prosecuting the matter. However, considering the ground searched, I-1 of 2019 is allowed and delay of 947 days is condoned subject to denial of interest for the said period. Call for TCRs. That will not be considered now. It cannot be production of documents. It cannot be disposed of here. It should be disposed of along with appeal.
Number 18, Najib B.
Appearing for the appellant in this case. This case, my lord, challenging the quantum of compensation ordered by the tribunal.
We have filed a appeal challenging the liability, na?
ಇಲ್ಲ ಸ್ವಾಮಿ, quantum, only quantum.
ಎರಡು appeal ಅವಲ್ಲ?
ಒಂದು claimant's enhancement ಹಾಕಿದ್ದಾರೆ.
So claimant has filed an appeal for enhancement. And you have filed for challenging
Reduction.
on the count of quantum. Liability is undisputed.
No dispute. No, not disputed.
Okay.
The date of accident is 19/12/2015.
19/12/2015.
15 mila. The deceased was working as a painting contractor ಅಂತ ಹೇಳ್ತಾರೆ. There is no material to show that he was.
What is the age of the deceased?
48 years ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
What is the income taken by the
income 9,000 has been considered, my lord. Yeah, according to the chart, 9,000 is proper. ಆ ಇಯರ್ಗೆ ಅಷ್ಟೇ ಇದೆ.
9,000 ತಗೊಂಡಿದ್ದಾರೆ.
ಹೌದು, ಬಟ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೊಂಡಿಲ್ಲ. ಕನ್ವೆನ್ಷನಲ್ ಅಲ್ಲಿ 2,75,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
Future prospects were not taken.
Not taken.
So 25% add ಆಗುತ್ತೆ.
ಹೌದು, 25% ಆಡ್ ಆಗ್ಬೇಕು. ಕನ್ವೆನ್ಷನಲ್ ಅಲ್ಲಿ 2,75,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ನಂಬರ್ ಆಫ್ ಡಿಪೆಂಡೆನ್ಸ್ ಅಂತಂದ್ರೆ ಲಾಸ್ ಆಫ್ ಕನ್ಸೋರ್ಷಿಯಂ ಪಾರ್ಟಿ ಈಚ್ ಅಂದ್ರೆ 5 ಜನ ಇದ್ದಾರೆ. 2 ಲಕ್ಷ ಆಗುತ್ತೆ. ಮತ್ತೆ 15,000 30,000 ಕೊಡ್ಬೇಕು. ಫಿಂಡಲ್ ಮತ್ತೆ ಎಸ್ಟೇಟ್ 2,30,000 ಆಗುತ್ತೆ ಸರ್, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 2,75,000. Tribunal has given a finding that second and third respondents are major, therefore 1/3 has been deducted. There are 17 of the judgment, my lord. There is a discussion.
One minute. So according to you, under conventional heads 275 in place of 275 230 ಬರಬೇಕಾಗಿತ್ತು.
ಹೌದು ಹೌದು ಸರ್
ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
That was your ground.
ಹೌದು. So far as deduction is concerned, para 17 of the judgment may kindly be.
Yes, Sukhilra, that is the only.
Ashte, sir, ashte. That's the only.
But is there any evidence to show that petitioners 2 and claimants 2 and 3 are employed?
Employed ಅನ್ನಕ್ಕೆ ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ. But majors ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
Clearly majors is not a ground ಅಲ್ಲ. He is the father.
ಅದೇ 20 ವರ್ಷ ಆಗಿರೋದ್ರಿಂದ ಮೂರನೇ ಮಗನ 20 ವರ್ಷ ಇದೆ.
ಅಲ್ಲ 20 ವರ್ಷ ಇದೆ.
ಹೌದು.
But they are not employed.
ಅಲ್ಲ ಅದ್ರ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಏನು ದಾಖಲೆ ಇಲ್ಲ.
Yes, Sukhilra, ನೀವೇನು?
Fairly submitted all aspects. One thing, my lord, I will permit to proceed. Respect to my lord, deduction of 1/3 instead of 1/4. The worship may kindly consider, my lord, kindly deduct 1/4, my lord, not 1/3.
Have you laid any evidence that they are not, they are dependent? Age 20-21 years, they have attained majority. Whether is there any evidence that they are attending the college or school?
Just stated in the evidence, my lord, not they have placed any document with respect to studying or any other course. Just, my lord, depend on the age, my lord, they have made the case. Then another thing, my lord, they are training, not very remote area. Not being in the age of, my lord, at the age of, my lord, 21 years.
Yes, Sukhilra, ಏನು ಹೇಳ್ತೀರಿ ನೀವು? Have you specific defense that they are the earning members?
ಅದೇ ಸ್ವಾಮಿ ಅವ್ರದ್ದು ಯಾವ್ದು ಸ್ಟಡಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅದು ಯಾವ್ದು ಹಾಕಿಲ್ಲ ಅನ್ನೋದು ಒಂದಷ್ಟೇ.
ಹಾಕ್ಲಿಲ್ಲ, ಬಟ್ ದೇ have deposed. But is there any specific evidence led by you that they are earning members?
ಇಲ್ಲ ಸರ್, ನಮ್ದು ಎವಿಡೆನ್ಸ್ ಯಾವ್ದು ಇಲ್ಲ. ನಮ್ದು
ಸಜೆಷನ್ ಮಾಡಿದೀರಾ?
ಅದನ್ನ ಮೇಜರ್ಸ್ ಅಂತ ಮಾಡಿದೀವಿ.
ಅಲ್ಲ ಮೇಜರ್ಸ್ ಅದನ್ನ ಸಜೆಷನ್ ಮಾಡ್ಬೇಕಾಗಿ ಇಟ್ ಇಸ್ ಬೋರ್ನ್ ಔಟ್ ಫ್ರಮ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಓನ್ಲಿ. ಹ್ಯಾವ್ ಯು ಸಜೆಸ್ಟೆಡ್ that they are the earning members, so they are not dependent ಅಂತ ಹೇಳಿ ಏನು ಸಜೆಷನ್ ಇದೆನಾ ಅಂತ ಕೇಳಿದೆ. In the evidence of PW1 ನೋಡಿ ಹೇಳಿ. ನೋ ಪ್ರಾಬ್ಲಮ್. ಕ್ರಾಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರ ಅವರು. ರೂಟೀನ್ ಕೋರ್ಸ್ ಕ್ರಾಸ್
ಮಾಮೂಲ ಏನ್ ಸ್ಟಡಿ ಮಾಡ್ತಿದ್ರು, ಏನ್ ಓದ್ತಾ ಇದ್ರು, ಸ್ಟಡಿ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಕಿಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಹೋಗಿಲ್ಲ.
ಬಟ್ ಅಲ್ಲ ಸ್ಟಡಿ ಮಾಡ್ತಿದ್ರು. ಇಸ್ ಇಟ್ ನಾಟ್ ಯುವರ್ ಡ್ಯೂಟಿ ಟು ಡಿನೈ ದಟ್ ದೇ ಆರ್ ಅಟ್ ಲೀಸ್ಟ್ ಅಸೆಟ್ ದಟ್ ದೇ ಆರ್ ನಾಟ್ ಡಿಪೆಂಡೆಂಟ್ ಅಂತ ಹೇಳಿ ನೀವು ಸಜೆಷನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಹೌದು.
Do this matter is listed for admission by consent of the parties, that is taken up for final disposal. These two appeals are filed under section 173 of any act challenging the quantum. ಅಲ್ಲ ನೀವು ಯಾಕೆ ಅಪೀಲ್ ಮಾಡಿದ್ರಿ? 30% ಡಿಡಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಚಾರ್ಟಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಇಲ್ಲ. ಅದು 9,000 ತೊಗೊಂಡ್ರೆ ಜಾಸ್ತಿ ಆಯ್ತು ಅಂತ ಒಂದು. ಮತ್ತೆ ಕನ್ವೆನ್ಸ್ ಲೆಟ್ ಅಲ್ಲಿ 2,75,000 ಕೊಟ್ಟಿದ್ದು ಅಂತ.
75 ಕಡಿಮೆ ಅದ್ರೊಳಗೆ ಒಂದು 60-55 ಕಡಿಮೆ ಆಗುತ್ತೆ. ಬಟ್
ಪ್ರಣಯ ಸೇತಿ ಕೇಸ್ ಬಂದ್ಮೇಲೆ ಸ್ವಾಮಿ ಬೇರೆ
ಇನ್ಕ್ರೀಸ್ ಆಗುತ್ತಲ್ವಾ?
ಅದೇ ಪ್ರಣಯ ಸೇತಿ ಬಂದ್ಮೇಲೆ ಎಲ್ಲಾ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಡಿಸ್ಪ್ಯೂಟ್ ಇತ್ತು. ರೇಷ್ಮಾ ಕುಮಾರಿ ಅದ್ ಹಿಡಿದು ಕೂಲಿ ಲೇಬರ್ಸ್ ಅದಕ್ಕೆ ತಗೋತಾ ಇರಲಿಲ್ಲ ಆ ಟೈಮಲ್ಲಿ.
These notices are filed except for the MU Act, challenging the judgment and award passed by MACT Udupi sitting at Kundapur in emission number 473 of 2016 dated 7th November 2017, challenging the quantum portion. There is no serious dispute regarding the factual aspect. Admittedly, on 19/12/2015 at 7 p.m., deceased Keshav Pujari was standing on Mud Road near NH 66 in front of Malingeshwara temple for crossing the road, and at that time, Mahindra Bolero camper bearing registration number K820C8165 came from Kundapur and proceeding towards Udupi, dashed against the deceased, and due to the said impact, the deceased suffered fatal injuries and he was immediately shifted to the hospital wherein he succumbed because of the accidental injuries. The claimants are the widow, children, and mother of the deceased. They filed a claim petition under section 166 of any act claiming compensation of rupees 20,70,000 on account of untimely death of deceased Keshav Pujari. Next, the claim petition was contested and the tribunal, after assessing the oral as well as documentary evidence, has awarded rupees a total compensation of rupees 12,11,000 under with interest at the rate of 6% per annum to the claimants under following heads. Being agreed by this award, the claimant has filed MFA 981 of 2018 seeking enhancement, while insurance company has filed MFA 2290 of 2018 seeking for reduction of the compensation. Third, the arguments advanced by the learned counsel for appellant, claimant, and the learned counsel for respondent insurer. Here is the records. Next, the learned counsel for appellant claimant would contend that though the tribunal has considered all the aspects in accordance with law, the tribunal has failed to add future prospect to the extent of 25% and further has taken the dependency at 1/3 in place of 1/4, and hence he would seek for enhancement. Per contra, the learned counsel for respondent insurer would contend that the tribunal has awarded a sum of rupees 2,75,000 under the head of under conventional heads, which is on higher side, and hence he would further contend that maximum claimants would be entitled for 2,30,000 under the conventional heads, and as such he would seek for the reduction of the compensation. Having heard the arguments and perusing the reports, it is evident that the accident occurred on 19/12/2015. There is no dispute regarding the age of the deceased as 48 years. The tribunal has considered the notional income at 9,000 as per Lok Adalat chart in the absence of any material evidence. Hence, the said finding also does not call for any interference. However, the tribunal has not added future prospects of 30% or 25%, considering the avocation of the deceased. If the income is taken at 9,000 and future prospects at 25% is added, the loss of income, the monthly income would work out at 11,250. Next one. The tribunal has tribunal on the ground that the claimants 3 and 4 being the claimants 2 and 3 being the major sons are not dependents, and considering 3 dependents has deducted 1/3. But however, there is no material evidence placed to show that claimants 2 and 3 are attending the school or earning members. Even during the cross-examination of PW1, no suggestion is made to PW1 suggesting that appellant claimants 2 and 3 are self-reliant. Under these circumstances, tribunal has erred in taking the in deducting 1/3 towards personal expenses, and considering the number of dependents, it ought to have deducted 1/4 towards personal expenses. Considering the age of the deceased, multiplier 13 is applicable. Hence, the loss of income or future loss of dependency would work out 11,250 into 12 into 13 into 3/4. 13 lakhs. 13 lakhs 16,250. Next. Further, the claimants appellants are the widow, children, and mother of the deceased. Hence, each of them are entitled for 40,000, and hence the claimant should be entitled for rupees 14 to 5, 2 lakhs under the head of loss of consortium. Further, they are entitled for rupees 15,000 under the head of loss of estate and rupees 15,000 under head of funeral expenses. Hence, claimant would be entitled for total compensation under various heads as under loss of dependency 13 lakhs 16,250, loss of consortium 2 lakhs, funeral loss of estate 15,000, funeral expenses 15,000, total 15 lakhs 46,250, as against 12 lakhs 11,000 awarded by the tribunal. Under these circumstances, the appeal filed by the claimants needs to be allowed, and the appeal filed by the insurance company does not survive for consideration. Accordingly, I proceed to pass the following order. MFA 981 of 2018 is allowed in part. The claimants are held entitled for total compensation of 15 lakh 46,250 as against 12 lakhs 11,000 awarded by the tribunal. The enhanced compensation of rupees so and so shall carry interest at the rate of 6% per annum. The insurance company is directed to deposit the entire enhanced compensation with accrued interest thereon within 6 weeks from today. The disbursement, apportionment, disbursement, and deposit shall be as per the terms of the award passed by the tribunal. MFA 2290 stands this is.
Amount in deposit may be transferred.
Amount in deposit shall be transmitted to the tribunal.
And for the respondent,
As per request, call for TCS.
TCR. B.
Hearing for the appellant in this case.
Nagaraj Hegde. Huh?
First time, my lord.
You are for
Appellant, my lord.
appeal?
ಅದೇ ಅವರು ಒಂದು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ ಸರ್.
ಓ ನಿಮ್ದು ಒಂದು ಅಪೀಲ್ ಇದೆನಾ? TCS ಬೇಕೇನ್ರಿ?
ಇದು ಆಂಪಿಟೇಷನ್ ಕೇಸ್.
TCS ಬಂದಿದೆ. ಎದಕ್ ಟೈಮ್ ಬೇಕ್ರಿ ವಕೀಲ್ರಿ?
ಹೋಗಿದ್ದಾರೆ ಇವರನ್ನ.
As per request of the learned counsel for appellant claimant, use the matter after 2 weeks.
KC.
So.
Number 22, and Venkatesh.
ವೆಂಕಟೇಶ್ ಅವ್ರ ಕಲಿಗೆ ಬರ್ತಿದ್ರಲ್ಲ.
My lord, I am appearing, my lord.
ಹಾ. In case of, it is case of death. ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ವಕೀಲ ಕ್ವಾಂಟಮ್ ಓನ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಕೇಳೋಣ.
22, my lord.
22 ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿದೆ, ಕ್ವಾಂಟಮ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿದೆ ಅಂತ ಕೇಳಿದ್ರೆ.
ಇಲ್ಲ, ನೆಗ್ಲಿಜೆನ್ಸ್ ಕ್ವಾಂಟಮ್, my lord. ಇಂಟ್ರೆಸ್ಟ್ 9% ಕೊಟ್ಟಿದ್ದಾರೆ, ನೆಗ್ಲಿಜೆನ್ಸ್ ಹಾಕಿರೋದು ಸರಿ ಇಲ್ಲ, 70-30 ಮಾಡಿದ್ದಾರೆ. That is only question before this court, my lord.
70 ನಿಮ್ಮ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ, ಅದು ತಪ್ಪು ಆಗಿದೆ ಅಂತ ಸರಿ ಮಾಡ್ಬೇಕು ಅಂತ ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಮೈ ಲಾರ್ಡ್. ಇಂಟ್ರೆಸ್ಟ್ 9% ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಓಕೆ.
ಆ 2 ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
ಹೇಳಿ ನಿಮ್ದು 2 ಗ್ರೌಂಡ್ ಅಂದ್ರೆ ಹೇಳ್ಬಿಡಿ ಮೊದಲು, ಆಮೇಲೆ ಅವ್ನ ಕೇಳ್ತೀನಿ.
14-11-16 ಅಲ್ಲಿ 4 ಗಂಟೆಯಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಯ್ತು.
14-11-16
ಹೌದು ಸ್ವಾಮಿ.
ಎಸ್.
ಇವರು ಕೂಲಿ ಮಾಡಿ 15,000 ಸಂಪಾದಿಸ್ತಾರೆ, ಪೆಡೆಸ್ಟ್ರೈನ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಓಕೆ.
MACT ನೋಷನಲ್ ಆಗಿ 9,000 rupees ತಗೋತದೆ. 40% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಆಡ್ ಮಾಡುತ್ತೆ. ಪೇಜ್ ನಂಬರ್ 7, ಮೈ ಲಾರ್ಡ್.
ಅಲ್ಲ, what is the age?
His age is 20 years, my lord. Actually 19, but 20 years ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ.
ಏನ್ 19-20 ಏನ್ ಬಾಳ ಡಿಫರೆನ್ಸ್ ಆಗೋಲ್ಲಲ್ಲ?
ಇಲ್ಲ, ಏನ್ ಡಿಫರೆನ್ಸ್ ಏನಿಲ್ಲ, ಮೈ ಲಾರ್ಡ್.
ಸೊ 9,500 ತಗೋಬೇಕಾಗಿತ್ತು, 9,000 ತಗೊಂಡಿದ್ದಾರೆ
ಅಷ್ಟೇ. ಅದು ಕ್ಲೈಮೆಂಟ್ಸ್ ಇದು. ನಂದು
ಕರೆಕ್ಟ್. ನಿಮ್ನು ಕೇಳ್ಬೇಕಲ್ಲ ಸರ್.
40%
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ, ಕರೆಕ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮಲ್ಟಿಪ್ಲೈರ್ 18 ಬರುತ್ತೆ.
ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಸರಿ.
ಇಂಟ್ರೆಸ್ಟ್ ಪೋರ್ಷನ್ ಅಂದ್ರೆ ನೆಗ್ಲಿಜೆನ್ಸ್, ಈ ವಾಸ್ ಎ ಪೆಡೆಸ್ಟ್ರೈನ್, ಮೈ ಲಾರ್ಡ್. ವಿತೌಟ್ ಎವಿಡೆನ್ಸ್ ಸ್ವಲ್ಪ ತಾವು ಗಮನಿಸಿದ್ರೆ ಕೋರ್ಟ್ 50-60% ಅನ್ನ ಹಾಕ್ತೀರಾ.
50 ಪೆಡೆಸ್ಟ್ರಿಯನ್ಗೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ವೆಹಿಕಲ್ಸ್ ಹಿಂದೆ ಮುಂದೆ ನೋಡಿದಿರ ಏಕಾಏಕಿ ರೋಡ್ ಬಂದ್ಬಿಟ್ರೆ ಎನಿಬಡಿ ಫಾರ್ ದಟ್ ಮ್ಯಾಟರ್ ಕೆನಾಟ್ ಕಂಟ್ರೋಲ್ ಅಟ್ ದಿ ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್. FIR ನೋಡಿ, ಮೈ ಲಾರ್ಡ್. ದಟ್ ವಿಲ್ ಕ್ಲಿಯರ್ ದಿ ಡೌಟ್ ಆಫ್ ದಿ ಕೋರ್ಟ್, ಮೈ ಲಾರ್ಡ್. ಅವರು ವಿಟ್ನೆಸ್ ಅನ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ದಯವಿಟ್ಟು ಅದನ್ನು ಗಮನಿಸಬೇಕು ಕೋರ್ಟ್, ಏನ್ ಹೇಳ್ತಾರೆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಅಂತ. ಪಂಚನಾಮೆ ಕೂಡ ಎಕ್ಸಿಬಿಟ್ P5 ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಲುಕ್ಡ್ ಇಂಟು, ಮೈ ಲಾರ್ಡ್, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಪೊಲೀಸ್ ಅಥಾರಿಟೀಸ್.
He was crossing the road.
He was crossing the house.
Okay.
Sorry, sir.
It was a main road.
ಹೌದು ಸ್ವಾಮಿ, ಮೇನ್ ರೋಡ್ ಸ್ವಾಮಿ.
Correct. There was a bus stop.
ಹೌದು.
And there was a bus stop. What precaution the drivers are required to take?
ಇಲ್ಲ, ಬಸ್ ಸ್ಟಾಪ್, ಮೈ ಲಾರ್ಡ್. FIR ನೋಡಿ, ಸ್ಥಳ ಪಂಚನಾಮೆ ನೋಡಿದ್ರೆ This court will clear the doubts of
ಅವನು
my lord.
60 ಅಡಿ he was thrown away at a distance of 60 feet when he was hit by a car.
ಹೌದು ಇದೆ ನಿಜ.
When he was required to thrown away at a distance of 60 feet, the speed of the vehicle can be imagined.
There is no my lord, highways ನಲ್ಲಿ ಇದು ಇಲ್ಲದೆ ಇರುವಾಗ ಇವ್ರು ಕ್ರಾಸ್ ಮಾಡಬಾರ್ದು, ಅಥವಾ ಅಕಸ್ಮಾತ್ ಕ್ರಾಸ್ ಮಾಡೋ ಪರಿಸ್ಥಿತಿ ಬಂದಿದ್ರೆ ಎರಡೂ ಕಡೆ ವೆಹಿಕಲ್ಸ್ ನೋಡಿ ಕ್ರಾಸ್ ಮಾಡ್ಬೇಕು. ಏಕಾಏಕಿ ಇವರು ಮೈಲಾಡ್ FIR ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ನಾಗಪ್ಪ ಫೈಲ್ ಮಾಡಿರೋದು.
FIR ನೋಡಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. FIR ಓನ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ನೋಡಿನ ನಾನು ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ. at a distance of 60 feet.
ಕಾರ್ ಹೊಡೆದ ಡಿಸ್ಟೆನ್ಸ್ ಗೆ 60 ಅಡಿ ತೊಳ್ಕೊಂಡು ಹೋಗ್ಲಿಲ್ಲ ಮೈಲಾಡ್.
ಕಾರ್ ಹೊಡೆದಿದ್ರು, ಕಾರ್ನಿಂದ 60 ಅಡಿ ಪುಟದ್ ಬಿದ್ದಿದ್ದಾನ ಅವನು. That was the case.
ಹೌದು.
So when there was an impact, he was thrown at a distance of 60 feet from the place of impact.
ಹೌದು.
That will assume the importance alva.
ಕಾರ್ ಸ್ಪೀಡ್ ಆಗಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ, ಕಾರ್ ಸ್ಪೀಡ್ ಅಲ್ಲೇ ಇದೆ, ಬಟ್ ಇಟ್ ಈಸ್ ಹೈವೇ.
When there was a bus stop, it was a highway, that is a different aspect. But when there was a bus stop, what is the normal precautions to be taken by the driver of the moving vehicle? ಯಾಕಂದ್ರೆ ಬಸ್ ಸ್ಟಾಪ್ ಇತ್ತಂದ್ರೆ ನಿಯರ್ ಬೈ ಸಿಗ್ನಲ್ಸ್ ಬಂದಿರ್ತದ.
ಹೈವೇದಲ್ಲಿ ಸಾಮಾನ್ಯವಾಗಿ ಸಿಗ್ನಲ್
ಹಾಕಿ ಹಾಕ್ತಾರೆ. ಬಸ್ ಸ್ಟಾಪ್ ಇದೆ, ಸ್ಕೂಲ್ ಇದೆ, ಎಲ್ಲ ಹಾಕಿ ಹಾಕ್ತಾರೆ. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ
ಸ್ಕೆಚ್ ನೋಡಿ ಮೈಲಾಡ್,
ಸ್ಕೆಚ್ ನೋಡಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
ಸ್ಕೆಚ್ ಅಪಘಾತ ನಡೆದ ಸ್ಥಳ ಇದು, ಡಬಲ್ ರೋಡ್ ಹೈವೇ ಇದು.
Highway, he was almost about completely crossed the road.
ಸ್ವಲ್ಪ
ರೋಡ್ ಡಿವೈಡರ್ ಹಾರ್ಡ್ಲಿ 3 to 4 feet ಇದ್ದವನು.
ಹೌದು.
ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಹೊಡೆದಿದ್ದೀರಾ ನೀವು? ಲೆಫ್ಟ್ ಸೈಡ್ ಸಾಕಷ್ಟು ರೋಡ್ ಇದೆ.
ಹೊಡೆದಿರುವುದು ನಿಜ ಮೈಲಾಡ್, ಐ ಆಮ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಟ್, ಬಟ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಫ್ ದಿ ಕ್ಲೈಮೇಟ್ ಇಸ್ ಆಲ್ಸೋ ಟು ಬಿ ಲುಕ್ಡ್ ಇಂಟು ಬೈ ದಿಸ್ ಕೋರ್ಟ್.
ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿ 30% ತಗೊಂಡಿದಾರಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು.
ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
ಮತ್ತೆ that is the only ground.
ಹೌದು ಸ್ವಾಮಿ. ಇಂಟ್ರೆಸ್ಟ್ 9% ಇದೆ. ಅದೊಂದು
ಇಂಟ್ರೆಸ್ಟ್ ಇಸ್ ಓಕೆ, ಇಂಟ್ರೆಸ್ಟ್ ಇಸ್ ಓಕೆ. But income was taken on for 9,500.
9,500 ತಗೋಬೇಕು ಮೈಲಾಡ್.
Sorry.
ಅಷ್ಟೇ.
So now you are harping on interest portion as well as contributor negligence of deceased.
ಹೌದು ಸ್ವಾಮಿ, ಅದನ್ನ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತಾ ಇದೀನಿ ಸ್ವಾಮಿ.
ಸರಿ, ತಂದಿದ್ರೆ ಆಯ್ತು. Yes.
Negligence is part of no negligence is part of the almost as artifact of normal translate. Even other very discussion of this one is very clear. Para 10 of the it cannot be disputed that the accident not have been avoided if the power driver had applied the back brake. It could have been avoided. There is no evidence used by the respondent to show that the power driver had tried to level best to avoid the accident.
It was highway. Highways are meant for speed. Onnedu. ಎರಡನೇದು, is there any pedestrian crossing? My simple question is crossing stripped zebra marking ಏನ್ರಿ ಇತ್ತ nearby? ಇಲ್ಲ. You are not crossing a stripped dedicated line.
Zebra crossing is come only in the
city ಇರ್ಲಿ. Is it a highway or state highway, national highway? When national highway ಇತ್ತಂದ್ರೆ national highway rules are governed. It is meant for speed only.
That should have been examined. They are not examined.
At the same time, you also required to prove Allah. You have taken all precautions. You stood.
That's not my position. That my no evidence is examined.
See, ಅದಕ್ಕೆ ಹೇಳೋದು ನಾನು. You are supposed to lead an evidence to show that you have stopped, checked the vehicles and then tried to cross the road. You have not examined any eyewitnesses because the persons who have allowed you to go to your work were standing on the bus stop only. They have asked you to proceed to your work only, and you try to cross the road when the accident has occurred. What prevented you to examine those witnesses?
Not any of the eyewitness, but the deceased wife has reported.
She is not an eyewitness. That is-
But anyway, there is no evidence to prove that the negligence is on the part of the deceased.
See, it is a highway.
Right? You don't have-
See, the factual aspect that it is a national highway.
Actually, what happens, there is a bus stop. Generally, people in the bus stop, they will track them to catch the bus and then they get on.
See, you can get down on the left side. You are not supposed to cross the road. Crossing is different. Getting down at the bus stop is different.
Bus stop is there is buses will stop, people will have a movement. At that time, it is the duty of the vehicles which are moving that place. Very conscious.
So one thing again we'll have to consider, he was not on left side. He was near to road divider because there was a bus stop.
Report crossing that road, man, that is not disputed. That is not disputed. 30% is not higher. There is even the
No,
government
sir.
statement, madam. Our honorable court very clear. It is not here. Examine the eyewitness. The negligence cannot be shown. Very report, madam. There are 9. Very clear by our reason. Though the insurance company has alleged that the accident occurred due to the contributory negligence on the part of the claimant, on evidence has no evidence as laid out by the insurance company in this regard. It is pertinent to note that no eyewitness has been examined to testify with regard to the manner of the accident as alleged by the insurance company. The tribunal taking into consideration the material made available has rightly come to the conclusion that the accident occurred due to the rash and negligent driving of the part of the driver of the offending vehicle.
Sir, this is not applicable. How it is applicable? Because it is not a highway. It is a Kolar Srinivaspur road, which is not a highway. So no, sir, this is Kolar Srinivaspur main road. It is not a highway. Kolar Srinivaspur road is not a national highway, and the National Highway accidents are covered under National Highways Act. There are specifications under National Highways Act.
Nearby village, madam.
Whatever it will be, sir. Hey, ಯಾವನೋ ಎಲ್ಲಿಂದ ಬರೋನ್ಗೆ ನಿಯರ್ ಬೈ ವಿಲೇಜ್ ಎಲ್ಲಿದೆ ಅದು ಗೊತ್ತಿರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. Sir, how the national highways are being treated in the villages, do you know? ಅಲ್ಲಲ್ಲ ನಾನು ಅದನ್ನ ಹೇಳ್ತಾ ಇಲ್ಲ. Though they create a divider to cross through, divider ಹೊಡಿತಾರೆ. ಟ್ರ್ಯಾಕ್ಟರ್ ಇಳಿಸ್ಲಿಕ್ಕೆ ಡಿವೈಡರ್ ಹೊಡಿತಾರೆ, ಮೋಟರ್ ವೆಹಿಕಲ್ ಹೋಗ್ಲಿಕ್ಕೆ ಡಿವೈಡರ್ ಹೊಡಿತಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಅಟಿಟ್ಯೂಡ್ ಆಫ್ ದಿ ವಿಲೇಜರ್ಸ್. ಅಷ್ಟು ಸುತ್ತ ಹಾಕೊಂಡು ಹೋದ್ ಕಷ್ಟ ಆಗತ್ತೆ ಅವ್ರಿಗೆ, ಅದಕ್ಕೆ ಅದನ್ನ ಹೊಡೆದ ಡ್ಯಾಮೇಜ್ ಮಾಡಿ ಅಲ್ಲಿಂದ ವೆಹಿಕಲ್ ತಗೊಂಡು ಹೋಗ್ತಾರೆ. No, highways are meant for speed, sir.
30% not correct. There is no evidence as per the only the examined eyewitness.
Sir, at the same time, when you are crossing highway, what evidence you are led first? You are not led any evidence. So if you lead evidence, then the rebuttal is required to be proved by the other side because it is a highway.
Only because highway is four-wheeler with the car was driving, you should be more cautious, madam.
No, sir, highways, highway act, highways are meant for speed only.
You could have avoided the accident.
See, best person would be the deceased to avoid the accident. Had he taken minimum precautions to see, highways, ದೂರದಿಂದ ಬರೋ, you cannot imagine the speed of the vehicle.
You should be very careful. Driver of
The crosser should be more cautious, not the driver.
who could have avoided the accident, madam. This car driver could have avoided that. Even the discussion is also very clear. 30% no reason was given. 30%.
No, sir.
At least even for that also covered judgment, even in the there is no zebra, it's 25%.
ಕೊಡಿ ಅದು ಕೊಡಿ.
No, not 20% may be taken. It can take 20%, 25%. Tribunal taking into consideration the material record by evidence and record and the case to be considered that claimant had substantially contributed the accident and negligence in the ratio of 40%. If the claimant had contributed to the extent of 40% for the accident, so far as the injuries are suffered by the claimant, the tribunal taking into consideration the prolonged hospitalization for the duration of more than 1 year and relying on the evidence PW2, the doctor came to the conclusion that the claimant ended for complex health. The issue of stated below, the appeal is allowed in part. The judgment and the award of the tribunal is modified to the rating of the appropriate negligence, modified to the extent that the contributing negligence of the appellant is paid to be 25%.
What is the reasoning? So, ತಗೊಳ್ಬೇಕಾದ್ರೆ 25%. ಅಲ್ಲಲ್ಲ, what is the discussion ಆದ್ರೆ ಅಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ 40% ಇದೆ 25% ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ what is the grounds? There his evidence was there. He claimant himself was the injured there. ಕೊಡಿ
Regarding the contributing negligence, there is no discussion. Simply 30% of it. That is also not correct. 30%, that is also higher rate. This is no negligence, my lord. Even I will testify to it. That's 4 and 10.
This is not the case of crossing the road. It is not the case of crossing the road. It was the this is a case wherein he was he claims to be standing by on a mud road to proceed to Udupi, but he was not standing on a mud road, he was standing on a road. So therefore he has contributed until ill observation is there. Zebra crossing bitbidi, this is not again highway na cross road. It is not a case of crossing. It is standing on a road.
This one suggestion that zebra crossing should be there. There is no zebra crossing village.
Sir, highways are made. You are ignoring Highways Act itself. See, villages doesn't make much difference, sir. Villages our ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ it cannot be accepted. Highways are meant for speed and they damage the highways also only in order to accommodate them.
30% is too higher. Even the discussion is also very clearly that the car is driving very fast. You could have avoided the accident. You are not afraid any mind and that is the discussion. 30% as direct element. portion 30% is not cut. That's also not no reason for given. We contributed 30%. But also it is not there is no discussion on this part. They have not made any positive evidence also. The as per section 106 of the evidence act, they have to prove it, man. There is an existence on the part of.
Sir, when you are crossing a, sir, try to understand. Highways Act, nodi, you are arguing a general. You are ignoring that you are crossing in a highway. Highways, see, Highways Act prevails for other acts. You cannot argue in this way, sir. Social justice does not mean that a poor vehicle driver, he is required to be prosecuted unnecessarily. ಮತ್ತೆ ಅದನ್ನು ನೋಡ್ಬೇಕಾಗತ್ತಲ್ಲ. ನೀವು ನಿಮ್ಮ ಹರಿಯ ಒಳಗ ಎಲ್ಲೋ ಕ್ರಾಸ್ ಮಾಡಕ್ ಹೋಗಿ ಎಲ್ಲೇ ಮಾಡ್ಕೊಂಡ್ರೆ who has to suffer? The driver will also have to suffer. He has to face a criminal trial. ಅದನ್ನು ನೋಡ್ಬೇಕಲ್ಲ. ನೀವು ಒಂದನ್ನು ನೆಗ್ಲಿಜೆನ್ಸ್ ಮಾಡಿದ್ರಿಂದ ಒಬ್ರು ಮಾಡಿದ್ರಿಂದ ಎಷ್ಟು ತೊಂದರೆ ಆಗುತ್ತೆ. ಸಿಸ್ಟರ್ಸ್ ಯಾಕೆ ಇದು ಪ್ರೊವಿಷನ್ ಕೆಳಕ್ ಕೊಡ್ತಾರೆ? ಸಿಸ್ಟರ್ಸ್ ಗೆ ಯಾವ ಪ್ರೊವಿಷನ್ ಕೆಳಕ್ ಕೊಡ್ತಾರೆ? ನಂಗೆ ನೋ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ಬರಲ್ಲ ಸರ್. ಸಿಸ್ಟರ್ಸ್ ಬರಲ್ಲ. Only Magma and Satvinder Singh, filial concentration, spousal concentration, parental, ಮೂರೇ ಬರೋದು ಹೆಡ್ಡು. Sisters doesn't fall under the consortium. MFA number 2499 of 2019. This is brother, major brother. Consortium is low on the. Sir, I cannot go by the decision of this court when there is a decision of the apex court. Apex court not. Sir, apex court ಅವರು ಯಾವ್ಯಾವ ಇದು ಹೆಡ್ ಕೆಳಗ ಕನ್ಸೋರ್ಟಿಯಂ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಮ್ಯಾಗ್ಮಾ ಅಂಡ್ ಸತ್ವಿಂದರ್. ಒಂದನೇದು ಫಿಲಿಯಲ್ ಅಪ್ಲೈಯಿಂಗ್ ಟು ದಿ ಚಿಲ್ಡ್ರನ್, ಸ್ಪೌಸಿಯಲ್ ಗಂಡ ಹೆಂಡತಿ, ಪೇರೆಂಟಲ್. ಸಿಸ್ಟರ್ಸ್ ಆರ್ ಬ್ರದರ್ಸ್ ಡಸ್ ನಾಟ್ ಫಾಲ್ ಇನ್ ಎನಿ ಆಫ್ ದಿ ಕ್ಯಾಟಗರೀಸ್. They may be legal heirs. I'm not depending on it, but see, she can be at the most, she can become a dependent. See, dependence is different, consortium is different. No, sir, no, consortium ke baralla. Consortium, you are entitled 40,000 towards the mother. ಏನದೆ mother ಕೊಡೋಕೆ ಬರುತ್ತೆ, sister ಗೆ ಬರ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಪ್ರಯೋಜನ ಇಲ್ಲ. ಪ್ರೊವಿಷನ್ ಇಲ್ಲದೆ ಇದ್ದಾಗ ಕೊಡಕ್ ನಮಗ್ ಕಷ್ಟ ಆಗುತ್ತೆ ಸರ್. ಸರ್, we are bound by the dictum of the apex court, and apex court defined under which heads the consortium is to be granted. ಯಾರ್ಯಾರು ಎಲಿಜಿಬಲ್ ಅಂತ ಹೇಳಿ ಡಿಸಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಹೇಳಿದ್ದಾರೆ ಅವರು. That is binding on this court. Love and affection and consortium, whatever it may be, sir.
Last submission, my lord. Last submission, my lord. Cross examination of PW1 ತಾಯಿ ಹೇಳ್ತಾರೆ 5,000 ನನ್ನ ಮಗ ಸಂಪಾದಿಸ್ತಾ ಇದ್ದು 15,000 ಸಂಪಾದಿಸ್ತಾ ಇಲ್ಲ ಅಂತ. I heard my brother arguments unnecessarily. PW1 cross examination ನೋಡಿ ಮೇಲೆ ಸೆಕೆಂಡ್ ಪ್ಯಾರ. ತಾಯಿ ಅವರೊಬ್ಬರನ್ನೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದು, ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡಿ ಸ್ವಾಮಿ. ಪ್ಯಾರ ನಂಬರ್ 2 ನಲ್ಲಿ
ಎಸ್ 5,000 ಗಳಿಸ್ತಿದ್ದ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ನಾವು ಅದಷ್ಟೇ ಸ್ವಾಮಿ ನಾನು ಈ ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ತರುವುದು.
ನಿಮ್ದು ಅಡ್ಮಿಷನ್ ಇದೆಯಲ್ಲ ಸರ್, ಅಡ್ಮಿಟ್ ಸ್ಟ್ರೇ ಅಲ್ಲ ರೀ, ನಿಮಗೆ ಬಂತಂದ್ರೆ ಅದು ಸ್ಟ್ರೇ ಆಗತ್ತ ಹೇಗೆ ಸರ್? That is an admission given by your party that suggests, wherein it is suggested as per your claim he was not earning rupees 15,000 and he is only earning rupees 5,000. How don't you tell? And you say that it should be in ignored. Agree. though this appeal is.
I will be permitted to leave the court hall, my lord.
Yes, sir, yes, please.
I have a great, my lord.
Yes, yes, sir, yes, sir. By the consent of the parties, the matter is taken up for final disposal. These two appeals are filed by the insurance company as well as claimant, challenging the ಇದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ 18/21 ನಮ್ ಕೋರ್ಟ್ ಪೋಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಬಂದಿದೆ ಏನ್ರಿ? ಹಾ, ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ. ಮತ್ತಿಲ್ಲ ಅಂದ್ರೆ no, I have not power, sir. My roster is from 17 to 19. If 21 matter cross objection post ಮಾಡ್ಬೇಕಂತಂದ್ರೆ ಒಂದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ತಗೋಬೇಕಾಗತ್ತೆ ಚೀಫ್ ಅವ್ರ ಕಡೆಯಿಂದ. ಹಾಗೆ ಇಲ್ಲ 18/21 ಇದೆ cross objections. That is also wrong, sir. Allah, it should be heard by this court only, which hears the MFA, original MFA, but there should be a specific order from the CJ. ಅದನ್ನ ತಗೊಂಡಿಲ್ಲ ಇವರು, ಡೈರೆಕ್ಟ್ಲಿ ಕನೆಕ್ಟಿಂಗ್ ಆರ್ಡರ್ ಆಯ್ತು. ಆ ಕನೆಕ್ಟಿಂಗ್ ಆರ್ಡರ್ ಆಗೈತಿ, ದಟ್ ಮೇ ನಾಟ್ ಬಿ ಪ್ರಾಪರ್, ಸರ್. ಹಂಗೆ ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಿ. That is, I am not the person who decides the roster. Allah, roster decide ಮಾಡ್ತಾರೆ, ಅವ್ರು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. I can direct the register to obtain necessary orders. ಅದು heard ಮಾಡಿರ್ತೀನಿ, ಬಟ್ ಒಂದು ಫಾರ್ಮಲ್ ಆರ್ಡರ್ ತಗೊಂಡು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಳಗೆ will dispose of. So during the course of hearing, it is noticed that the MFA CROB 18/21 is posted before this court as per order dated 15/7/22. ಎಲ್ಲಿದ್ದಾರೆ ಅದು? As per order dated 8/2/21. However, this court doesn't have any roster pertaining to 21, and roster is restricted from 2017 to 19. Under these circumstances, the registry is directed to place the matter before Honorable ACJ, Acting Chief Justice, for to obtain necessary orders regarding MFA CROB number 18/21 being clubbed with MFA 4814 of 2018. ಅದು ಮುಂದೆ ಒಂದೇ ರೋಸ್ಟರ್ ಇತ್ತು. ಎಂಟೈರ್ ರೋಸ್ಟರ್ ವಾಸ್ ವಿತ್ ಓನ್ಲಿ ಒನ್ ಕೋರ್ಟ್. ಅದಕ್ಕೆ ಅವ್ರು ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಬಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ರೋಸ್ಟರ್ ಸ್ಪ್ಲಿಟ್ ಆಯ್ತು. ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಆರ್ಡರ್ ಬೇಕಾಗಿತ್ತು, ತಗೊಂಡಿಲ್ಲ. ಬಟ್ ದಟ್ ಐ ಹ್ಯಾವ್ ಪಾಸ್ಡ್ ಆರ್ಡರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ಟಿತ್ತು. ಅದಕ್ಕೆ ಇರ್ತದೆ, ಬಟ್ ಒಂದು ಫಾರ್ಮಲ್ ನಾಳೆ ಟೆಕ್ನಿಕಲ್ ಡಿಫೆಕ್ಟ್ ಆಗ್ಬಾರ್ದು. ದಟ್ ಈಸ್ ದಿ ಓನ್ಲಿ ಇಂಟೆನ್ಷನ್. Hence, Last sentence, office is directed.
To obtain necessary orders regarding MFA crop 1821 being clubbed with the MFA 4814 of 8.
18 is the matter next Monday. ಅದನ್ನೆಲ್ಲ ತೆಗೆದ್ಬಿಡಿ. ಇದು posted.
Number 23, and 14.
Three, number 7702 of 2018. Appealing for the respond number 3 and 4. Already filed a memo that was in respect of R1 and R2, ARP only lost. R1 and R2 died, no. And on the same date, my learned friend has filed on 6/4/2022, a memo is filed.
ಎಲ್ಲಿ ಎದರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಇವರು?
ನಮ್ಮ MFA number 7702 of 2018 only is filed along with the death certificate.
ಆಯ್ತು, R1 and R2 ಡೈಡ್ ಅಂತ ಹೇಳಿ ಬರ್ದ್ರು ಅವರು. ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದು.
The R3 and R4 are the only elements of R1 and R2. They will be treated as not the elements of R1 and R2. Respond number 3 and 4 will be treated as elements of R1 and R2.
ಇಲ್ಲಿ ಇನ್ನೊಂದು ಬರುತ್ತೆ ಈಗ ನಾವು R1 and R2 are dead. Guardian of R4.
ಈಗ ಮೇಜರ್ ಇದೆ, ನನ್ನ ಅಪೀಲು ಹಾಕಿ.
ನೀವು ಮೇಜರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಗಿಲ್ಲ, ಮೇಜರ್ ಡಿಸ್ಚಾರ್ಜ್ ಅಂತ ಹೇಳಿನೂ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
ಸಪರೇಟ್ ಅಪೀಲ್ ಇದೆ.
ಅಲ್ಲ ಇರ್ಲಿ, ಕರೆಕ್ಟ್ ಸರ್. 2018 ಇಂದಾಗ ಇದೆ ಎರಡು. 2018 ಮೂರು ಅಪೀಲ್ 2018.
73 of 2022, my learned friend has filed.
73
2022.
73 of 22 ಅದು ಇದ್ರ ಕೂಡ ಬಂದೇ ಇಲ್ಲ. ಅದು ಬರಲ್ಲ, ಅದು ಇಮಿಡಿಯೇಟ್ಲಿ ಅನ್ಲೆಸ್ ಸ್ಪೆಸಿಫಿಕ್ ಆರ್ಡರ್ ಅದು ಬರಲ್ಲ. ಬಟ್ ಇದ್ರೊಳಗೆ ನೀವು ಐದರ್ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಸೀಕ್ ಫಾರ್ ಅ ಡಿಸ್ಚಾರ್ಜ್ ಆಫ್ ದಿ ಮೈನರ್ ಗಾರ್ಡಿಯನ್, seeking permission to contest or wakalat hakbeku. She respond number R4 doesn't have any power in this case because he was minor. She was represented by deceased R1. Now there is no power. Our power hakbeku. New power discharge R4 ge discharge ilda wakalat hakidare.
ಮೇಜರ್ ಇದ್ರು ಅನ್ನೋ ಕಾರಣಕ್ಕೋಸ್ಕರ ನಾನು R3 and R4.
ಅಲ್ಲ ಇದನ್ನ 5/4/22 ಹಾಕಿದೀರಾ, ಬಟ್ ವಿದೌಟ್ ಡಿಸ್ಚಾರ್ಜ್. ಅದು ತಪ್ಪಲ್ಲ. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಸೊ ದಟ್ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಕೊಳ್ಳಂತ ಅಷ್ಟೇ. ಅಂಡ್ ಮೀನ್ ವೈಲ್ ಹೆಂಗಾದ್ರು ಅದು ಇನ್ನೊಂದು ನಿಮ್ದು 73 of 22 is to be clubbed with this. The learned counsel for appellant in MFA 23.2 filed a memo stating that the respondents 3 and 4 are the legal heirs of deceased R1 and R2. They said submission is placed on record as it is also not disputed by the respondents 3 and 4. The learned counsel for respondents 3 and 4 is the learned counsel for appellant is directed to carry out necessary amendment in the cost title. Next, it is also submitted that the crop 73 MFA crop 73 of 22 filed by the claimant is also pending, and it is requested to club MFA crop 73 of 22 along with these matters. However, this court doesn't have any roster pertaining to 2022. Considering the fact that original matters are pending before this court, the registry is directed to obtain necessary orders from the necessary orders and place MFA crop 73 of 22 along with these matters. Release the matter next week. ಅದು comply ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು. 14/9.
Number 24, Pradeep B.
For the appellant in this case. No? So second round of litigation, my lord, earlier the Samba court has remanded the matter. The claim petition has been dismissed. Non-involvement of vehicle. TCR ಬೇಕಾಗಬಹುದು ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
T-shirts ಬಂದಿಲ್ವಾ? ಬಂದಿಲ್ಲ. T-shirts ಬೇಕಂತಲ್ಲ ರೀ. Call for T-shirts. ಏನು ಫೈಲ್ ಮಾಡಿದ್ರಿ? Release when they are disputing the liability itself. Note ಮಾಡ್ಕೊಂಡು the learned counsel for respondent submit that he has filed a memo for release of the amount. Office is directed to verify and put it along with the file. Next.
Number 25, Poojan. Number 26, Kavita Hasti. Number 26, Kavita Hasti.
No representation. All for T-shirts.
Number 27, Poojan. Number 28, Emily. Number 28, Emily.
No representation. All for T-shirts.
The hearing matter, number 29, Keshav Prashad.
Lord, I appear for the respondents in this matter. I pray for 3 days accommodation, my lord. The counsel for the appellant has submitted his arguments and has produced a judgment. I'll give my reply, my lord, by examining the same, my lord. 3 days time may be granted.
Sir, 1 week ಆಯ್ತು. Other citation or rely ಮಾಡಿದಕ್ಕೆ time ತಗೊಂಡಿದ್ದೀರಿ. Again you are seeking adjournment.
Only 3 days, my lord. I'll assess this.
ಅಲ್ಲ 3 days ಇರ್ಲಿ, 1 day ಇರ್ಲಿ. Already there are no new citations. He has already placed it. Copy is served on you.
Copy was given, my lord. For 3 days I was not keeping well. I could not work on it, my lord.
ಏನ್ 4 ದಿನ ರಜಾ ಇತ್ತಲ್ರಿ?
ಹೌದು.
5 ದಿನ ಕಂಟಿನ್ಯೂಸ್ ರಜಾ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ.
One last accommodation.
11 counsel for respondent praise time. This the matter on 8th.
Great.
The hearing matter, number 30, in Krishna Swami. Number 30, in Krishna Swami.
ಅವ್ರು ಇವ್ರು ಬರ್ತಾರಲ್ರಿ, ಲಕ್ಷ್ಮೀ ನರಸಿಂಹ ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಇರೋಗು ಕ್ಲಬ್ ಆಗೈತೇನ್ರಿ? ಟಾಪ್ 5 of 20. ಕುಡಿ ಯಾವತ್ತಾವ್ರಿ? ಅದು ಕಾಮನ್ ರೋಸ್ಟರ್ ಇದ್ದಾಗ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Quite natural. It is noticed that this court does not have any roster pertaining to 2020. However, MFA crop 5 of 20 is posted before this court along with MFA 189 of 2017 Registry is directed to obtain necessary orders in MFA crop of 5 of 20. List after 2 weeks.
Number 31. Which is what, Tushar?
Appearing for the appellant in 1/18 of 2017.
Yes, Vakilra. Now you want to prove his age to be 44 in place of 46 taken by the tribunal.
Additional document.
Why you are not produced it before the tribunal?
We have produced, there was, as per the lower court record.
Why you are not produced and why 41 or 27 yavag use madbeku? If you are unable to produce the document beyond for the reasons beyond your control. Lack of knowledge cannot be considered because he has engaged a counsel. Lack of knowledge cannot be a ground at all. Ignorance of law is not a ground. And you have mentioned in your claim petition as 45 years. Now you want to go beyond against your claim petition. It is not a oversight. Huh? It cannot be treated as an oversight. How medical records so different age mention ಮಾಡಿದ್ಮೇಲೆ ನಿಮ್ಮ ಜವಾಬ್ದಾರಿ ಏನಿತ್ತು ಕಾಂಕ್ರೀಟ್ ಮೆಡಿಕಲ್ ಒಂದು ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಹಾಜರು ಮಾಡಿದ್ರೆ ಕ್ಲೋಸ್ ಆಗಿ ಹೋಗಿತ್ತು ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ ಹಾಜರು ಮಾಡೋದು ಅಪೀಲ್ ಒಳಗೆ ಬಂದ ಇಲ್ಲ ಒಂದು ಏಜ್ ಇಷ್ಟಿತ್ತು ಅಂತ ಹೇಳ್ತೀರಾ ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಎ ರಾಂಗ್ ನೋಷನ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ನಿಮ್ ಕ್ಲೇಮ್ ಪ್ರಕಾರ 45 ನ ತೋರಿಸಿದ್ದಾರೆ.
ಎಕ್ಸಿಬಿಟ್ P6 ಅಲ್ಲಿ 46 ಮೂನ್ ಸರ್ಟಿಫಿಕೇಟ್.
Applied multiplier 13. Should have been 14.
44, 45 doesn't make much difference. ಅದೇ ಹೇಳಿದೆ 44, 45 doesn't make much difference. If he enters 46, lot of difference will be there. In only one document, it is shown as 46. That is exhibit P6. In all other documents and in your claim petition, it is referred as 45.
Of accident December 2014.
Either ನಿಮ್ಮ document ಪ್ರಕಾರ what is the date of accident? July
ಅಲ್ಲ 21/2/2014.
2012-2014.
ಹೌದು ಹೌದು ಸರ್.
ಅದರ ಪ್ರಕಾರ 45 ಬಂದ್ಬಿಡ್ತದಲ್ಲ. 44 ಕಂಪ್ಲೀಟ್ ಆಗಿ 45 ಎಂಟ್ರಿ ಆಗಿದ್ದದು. His date is 14/2/1970.
If he crosses 45, 2015 February he become 44, 46. 40 to 45 years.
ಅದೇನ್ ಬಾಳ ಡಿಫರೆನ್ಸ್ ಆಗುದಿಲ್ಲ ಎಕ್ಸೆಪ್ಟ್ ಎಕ್ಸಿಬಿಟ್ P6 ಬಿಟ್ರೆ ಬೇರೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ವಕೀಲ್ರೆ.
ಹೌದು ಸ್ವಾಮಿ, ಎಕ್ಸಿಬಿಟ್ P6 ಮಾತ್ರ 46
46 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಬಟ್ ಆಲ್ ಅದರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಇನ್ಪೇಷಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಎವ್ರಿಥಿಂಗ್ he has shown to be 45 years only.
45 years.
And again, it is corroborated by the additional document. That is the transfer certificate, original transfer certificate of the government school, wherein his date of birth is shown to be 14/2/2070. So this corroborates the admission documents, and it dislodges the presumption of exhibit P6 ಅಷ್ಟೇ.
Please.
So 45 ತಗೋಬೇಕಾಗತ್ತೆ ಅಷ್ಟೇ.
ಆಗ್ಬೋದು.
That will be
ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದ್ರೆ ಅದರ ಡೇಟ್ ಆಫ್
ಅದರ ಬಗ್ಗೆ ಸೆಟಲ್ ಲಾ ಇದೆ. What is the nature of the injuries?
Fracture of tibia and fibula, fracture of left femur and fracture of left tibia.
Fracture of tibia and fibula of left leg.
Right leg.
Right leg and femur of right leg.
Left milord, left tibia and left femur.
Yeah, you know, one certificate. Right tibia and fibula, left femur and tibia.
Please.
How many days he was inpatient?
66 days total.
Medical bills ಸರಿಯಾಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ as per records.
ಹೌದು.
What is the disability?
Disability para 13 and 14 of the judgment.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
40% ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
40% to the whole body.
ಹೌದು, ಹೋಲ್ ಬಾಡಿ ತಗೊಂಡಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ನನ್ನ ಮೇಜರ್ ಗ್ರೌಂಡ್. 30% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ. ಇಂಜುರಿ ಕೇಸ್ ಮೇಲೆ ದ ಫ್ರಾಕ್ಚರ್ ಇಸ್ ಯುನೈಟೆಡ್ ವೆಲ್ ಅಂತ ಡಾಕ್ಟರ್ ಹೇಳಿ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ PW 2 ಮೇಲೆ.
So you are aggrieved by taking 40% future prospects ಅಷ್ಟೇ.
ಹೌದು, ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೊಂಡ್ರೆ ಜಾಸ್ತಿ ಇದೆ, ತಗೊಳಕ್ ಬರಲ್ಲ ಅಂತ. ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ 2012-2014 ಆದ್ರೆ ನೋಷನಲ್ ಇನ್ಕಮ್ 8,500 ಇದೆ, ಅಲ್ಲಿ 9,100 ತಗೊಂಡವ್ರು ಸರ್.
9,100 ತಗೊಂಡಿದ್ದಾರಾ?
ಹೌದು, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್.
Including future prospects.
ಹೌದು.
What is the notional income ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
7,000 ತಗೊಂಡಿದ್ದಾರೆ.
7,000 ತಗೊಂಡಿದ್ದಾರೆ.
2,100 ಆಡ್ ಮಾಡಿದ್ದಾರೆ.
ಏಜ್ ಇಸ್ 45.
ಅದೇ 46 ಅಂತ ಅಲ್ಲಿ MSCT ಅಲ್ಲಿ ತಗೊಂಡಿರೋದು.
ಅಲ್ಲ, even otherwise it only affects multiplier.
ಹೌದು.
But future prospects 40% ಹೇಗೆ ಬರುತ್ತಾ? ಹೇಗೆ 30%? ಅಲ್ಲ, ನಾನು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ವೆದರ್ he has got any permanent ನನ್ನ ಡಿಸಬಿಲಿಟಿ ಕೇಳ್ತಾ ಇಲ್ಲ ಸರ್, ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಬಗ್ಗೆ ಅಷ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ವಾಟ್ ಈಸ್ ದಿ ಪರ್ಮಿಟೆಡ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್? ಈವನ್ ಲೆಟ್ us accept that he is entitled for future prospects after 40 years. ನನ್ನ ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ಕೇಳ್ತಾ ಇಲ್ಲ, ನಿಮ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಯಾವ್ದು ತಗೊಳ್ಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. 40% ಪರ್ಮಿಸಿಬಲ್?
ಇಲ್ಲ, ಅಲ್ಲಿ 30% ತಗೊಂಡಿದ್ದಾರೆ. Para 16 of the judgment.
30% ಬರುತ್ತೇನ್ರಿ? ಇವರೇ ಬರುತ್ತಾ? Even as per this decision only 25% ಅಲ್ಲ, you are self employed. 25% ಬರ್ಬೇಕಷ್ಟೇ. ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದೀನಿ, ಅದನ್ನ ಹೇಳಕ್ ರೆಡಿನೇ ಇಲ್ಲ ನೀವು.
ಈ ಕೇಸಲ್ಲಿ 25% ಬರಲ್ಲ.
ಮ್ಯಾಕ್ಸಿಮಮ್ 25% ಬರುತ್ತೆ. ಅಂಡ್ ಅವ್ನ ಪ್ರೊಫೆಷನ್ ನೋಡಿದ್ರೆ ವೆದರ್ ಇಟ್ ಇಸ್ ಎ ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ 100%, ದಟ್ ಇಸ್ ಎ ಡಿಫರೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್. ಅವ್ರು ತಗೊಂಡಿದ್ದ 30% is it should be 25% in normal course only, since he is a self-employed. Then any other ground? 6% correct ada. Pain and injury, suffering, loss of future earning ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಅಲ್ರಿ, ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ರಿ ವಕೀಲ್ರೆ?
ಇಲ್ಲ, ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ, 35,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪೇನ್, ಇಂಜುರೀಸ್ ಅಂಡ್ ಸಫರಿಂಗ್ 35 ಕೊಟ್ಟಿದ್ದಾರೆ. 4 ಫ್ರಾಕ್ಚರ್, 2 ಕಾಲಿನ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿಲ್ಲ. ಅಮ್ಯುನಿಟೀಸ್ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿಲ್ಲ.
ಹೌದು.
ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
25,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಮಿಸ್ಲೇನಿಯಸ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 35,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಸ್, ಅದಕ್ಕೆ 35,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದಾರಲ್ಲ, 25,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದಾರಲ್ಲ. ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 25 ಕೊಟ್ಟಿದ್ದಾರೆ. 25 ಏನ್ ಕಡಿಮೆ ಅಲ್ಲ.
ಫಸ್ಟ್ ಫಾರ್ಮೇಷನ್ ಆಗ್ತಾ ಇದೆ, ಈವನ್ ಆಫ್ಟರ್ ದಿ ಲ್ಯಾಪ್ಸ್ ಆಫ್ ಲೋಯರ್ ಎಂಡ್.
ಅಲ್ಲ, ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ನಿಮ್ಗೆ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ದಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಬಿ ಕನ್ಸಿಡರ್ಡ್. ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಕನ್ಸಿಡರ್ ಮಾಡೋಣ ಅಂತ. ನೀವ್ ಎದಕ್ ಬಂದಿದ್ದೀರಿ? ಓನ್ಲಿ
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ. ಇಂಜುರಿ ಕೇಸಲ್ಲಿ ಫ್ರಾಕ್ಚರ್ ಇಸ್ ಯುನೈಟೆಡ್ ವೆಲ್ ಅಂತ ಹೇಳಿ.
ಆಯ್ತಾ, ನಮ್ ಕೋರ್ಟದ ಡಿಸಿಷನ್ ಇದೆಯಲ್ಲ, ಧಾರವಾಡ ಬೆಂಚ್ ಇದೆ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಡಿಸಿಷನ್
100% ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲ 100% ಹೇಳಲ್ಲ ಅಲ್ಲಿ ಅವರು.
ಅದು ಲುಕಿಂಗ್ ಟು ದಿ ನೇಚರ್ ಆಫ್ ಜಾಬ್ ಅವಕೇಶನ್
ಅವ್ರು ಹೇಳಿಲ್ಲ, ಅವ್ರು ಹೇಳಬೇಕಾಗಿತ್ತು ಅದನ್ನ.
ಅದೇ ಅದೇ
ಇದು PW2 ಎವಿಡೆನ್ಸ್ ಕೊಡಿ. ಡಿಸಬಿಲಿಟಿ
ಮೇಲೆ 62% ಲೆಫ್ಟ್ ಲೋಯರ್ ಲಿಂಬ್, 30% ಟು ದಿ ರೈಟ್ ಲೋಯರ್ ಲಿಂಬ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಟೋಟಲ್ 92% ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್ ಲಿಂಬ್ಸ್ಗೆ, ಬೋತ್ ದ ಲಿಂಬ್ಸ್.
ಸೊ 40% ಟು ದಿ ಹೋಲ್ ಬಾಡಿ ತಗೊಂಡಿದ್ದಾರೆ.
40% ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಶಾರ್ಟ್ನಿಂಗ್ ಆಫ್ ದಿ ಲಿಂಬ್ ಇದೆನಾ?
ಶಾರ್ಟ್ನಿಂಗ್ ಆಫ್ ದ ಲಿಂಬ್ ಬಗ್ಗೆ ಏನು ಹೇಳಲ್ಲ ಸ್ವಾಮಿ. PW2 ಫ್ರಾಕ್ಚರ್ ಇಸ್ ಯುನೈಟೆಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಫ್ರಾಕ್ಚರ್ಸ್ ಆರ್
ಫೋರ್ ಸೆಂಟಿಮೀಟರ್ ಶಾರ್ಟ್ನಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಸರ್ ಇಟ್ ಈಸ್ ಮಾಲ್ ಯೂನಿಯನ್ ಅಂತ ಹೇಳಿ ನೀವು ಕ್ರಾಸ್ ಒಳಗೆ ಎಲ್ಲಿ ಶಿಟ್ ಮಾಡಿದಿರಿ? ಮಾಲ್ ಯೂನಿಯನ್ ಬಿಕಾಸ್ ಆಫ್ ಓವರ್ಲ್ಯಾಪಿಂಗ್ ಆಫ್ ದಿ ಬೋನ್ಸ್ ವಿಚ್ ಹಸ್ ರಿಸಲ್ಟೆಡ್ ಇನ್ 4 ಸೆಂಟಿಮೀಟರ್ ಶಾರ್ಟ್ನಿಂಗ್ ಆಫ್ ದಿ ಲೆಗ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಸರ್. ಗಾಯಾಳವನ್ನು ಪರೀಕ್ಷಿಸಿದ್ದು 14/7/2016 ಗಾಯಾಳವನ್ನು ಪರೀಕ್ಷಿಸಿದ್ದು. ಆ ದಿನ ಆತನಿಗಾದ ತೊಂದರೆಗಳ ಪ್ರಮಾಣ ಪತ್ರ ಗಾಯಾಳದ ಎಡಗಾಲಿನ ಮುರಿದ ಮೂಳೆಗಳು ಕೂಡಿಕೊಂಡಿರುತ್ತವೆ.
ಕರೆಕ್ಟ್.
ಫೀಮರ್ ಮುರಿದ ಮೂಳೆ ವಿಳಂಬವಾಗಿ ಕೂಡಿಕೊಂಡಿರುತ್ತವೆ.
ಕರೆಕ್ಟ್. ಬಟ್ ಅರ್ಲಿಯರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಡಿನೈ ಇಲ್ಲ.
ಅದು ಇಂಪ್ಲಾಂಟ್ಸ್ ರಿಮೂವಲ್ ಬಗ್ಗೆ ಹೇಳಿದಾಗ
ಆಗಿದ್ದು ಮೂಳೆಗಳು ಒಂದರ ಮೇಲೊಂದು ಕೂಡಿಕೊಂಡಿರುವುದರಿಂದ 4 ಸೆಂಟಿಮೀಟರ್ ಎಡಗಾಲು ಗಿಡ್ಡವಾಗಿರುತ್ತದೆ. ಲೆಫ್ಟ್ ಲೆಗ್ ಶಾರ್ಟ್ನಿಂಗ್ ಬೈ 4 ಸೆಂಟಿಮೀಟರ್.
ಈಗಲೂ ಎಡಗಾಲಿನ ಟಿಬಿಯ ಸ್ಕ್ರೂ ಅಳವಡಿಸಿದ್ದು ಅಲ್ಲಿ ಕೀವು ತುಂಬಿಕೊಳ್ಳುತ್ತಿರುತ್ತದೆ. ಈಗಲೂ ಚಿಕಿತ್ಸೆಯನ್ನು ಮುಂದುವರಿಸಲಾಗಿದೆ. ನಾನು ದಿನಾಂಕ 14/7/2016 ಗಾಯಾಳವನ್ನು ಪರೀಕ್ಷಿಸಿದ್ದು. ಆ ದಿನ ಆತನಿಗಾದ ತೊಂದರೆಗಳನ್ನು ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಹೇಳಿರುತ್ತೇನೆ. ಗಾಯಾಳುವಿನ ಎಡಗಾಲಿನ ಮುರಿದ ಮೂಳೆಗಳು ಕೂಡಿಕೊಂಡಿರುತ್ತವೆ. ಎಡಗಾಲಿನ ಫೀಮರ್ ಮುರಿದ ಮೂಳೆಗೆ ವಿಳಂಬವಾಗಿ ಕೂಡಿಕೊಂಡಿರುತ್ತವೆ.
ಕರೆಕ್ಟ್, ಕೂಡಿಕೊಂಡಿದ್ದಾವೆ. ಬಟ್ ಹಿ ಹ್ಯಾಸ್ ಗಿವನ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ದಟ್ ದೇ ಯುನೈಟೆಡ್ ಬಟ್ ಮಾಲ್ ಯುನೈಟೆಡ್ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಿಕಾಸ್ ಆಫ್ ಓವರ್ಲ್ಯಾಪಿಂಗ್ ಇಲ್ಲಿದೆ. ಓಪನ್ ಫ್ರಾಕ್ಚರ್ ಆಗಿದ್ದು ಮೂಳೆಗಳು ಒಂದರ ಮೇಲೊಂದು ಕೂಡಿಕೊಂಡಿರುವುದರಿಂದ ಎಡಗಾಲು 4 ಸೆಂಟಿಮೀಟರ್ ಗಿಡ್ಡವಾಗಿರುತ್ತದೆ.
ನೋಡಿದೆ ಸ್ವಾಮಿ, ನೋಡಿದೆ.
That is not denied in the entire cross examination.
ಬಟ್
and there is a shortening of the leg.
ಫರ್ದರ್ ಇದ್ರೊಳಗಡೆ ಯುನೈಟ್ ಅಂತ ಕೇಳ್ಕೊಂಡಿದೀವಿ. ಹೌದು ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಯುನೈಟ್ ಆಗಿದ್ ಖರೆ.
ಹೌದು ಸರ್. ಅಲ್ಲ, ಶಾರ್ಟ್ನಿಂಗ್ ಬಗ್ಗೆ ನಾವೇನ್ ಇದ್ ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ಸರಿ ಹೋಗಿದೆ ಅಂತ ಕೇಳಬೇಕಾಯ್ತು.
ಶಾರ್ಟ್ನಿಂಗ್ ಇಟ್
ಯುನೈಟ್ ಆದ್ಮೇಲೆ ಸರಿ ಹೊಂದಿರುತ್ತೆ ಅಂತ ಕೇಳಬೇಕಿತ್ತು. ಅದೊಂದು ವರ್ಡ್ ಕೇಳಿಲ್ಲ.
So what is the illegality then? Taking future prospects. 30% ತಗೊಂಡಿದ್ದು excess ಇದೆ, I do consider it.
ಅದೇ ಸ್ವಾಮಿ, 40%
ಸಾರಿ 30% ತಗೊಂಡಿದ್ದು excess.
ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ಸ್ ಗೆ ತಗೊಂಡಿರೋದು 40% ಜಾಸ್ತಿ ಇದೆ. ಯಾಕಂದ್ರೆ 92% ದಿ ಲಿಂಬ್ಸ್ ಆಗುತ್ತೆ, 30% ಹೋಲ್ ಬಾಡಿ ಆಗ್ಬೇಕಾಗುತ್ತೆ. 40% ಕನ್ಸಿಡರ್ ಮಾಡಿ.
But you are not explaining a shortening of the limb.
ಹೌದು, ಅದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ನಾವು ಮಾಡಿಲ್ಲ. ಡಾಕ್ಟರ್ ಕೇಳಿದಾಗ ನೆಕ್ಸ್ಟ್ ಅದನ್ನ ಫರ್ದರ್ ಕ್ವೆಶ್ಚನ್ ಮಾಡಬೇಕಂತ ಕ್ವೆಶ್ಚನ್
ಮಾಡಿದ್ರೆ ಶಾರ್ಟ್ನಿಂಗ್ ಆಫ್ ದಿ ಲೆಗ್ ಮಾಡಿದ್ರೆ ಟೇಕಿಂಗ್ ಡಿಸಬಿಲಿಟಿ ಟು ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ 40% ಈಸ್ ರೀಸನೇಬಲ್. ಯಾಕಂದ್ರೆ ನೀವು ಸರಿಯಾಗಿ ಕ್ರಾಸ್ ಮಾಡಿದ್ರೆ ಯು ವುಡ್ ಹ್ಯಾವ್ ಎಲಿಸಿಯೇಟೆಡ್.
ನಾವು ಅದು ಯುನೈಟ್ ಆಯ್ತು ಅಂತ
ಅವ್ನು ಡ್ರೈವ್ ಮಾಡಕ್ ಬರುತ್ತೋ ಇಲ್ಲೋ, ಡ್ರೈವಿಂಗ್ ಏನು ಕೇಳಿಲ್ಲ.
ಬೋತ್ ದ ಬೋನ್ಸ್ ಯುನೈಟ್ ಆಗಿದೆ ಅಂತ ಅಷ್ಟು ನಾವು ಸುಮ್ಮನೆ ಆಗ್ಬಿಟ್ವಿ. ಶಾರ್ಟಿಂಗ್ ಬಗ್ಗೆ ಏನು ಹೇಳಕ್ ಹೋಗಿಲ್ಲ.
Anything else, Sukilra? ಇದು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ 25% ಬರುತ್ತೆ, ನಾಟ್ 30%. 30% ಪ್ರೊವಿಷನ್ ಇಲ್ಲ ಸೆಲ್ಫ್ ಎಂಪ್ಲಾಯ್ಡ್. ನಾರ್ಮಲಿ ಕೊಡಬಾರ್ದು, ಬಟ್ ಶಾರ್ಟ್ನಿಂಗ್ ಆಫ್ ಲೆಗ್ ಇದೆ. ಇಟ್ ಹ್ಯಾಸ್ ಥ್ರೋಟ್ ಲೈಫ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಸಫರ್.
ಇದೆ, ಮುಂದುವರಿಯುತ್ತೆ.
These appeals are filed under section 173(1) of MA Act, challenging the judgment and award passed in emission number 844 of 2015 on the file of Principal Small Causes Court and MACT Mysore, dated 28th August 2016, so far as it relates to quantum. MFA 1218 of 2017 is filed by the insurance company challenging the quantum of the award, seeking reduction, while MFA 5243 of 2017 is filed seeking by the claimants seeking the enhancement. As these appeals are arising out of the same matter, they are heard and common judgment is being passed next. There is no serious dispute regarding factual aspects leading to the case. That admittedly on 2012-2014 at 8:30 p.m. petitioner was driving Tata Ace Auto bearing KA 452245 while loading tomato on Humsur Mysore State Highway and near Yemme Gaudanakoppulu Gate in Vilkere village. The respondent number 1 drove his maxi catch bearing KA 02886487 in a rash and negligent manner and dashed to the vehicle, Tata Ace vehicle of the petitioner, resulting in the accident. The petitioner has suffered grievous injuries all over his body and he was immediately shifted to the hospital and he has spent more than ₹5 lakhs towards medical expenses. He was earning ₹25,000 per month by doing agriculture work and auto driving, and due to the extended injuries he is permanently disabled, and hence he filed a claim petition under section 166 of MU Act claiming compensation of ₹25,25,000 with interest at the rate of 12% per annum. Next, the petition was contested by the respondent insurance company, and it is asserted that there is actionable negligence on the part of the driver of the claimant himself and disputed the liability. The tribunal, after appreciating the oral as well as documentary evidence, has awarded a total compensation of ₹8,75,932 to the claimant with interest at the rate of 6% per annum by fastening the liability on the respondents. You are not disputing the liability, Alva?
Not disputed. Liability not disputed, madam.
Being aggrieved by this award, the insurance company has filed FFA 1218 of 2017 challenging the quantum, while MFA 5243 of 2017 is filed by the claimants seeking enhancement. Heard the arguments advanced by the learned counsel for appellant claimant and learned counsel for respondent insurer. There is the request. Next. the learned counsel for appellant claimant would contend that the claimant has suffered the fracture of both the bones of both the legs and he was inpatient for 66 days. The tribunal has taken disability to the extent of 40%, but no compensation was awarded under the head of loss of amenities and laid up period. Hence, he would seek for enhancement of the compensation. Per contra, the learned counsel for respondent insurer would contend that the tribunal has added 30% of future prospects, which is not permissible, and hence he would challenge the quantum. Having heard the arguments and perusing the records, it is evident that the claimant has suffered fracture of the right tibia and fibula, as well as left femur and left tibia. He suffered fracture of all the both the bones of both the lower limbs. He was inpatient for 66 days. The doctor has given disability to the extent of 92% to the both the lower limbs, and tribunal has considered 40% disability to the whole body. The tribunal has taken the income of 7,000 per month, a notional income of 7,000 per month, and added 30% future prospects by considering his income at 9,100 per month. The claimant was a self-employed, hence adding, he was also aged about 45 years. The claimant has also produced, has filed IA 1 of 22 under order 41 rule 27 by producing the school transfer certificate issued by government school, wherein his date of birth is shown as 14/2/1970. In the claim petition, he has mentioned his age as 45 years. All the medical records disclose his age as 45 years, except Exhibit P6, wherein his age is shown to be 46. Based on Exhibit P6, the tribunal has taken the multiplier 13, and now it is argued that considering the certificate and the other medical records, his age is between 44 to 45 and multiplier 14 is required to be applicable. There is no reason quoted by the trial court as to why the age is taken as 46 as referred in Exhibit P6, while in all other medical records, the age of the claimant is shown to be 45. Further, this is supported by the transfer certificate now sought to be produced under Exhibit under IA 1 of 2022. Looking to these facts and circumstances, the age of the deceased, age of the claimant is required to be taken as 44 to 45, and multiplier 14 is required to be applicable. The tribunal has taken disability at 40% to the whole body. It is to be noted here that the claimant has suffered fractural injuries to both the lower limbs, including left femur, which is the main weight-bearing bone. The admittedly claimant was agriculturist as well as driver. The medical evidence further disclosed that there is shortening of left leg by 4 centimeters. The cross-examination of PW2 disclosed that the said aspect is not at all denied. Though in the normal circumstances, 40% of disability is on higher side considering the fractural injuries, but in view of the fact that there is shortening of the leg of shortening of left leg to the extent of 4 centimeter, the disability taken at 40% by the tribunal to the whole body cannot be said to be excess or exorbitant. Hence, the tribunal has rightly taken disability to the extent of 40% to the whole body. Next one. However, tribunal has taken the future prospect to the extent of 30%. Claimant is injured person, and in normal circumstances, question of adding future prospects does not arise at all. Even otherwise, the future prospects are required. Since claimant was in self-employed, as per decision in Pranasheti, future prospects are required to be added to the extent of 25% only. In view of the division bench decision of this court, High Court, even the claimant, considering the gravity of injury, is entitled for loss of future prospects as per the decision of as per Pranasheti's case. And the tribunal has taken the notional income at 7,000, which is on lower side. Admittedly, the extent has occurred in 2014, and this court is consistently taking the income of the notional income at 8,500 in respect of the extent occurred in the year 2014. Hence, 8,500 is required to be taken, and if 25% is added, the loss of income, the monthly income would work out at 10,625. Considering the as observed, as discussed above, the age of the claimant is between 44 to 45, and as such, multiplier 14 is applicable. Hence, loss of future income would work out to 10,625 into 12 into 14. 14 into 40 divided by 100.
7,14,000.
7,14,000 as against 5,67,840 awarded by the tribunal. Next. The tribunal has awarded medical expenses to the tune of rupees 2,13,092 on the basis of medical records, which does not call for any interference. Further, tribunal has also awarded rupees 35,000 under the head of loss of under the head of nourishment and miscellaneous expenses, which also just and proper and does not call for any interference. Next one. The tribunal has also awarded future medical expenses to the tune of rupees 25,000, and considering the evidence of medical officer PW2, this is a reasonable one and does not call for any interference. Next one. The tribunal has awarded rupees 35,000 under the head of pain and suffering. Considering the fractures to both the bones suffered by the claimant, it appears to be on lower side, and hence the claimant would be entitled for rupees 50,000 under the head of loss of under the head of pain and suffering. Next, the tribunal has not awarded any compensation under the head of loss of amenities, and considering the nature of injuries suffered by the claimant, he would be entitled for rupees 30,000 under the head of loss of amenities. Next, admittedly the claimant was inpatient for 66 days. He ought to have been prevented from attending his normal work at least for 3 to 4 months. Considering the tribunal has not awarded any income during the laid-up period. Considering the notional income of rupees 8,500, the claimant would be entitled for loss of income for 4 months, which amounts to 8,500 into 4. 36,000. 34,000 ಆಗುತ್ತೆ ನೋಡಿ. 34 ಆಗುತ್ತೆ. 34,000. Hence, claimant would be entitled for total compensation under various heads as under pain and future earning 10,625,000, medical expenses 213,092, nourishment and miscellaneous expenses 35,000, pain and suffering 50, loss of amenities 30, future medical loss of income during lead-up period for 4 months 34, future medical expenses 25 total. Hence, claimant would be entitled for total compensation of 11 lakhs 1,092, which is rounded up to 11 lakhs 1,000 as against 8 lakhs 75,932 awarded by the tribunal. As such, the MFA 5243 of 2017 filed by claimant needs to be allowed in part. Accordingly, I proceed to pass the comment. MFA 5243 of 2017 is allowed in part. The claimant is held entitled for total compensation and so as against so and so awarded by the tribunal. The enhanced compensation shall carry interest at the rate of 6% per annum, 6 weeks. So, the entire enhanced compensation shall be released in favor of claimant. The MFA 1218 of 2017 filed by the insurance company stands dismissed.
Amount in deposit may be transferred.
Amount in deposit made by the insurance company shall be transmitted to the tribunal.
On housing, so morning session, morning, we will back tomorrow.
Tomorrow, as per request, at the request of learned counsel for respondents.
Lord, I appeal for appellant, my lord. Lord, the case of death, my lord. My lord, out of an accident, my lord, 2 appeals were filed. my lord.
Out of the accident ke bandidri illi accident
Alla, 2 appeals were filed, my lord. One on account of injury sustained by wife Devi Ramma, and on another one on account of death of Gangadharappa, the husband of the Devi Ramma, my lord. My lord, the injury case was disposed of, my lord. And
adella beda injury case mele ನೀವು ಏನು appeal ಬಂದಿದ್ದೀರಾ?
ಬಂದಿದ್ವಿ, ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ the liability was on the owner, my lord. This honorable court pay and recover ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಅದರಲ್ಲಿ. I'm just giving the facts what happened in the injury case. Now, my lord, the appeal is
what is ground ಏನು ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ.
ಹೌದು, ಅಲ್ಲ ಲೈಟ್ ಮೋಟರ್ ವೆಹಿಕಲ್ ಅಂತ LMV light motor vehicle. He was driving LMV.
That is covered now. That is now covered.
It is now covered, my lord.
So pay and recovery ಆಗಬೇಕು.
Yes, my lord. That is one aspect, lord. ಈಗ ಎರಡನೇದು ಏನಂದ್ರೆ ನಂದು appeal is death case is before my lords now. 157. That is arising out of MVC 899, my lord.
Okay, just ಕೊಟ್ಟಿದ್ದಾರೆ. What
ಇದ್ರಾಗ 3,11,000 the tribunal has awarded, my lord. The tribunal has awarded on medical grounds 2,90,756, food and nourishment 20,000. Idrag loss of dependency was not awarded, my lord.
ಯಾಕೆ?
ಯಾಕಂತಂದ್ರೆ the reason was that my lord, the court below held that there is no nexus between the death and the injury, my lord.
Death and injury, there is no nexus.
Nexus ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರು. The lordships may find the relevant paragraphs from in page 11 of the judgment, para 22, my lord. Para 25, I beg your pardon, para 25.
Okay.
Lordship's kind permission, may I read that?
Yes, Sherry.
As per police records and wound certificate, petitioner number 1, deceased Gangadarappa, was sustained injuries in road traffic accident and sustained injuries over portal region and tenderness over left shoulder. He has taken treatment at SS Hospital, Davangere and Kasturba Hospital, Manipal. Learned counsel for the petitioner number 1 submitted that in the course of the trial, petitioner number was died due to the impact of injuries sustained in road traffic accident. The learned counsel for the petitioner further submitted that there is no inquest mahazar and PM report of deceased Gangadarappa. But according to medical records, petitioner number 1 sustained pneumocephalus. It is nothing but live dead. There is direct nexus between injuries and cause of death of Gangadarappa. Hence, praise for grant of compensation. In order to prove the medical expenses and nourishment, petitioner number 1 produced 183 bills, medical bills, got marked at exhibit P14. Further, he has produced 30 prescriptions, got marked at exhibit P15. I have carefully perused medical bills and prescription, said bills and prescriptions issued the year 2013 only. There is no document in respect of follow-up treatment of Gangadarappa. The learned counsel himself submitted that there is no inquest mahazar and PM report of Gangadarappa. Further, learned counsel for petitioner number 1 submitted that petitioner number 1 examined on commission appointed by this court. There is no doubt petitioner number 1 examined on commission as per order passed by this court on IA-2 filed on 9/10/2014. As per contents of the affidavit which enclosed to IA number 6, petitioner number 1 died on 5/1/2016. According to petitioner averments, petitioner number 1 was sustained injuries on 13/34/2013. There was more than 2.5 years gap between accident and death of petitioner number 1. The LRs of petitioner number 1 have not produced authenticated document to show the nexus between the injuries and cause of death of Gangadarappa. Hence, I am of the opinion that LRs of deceased petition number 1 fails to prove that Gangadarappa died due to impact of injuries received in the accident. Hence, LRs of deceased Gangadarappa is entitled for medical expenses and conveyance and nourishment, food and attendant charges. Accordingly, a sum of so and so 20,000 towards convenience, nourishment, food and attendant charges. The petition number 1 produced 183 medical bills and got marked exhibit P14. Said bills are supported by IP numbers of SS Hospital, Davangere and Kasturba Hospital, Manipal. According to exhibit P14, petitioner spent amount of rupees 2,90,756 towards medical expenses and nourishment. Total, it comes to 3,10,756 in all. In all, the petitioner are entitled to a sum of rupees 3,11,000. Hence, a sum of 3,11,000 awarded towards medical expense, conveyance, food and nourishment. Now, my lord, my humble submission before my lords is that, my lord, the date of accident may kindly be perused 34/2013. And date of death is 5/1/2016. The nature of injuries, my lord, sustained by the petitioner is pneumocephalus. That is nothing but a live dead, my lord. So, my lord, since he was unable to move.
Who has stated so?
That we have produced the medical records, my lord, for that.
Who has stated so? Man kelid artha madkolli. Have you examined a medical officer?
Yes, my lord, we have.
He is to be treated as a civil dead.
Alla, Dr. Raguraj anta heli, we have examined him, my lord. Medical certificates, medical bills, disability certificate, ella hakiddivi. Disability idral baralla. Medical certificates we have produced.
One thing is to you are supposed to answer.
Please, my lord.
If he is live dead.
Please, my lord.
question of examining him on commission doesn't arise.
ಅಲ್ಲಲ್ಲ ಅವನಿಗೆ he was not able to move. That is my submission. ಅವನಿಗೆ movement ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ. And the second submission is that, my lord, the the post-mortem ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ, that is the reason, my lord, the court comes to such conclusion, my lord. PM report is not conducted.
Sir,
my humble
court
submission.
court wants only one thing.
Please,
there should be some nexus regarding the injuries and death.
Please, my lord.
Where is that evidence?
This medical records, my lord.
Medical record only, it says that pneumocephalus, that itself cannot be treated as a cause of death because of the injuries. It only disclose that it is a live dead.
Please, my lord.
Live dead doesn't mean that he is dead.
Live dead doesn't mean, please, my lord, correct, my lord.
He is bedridden, that's all.
Yes, my lord, he is bedridden, my lord.
It is not how you prove that subsequent death is because of these injuries only.
My lord, he was completely on bed, my lord, after the
Let
accident.
it be. He was bedridden, there is no dispute.
Please.
The question is,
yes, my
the
lord,
injury has resulted in death subsequent, which has led to his death.
please, my lord.
What is the evidence?
Injuries, my lord, the case is like this, my lord. There is also a commissioner who was appointed even to examine his evidence. That itself shows, my lord, that he was unable to move.
Madam, I am not disputing. Even in case of paraplegia, he will be unable to move.
Please, my lord.
He will be unable to. There is no dispute. The issue is cause of the death and the injuries. It is a civil death because he is lying on the bed lifelong. If he survived 100% disability, it is entitled for everything.
Please,
but now, since he is no more, burden is on you to prove that death is because of the consequences of the injuries sustained by him. There is any excess between the death and the injuries. That is the only crux.
Lord, then, my lord, there is no finding also that he was not bedridden also, my lord. If that were to be the case, my lord, conclusion.
You have come in appeal.
My only
our trial court finding ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ ignore ಮಾಡಿ.
Postmortem report ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, my lord. Postmortem report, my lord, these people, my lord, come from villages. They don't permit for postmortem report, my lord. There are some sentiments, my lord. That is
no, madam, it is not the duty of the claimant. It was the duty of the hospital authorities. If he died because he was admitted in the hospital because of the injuries sustained, subsequently he dies, and death is not within 1 month or 2 months or 3 months, 2.5 months, 2.5 years.
Please, my lord.
He was a prolonged treatment.
Lordships may kindly peruse the records, my lord. It is a
I am asking you, records is okay. I am asking you, Nexus, where is
a person who is bedridden for more than 2 years, my lord, cannot survive, my lord.
Is it your statement? See, I'll ask you one question.
Please,
do you mean to say that a person who is lying on the bed for 2.5 years does not survive? Then a person in coma, doctor need not treat him, allow him to die. Coma, years together, they will be in coma.
There are
in home of ಎಷ್ಟೋ ಜನ ವರ್ಷಾನುಗಟ್ಟಲೆ bedridden ಆಗಿರ್ತಾರೆ. It cannot be treated that he is dead.
My lord, this bedridden is due to the injury sustained by the accident, my lord. That is my humble submission, my lord. And moreover, my lord, post-mortem report, my lord, there are several judgments of this honorable court, my lord, that PM report.
Madam, post-mortem report, I can understand.
Please, my lord.
100%. But
medical evidence.
Medical evidence, Nexus ತೋರಿಸಲಿಕ್ಕೆ medical evidence ಏನಿದೆ ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇ.
Please, my lord, I will, my lord. Lordships may kindly peruse the trial court records, my lord. Exhibit P8, my lord. May I read, my lord? This is issued by Kasturba Hospital, my lord, Manipal. This is to certify that Mr. Gangadharappa, with history of closed head injury and right temporal contusion, he underwent emergency right frontal parietal craniotomy and hematoma evacuation on 1/5/2013. He was discharged on 8/6/2013 with GCS of so-and-so with left hemiparesis. He has attended regular OPD follow-up with visit and found to have left hemiplegia. He was consulted with neuropsychological assessment. He has been given a 50% disability from neurology department. This is one of the document, my lord, which is issued by the neurological department, my lord, Kasturba Hospital.
Madam, ನಾನು ಕೇಳಿದ್ದು ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ. Where is the evidence of doctor who states, certifies that there is nexus between the injuries and death?
It happens during the course of trial, my lord. He dies during the course of.
Correct. Irlialla. During the course of the trial, he died. Let him die during the course of the trial. He was under treatment, alma. What prevented you from examining a doctor to prove that the death is because of the consequences of the injuries suffered by him?
ಅಲ್ಲ, ಅದು ಬರೀ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಅಷ್ಟೇ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತಿತ್ತು.
ಪೋಸ್ಟ್ ಯಾರು ಹೇಳಿದ್ರೆ ಮೇಡಮ್? ಡಾಕ್ಟರ್ ಹೇಳ್ತಾರೆ ಈ ಇಂಜುರಿಗೆ ಅವ್ರು ರಿಕವರಿ ಆಗ್ತಿದ್ರೆ ಡೆತ್ ವಾಸ್ ಡ್ಯೂ ಟು ಅಂತ ಹೇಳಿ.
I will get the dictionary meaning of this pneumocephalus, my lord. It means what ಅಂತ ಹೇಳಿ ನಮ್ಮ ಮುಂದೆ ಬೇಕಾದ್ರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಂದ್ರೆ ಮಾಡ್ತೀನಿ. It is a genuine case, my lord. Exhibit P12 also may kindly be produced, my lord. Treatment summary ಹಾಕಿದ್ದೀವಿ ಅದ್ರಾಗ.
ಅಲ್ಲ ಮೇಡಮ್, ನೀವು ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್
CT scan ಅಲ್ಲ, exhibit P12, there are several documents. P12 is also.
Madam, I am asking you the evidence of a expert who certify that there is nexus.
I will, my lord, I will. P12 and P13 may kindly be produced, my lord.
ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ evidence of a doctor. You are arguing P11 and P12.
ಅದ್ರ ಬಗ್ಗೆ ಅವ್ರದ್ದು ಏನು ಎವಿಡೆನ್ಸ್?
My lord, apparently.
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ನೀವು.
Correct.
Where he died? Whether he died in the hospital or in the home?
Illa, at home, my lord, at home.
He died in the home after discharge.
Please, my lord.
Then the heavy burden is on you to establish that there is some nexus. A doctor treated doctor exam ಮಾಡಬೇಕಾಗಿತ್ತು. ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರು, ದಾವಣಗೆರೆ ಹಾಸ್ಪಿಟಲ್ ಒಬ್ಬರನ್ನ ಎಕ್ಸಾಮ್ ಮಾಡಲಿಲ್ಲ ನೀವು. And now you are arguing and you are not a rustic villager. You are resident of Davangere city.
A rustic villager andre his
Davangere alli irtira ನೀವು. And ನಮಗೆ ಗೊತ್ತಾಗಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ. How it can happen?
My instructions are that, my lord. May I, my lord? My instructions are that, my lord, due to injuries he was completely bedridden. Manushargondu, and subsequently, my lord, after his death, my lord, he got a promise from his wife that not to get the post-mortem report PM done.
See, for your ನಿಮ್ ಗಂಡನಿಗೆ ನೀವು ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ದಕ್ಕ you want the other side should suffer.
Other side suffer alla,
ಮತ್ತೆ that is your emotional feelings alva.
Emotional alla. In so far as PM report is concerned, I am making my submission, my lord.
No, madam.
My lord, loss of dependence, definitely.
I am not concerned about, since it has occurred after 2.5 years, it may not be possible to conduct the PM. I do consider it, but you are required to prove the nexus. What is the evidence? Doctor ne exam madlilla ನೀವು. Treated doctor, this injury is likely to lead to death ಅಂತ ಹೇಳಿ ಏನಿದೆ ನಿಮ್ದು ಎವಿಡೆನ್ಸ್?
Lord, may I make submission like this, my lord? If a person, my lord, sustains any fractures, my lord, at the age of above 60 years, my lord, ಹಾಸಿಗೆ ಹಿಡಿದ್ರೆ ಮೆಲಾಡ್ ಡೆಫಿನೆಟ್ಲಿ ಮೆಲಾಡ್
ಹೇಳಲ್ಲ. ಅದನ್ನ ಯಾರು ಹೇಳ್ಬೇಕು? Who has to tell it? A expert should come and depose before the court. He is subjected to cross examination. Then only that it becomes an evidence. ನೀವು ಅದನ್ನ ಏನೂ ಮಾಡಲ್ಲ. ಒಂದು ಡಾಕ್ಟರ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಸಪೋರ್ಟ್ ಮಾಡಿ ಯು ಟ್ರೀಟ್ ಇಟ್ ಆಸ್ ಎ ನೆಕ್ಸಸ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
ಪ್ಯಾರಾಪ್ಲೀಜಿಯಾ ಕೇಸ್ ಅದ ಅಂತ ಹೇಳಿ ಎಕ್ಸಿಬಿಟ್ ಇದೆ ಮೆಲಾಡ್. ಇದಕ್ಕಿಂತ ಹೆಚ್ಚು ಅವರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಸಿಲ್ಲ.
No madam, cannot accept it. Yes, what you have to say?
It is a genuine case, my lord. It is a genuine case, my lord. That is
Yes,
my humble.
but it may be genuine. We feel sorry, but it is not supported by documents, and court will proceed only on the basis of documents. Personal feelings of the parties will not override the documents. Alva. ಅವನು ಸಾಯೋ ಟೈಮ್ದಾಗ ನೀ PM ಮಾಡಿಸ್ಬೇಡ ಅಂತ ಹೇಳಿ ಪ್ರಾಮಿಸ್ ತಗೊಂಡಿದ್ದ. Okay, fine. Whether it can be taken note of.
ಎಕ್ಸಿಬಿಟ್ P12 P13 ಅಲ್ಲಿ ಇದ್ರ ಬಗ್ಗೆ ಡಿಸ್ಕಷನ್ ಆಗಿದೆ. Lordship, kindly peruse for a moment 12 and 13.
ಆಯ್ತ್ರಿ, ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ ಅದನ್ನ. See, who has to depose about those documents?
I understand, my lord. Doctor ought to
ಅವ್ರು
have
ಯಾರಾದ್ರೂ author ಬಂದು ಹೇಳಲ್ಲ. You have not examined the author of those documents.
Exhibit PW3 Raghunath.
ಇಲ್ಲ, ಅದು ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಮೇಡಮ್.
PW3 ಹುಡುಗ ಈ ಕೇಸ್ ಒಳಗೆ ಇಲ್ವೇ ಇಲ್ಲ. PW3 is regarding injuries.
Injury case.
ಮತ್ತೆ ಈ ಕೇಸ್ ಒಳಗೆ ಒಬ್ರು ಡಾಕ್ಟರೇ ಇಲ್ಲ.
Whatever medical records are there, I have submitted.
So medical records,
instructions,
who has issued, author was not examined, and now you are coming to court on the ground that there is nexus. Burden is on you to prove the nexus. You don't want to examine a medical officer, a treated doctor, to say that such type of injury will lead to death, and subsequent is the death is because of these injuries until any evidence illalla.
Evidence exhibit ಅಲ್ಲಿ forthcome ಆಗ್ತಾ ಇದೆ.
Exhibits are not proved, madam. They only say nature of injuries will prove. Consequences of injury, author is required to be examined alva. Author ne exam ಮಾಡಲ್ಲ ನೀವು.
ಯಾವ ಗ್ರೌಂಡ್ ಅಲ್ಲೂ ಮೆಲಾಡ್. It's a great
No madam, whatever is granted. ಅದಕ್ಕೆ ಹೆಚ್ಚಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. But one thing is, in view of the change of law, pay and recovery ಅಂತ ಆಗುತ್ತೆ.
Neither he's been treated as injury case ಅಂತ ಆಗಿಲ್ಲ, nor death case ಮೆಲಾಡ್.
ನೀವು ಮಾಡಿಸ್ಲಿಲ್ಲ, ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ ನೀವು ಮಾಡಿಸ್ಬೇಕಾಗಿತ್ತಲ್ವ ಇವನ್ನೆಲ್ಲ. Even if he died, it doesn't prevent you from leading further evidence to prove the nexus alva. You could have examined some doctors under whom he was under regular medication. ಅವ್ರನ್ನ ಎಕ್ಸಾಮ್ ಮಾಡಿ ಇದರಿಂದ ಡೆವಲಪ್ಡ್ ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ಅಂತ ಏನ್ರಿ ಎವಿಡೆನ್ಸ್ ಬೇಕಾಗಿತ್ತಪ್ಪ.
P12 and 13 may kindly peruse before my lords.
ನಿಮ್ಗೆ ಏನ್ ಹೇಳ್ತಾ ಇದೀನಿ ನೀವು ಅರ್ಥನೇ ಮಾಡ್ಕೊಳ್ತಾ ಇಲ್ಲ ಮೇಡಮ್. ಎಕ್ಸಿಬಿಟ್ P12 and 13 ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರು whether it will prove nexus.
ಅಲ್ಲ, nature of injuries ಅಂತೂ ಪ್ರೂವ್ ಆಗುತ್ತೆ.
ಮೇಡಮ್, ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಗೆ ನಿಮಗೆ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. We are not disputing nature of injuries. We are asking you nexus. Nexus, how you are going to prove?
ಅಲ್ಲ, the conclusion of the tribunal is PM report ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಟ್ರಿಬ್ಯುನಲ್ ತಪ್ಪು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ. Let us accept it. Now you are in appellate court. On question of fact as well as on question of law, we'll consider it. The evidence sourcing. Court is empowered to reconsider the entire evidence. ಮಾಡೋಣಂತೆ. ನೀವು ಬರೀ 2P12 and P13 ನೋಡಿ ಅಂತ ನಾವು ನೋಡ್ತೀನಿ. ನಾನು it discloses gravity of injuries, that's all. It doesn't disclose that it will lead to death ಅಂತ ಹೇಳಿ ಏನ್ರಿ ಇದ್ದೇನಾ? Is there any nexus? ಅಥವಾ ಈ ಆಥರ್ನ ಎಕ್ಸಾಮ್ ಮಾಡಿ it is likely to cause the death ಅಂತ ಏನ್ರಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸಿದ್ದೀರಾ?
That is not done, my lord.
Huh?
Except the medical.
ಮತ್ತೆ except
Exhibit P8, P12, P13 ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾವುದು ಇಲ್ಲ. But it's my lord, my humble submission is that, my lord, it is a genuine case, my lord.
Yes.
Where it is, it can be construed as.
Yes. In fact, ಇನ್ನೊಂದು ಟ್ರಿಬ್ಯುನಲ್ ದವರು ಅವ್ರು ಅಪೀಲ್ ಮಾಡಿಲ್ಲ. The deceased hit the one vehicle from back rear end. Oh, smashment. Some contributory negligence ಹಾಕ್ಲಿಲ್ಲ ಅವರು. ಹೌದಾ?
ಇಲ್ಲ.
Huh?
They were moving, my lord, in a motorcycle, my lord.
Motorcycle ದವ್ರು ಹೋಗಿ ಹಿಂದಿನಿಂದ
extreme left side ಅಲ್ಲಿ dashed against motorcycle ಅಂತದ. Dashed against motorcycle. He was riding a motorcycle, my lord. He was apparently dashed against the by the Mahindra Alpha anta. Dashed against. These are all like coolies, my lord, agricultural coolies.
Coolies ಅಂತ ಹೇಳ್ತೀರಿ, 2-wheeler ಮೇಂಟೈನ್ ಮಾಡ್ತೀರಾ?
ಇವಾಗ my lord
ಕಾಮನ್ ಆಗಿಬಿಟ್ಟದ.
Please, my lord. My instructions are that, my lord, that since he had sustained hemiplegia, my lord, which is as good as live dead, my lord. Lord, as such, my lord, they had just kept him at home.
Yes.
Lord,
my
submission is that my lords may kindly grant under the head of loss of dependency, my lord, some amount may be awarded.
Some ಕೊಟ್ರೆ ಪೂರ್ಣ ಕೊಡ್ತೀವಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಏನು ಕೊಡಲ್ಲ. That is the law.
I go down.
Some ಕೊಡಕ
it's a genuine case.
ಸ್ವಲ್ಪ ಆದ್ರೂ ಕೊಡ್ಬೇಕು, ಅದಕ್ಕ ಪರಿಭಾಷೆ ಒಳಗ ಇಲ್ಲ, ಕಾನೂನು ಪರಿಭಾಷೆ ಒಳಗ ಬರಲ್ಲ. If you are entitled, you are entitled. If you are not entitled, you are not entitled. That's all.
Please,
yes, what you have to say?
My lordship, not only PN report, my lord, after he was died on 1/5/2016.
Yes.
He has sustained injuries on 34/2013. For
Yes.
there were more than 2.5 years of gap, my lord. They have not placed any material to show that 5/1/2016 he was taken to hospital, or before that 15 or 16 below. ಅದರಲ್ಲೂ ಎಲ್ಲೋ ಹಾಕಿಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್. ದಿಸ್ ಮ್ಯಾಟರ್ ವಾಸ್ ಹರ್ಡ್ ಸಮಟೈಮ್ಸ್, my lord, in several benches. ಅವ್ರಿಗೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ರು, ಅವ್ರಿಗೂ ಸಿಕ್ಕಿಲ್ಲ ಮೆಟೀರಿಯಲ್ ಏನು ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ಲಿಕ್ಕೆ.
ಏನಿದ್ದಿದೆ we have produced it. Whatever is there, my lord, it is before my lords in
This matter was urgent for production of additional documents, but my lord, is not placed.
That lady is a poor lady, my lord, the wife. Papa coolies, from where will she run behind the documents now at this point?
Connected matter pain recovery ಆಗಿರೋದ್ರಿಂದ this matter may be not as pain recovery.
Even that is covered law.
ಹೌದು ಕವರ್ ಆಗುತ್ತೆ.
Mukundev case.
Heard. Good with counsel. This appeal is filed by claimant LR of deceased Gangarappa, challenging the judgment and award passed in emission number 899 of 2013 on the file of third additional senior civil judge and MECT 7 at Davangere under section 173(1). Seeking enhancement. There is no dispute regarding the factual aspects. On admittedly on 30/4/2013 at 4:30 p.m. the deceased and his wife Devi Rama were proceeding on a two-wheeler, and at that time the respondent drove his Mahindra Alpha pickup plus van bearing KE 17/B6638 in a rash and negligent manner and knocked them from that side. As a result, both deceased as well as his wife Devi Rama sustained grievous injuries. They filed claim petitions under section 166 of MU Act. The deceased filed MEC 899 of 2013, while his wife, who is a legal heir in this case, has filed MEC 966 of 2013 claiming compensation. Next one. During pendency of the claim petition, the deceased Gangadharappa was examined on commission as PW1. Subsequently, he died on 5/1/2016. The wife of the deceased was brought on record as a legal heir and she prosecuted the matter. Next. The tribunal, after appreciating the oral as and documentary evidence, has held that there is no nexus between the death of deceased Gangadharappa and injuries sustained by him, and hence awarded rupees 3,11,000 towards medical expenses of the deceased, including nourishment. The tribunal has denied the compensation under other head of loss of dependency. Apart from that, the tribunal has fastened the liability on respondent number 2, owner, on the ground that the driver of the offending vehicle was not possessing valid and effective driving license. As such, next, being aggrieved by this judgment and award, the claimant, that is the LR of the deceased, has filed this appeal seeking enhancement. Heard the arguments advanced by the learned counsel for appellant, claimant, and learned counsel for respondent, insurer. Peruse the records. The learned counsel for claimant appellant would contend that the accident has occurred on 30/4/2014 and deceased died on 5/1/2016 because of the injuries sustained in the road traffic accident. She would also invite the attention of the court to exhibit P12 and P13 and contended that considering the gravity of the injuries, as the deceased has suffered pneumocephalus, which is a live dead, it is evident that the death is as a result of the injuries sustained by the deceased in the road traffic accident, and hence she would contend that tribunal is not justified in insisting PM report as well as inquest and sought for enhancing the compensation by awarding the compensation under the head of loss of dependency as well as under other statutory heads. She would also contend that tribunal has fastened the liability on the owner and it ought to have fastened the liability on the insurer with an order for pay and recovery as it was done in respect of the claim petition filed by her pertaining to injuries sustained by her. Next. Per contra, the learned counsel for respondent insurer would support the judgment and award and further contend that death was subsequent to 2.5 years and there is no evidence to show the nexus between the injuries and death. He would also contend that there is no evidence to show that prior to the death, the deceased was admitted in any of the hospital for complications regarding the injuries sustained by him. And the medical officer is also not examined to substantiate the said contention. Hence, he would contend that tribunal is justified in awarding the compensation under the medical heads. He would also contend that in view of the decision in Devan case, the pay and recovery can be passed, an order regarding pay and recovery needs to be passed as same is passed in the other case pertaining to the legal heir of the deceased who was also Devi Rama, who was also injured. Next. Having heard the arguments and perusing the records, it is evident that the claimant has suffered grievous injuries in the road traffic accident. The liability is not under serious dispute as the vehicle was duly insured with respondent number 3 insurer. However, there was no license to the offending driver and hence on this ground the tribunal has fastened the liability on the owner for breach of policy conditions. However, this law is settled in view of the decision reported in AR 2017 SC 3668 Mukul Devgan. And as such, the insurance company is liable to pay the compensation as policy was in force, and for breach of policy conditions, the insurance company is at liberty to recover the same from the owner respondent number 2. However, the claimant, it is all along asserted by the learned counsel for appellant that the death is because of the consequences of injuries sustained by the deceased in the road traffic accident dated 30/4/2014. It is to be noted here that death has occurred after 2 years, 8 months. The accident has occurred on 30/4/2014 and the death has occurred on 5/1/2016. Though the claimant and though the learned counsel for appellant has placed reliance on exhibit P12 and P13, they only disclose the grievous nature of injuries and he was being treated in Davangere as well as Manipal Hospital by a neurosurgeon. But however, there is no scrap of the evidence led by the claimant legal heir to show that there is any nexus between the death occurred on 5/1/2016 because of the injuries sustained on 30/4/2014 itself.
13 minutes, 13.
13/4.
34/2013.
ಅದ 34/2013
ಹೌದು ಸರ್ ಅದು
Please, my lord, please.
2013
34.
2013. Though the medical records produced by the voluminous medical records produced by the claimant appellant would disclose that the deceased suffered grievous injury and was bedridden, the evidence disclosed that he was examined on commission as PW1, but subsequent to his examination, he has suffered merely because he was bedridden or unable to move. It cannot be presumed that the injuries had led to his death. Nothing prevented the claimant to examine any of the doctors treated the claimant either from Manipal Hospital or from Davangere Hospital to prove any nexus between the death. No doubt, in view of there is long delay, postmortem or inquest may not be possible, but however, the claimant, the legal heir, ought to have examined any medical officer, the expert who has treated the deceased to show any nexus between the death and the injuries sustained. In the absence of any expert's evidence in this regard to show that there is any nexus, merely on the basis of Exhibit P12 and P13, it cannot be presumed that death is because of accidental injuries only, that too after more than 2.5 years. Under these circumstances, the tribunal is justified in awarding only 3,11,000 towards medical expenses, which does not call for any interference. Next. However, as observed above, the appeal needs to be allowed in so far cautioning the liability of payment of compensation to respondent number 3 insurer. Hence, the appeal needs to be allowed in part, and accordingly I proceed to pass on. The appeal is allowed in part so far as it relates to liability to pay the compensation. The award of the tribunal granting compensation of ₹3,11,000 to legal heir Devi Rama stands confirmed. However, the respondent number 3 insurance company is directed to pay the amount with accrued interest thereon as awarded by the tribunal, and with a liberty to recover the same from the owner respondent number 2 as per the decision cited. So
Yes.
Therefore, the appellant. The appellant is challenging the judgment and award passed by the learned trial judge. It is at page number 10, my lord. Dismissing the claim petition filed under section 22 of the Workmen Compensation Act of 1923. The ground stated at paragraph 23 and 24 of the impugned judgment. Lordship may kindly peruse in page 21 and paragraph 24. Paragraph number 24. In page 21.
Yes.
It is important to note here that the petitioner has taken a treatment at Dhanvantri Charitable Hospital, Sringeri Kopra Government Hospital, Venlock Hospital, Mangalore, and also from PW1 Uday Shankar. But PW3 admitted in his evidence that he and his brother respondent number 2 have not given any information to the medical officer that the petitioner has sustained injuries while removing the branches of standing trees in the estate, respondent number 1 estate. Even PW2 also admitted in his evidence that he has not given any information to the medical officer attached to Dhanvantri Charitable Hospital, Sringeri, Koppa Government Hospital, and Venlock Hospital, Mangalore, that he sustained injuries while removing the branches of standing trees in the estate, respondent number 1 estate. The very inaction on the part of the petitioner PW3 leads an adverse inference and creates a doubt about their evidence. Further, it is also important to note here that petitioner stated to have sustained injuries during the course of employment under respondent number 1 while removing the branches of the standing trees in respondent number 1 estate. If that is so, he can immediately lodge a complaint before jurisdictional police station, but he has not done so. Further, it is forthcoming the evidence of PW3 that after the accident, he and other workers, namely Mohan, Puttanna, Ananda and others came to the place of the accident. But neither PW2 nor the co-owners have informed about the incident to the nearest police station. PW2 and PW3 admitted that they did not attempt to lodge any complaint either before Sringeri police station or Jaipura police station. No explanation as such forthcoming either in the pleadings or in the evidence of PW2 and PW3 as to why the complaint was not lodged before the police station about the alleged incident. Therefore, the say of the petitioner that he had sustained injuries during the course of employment under the respondents is highly doubtful and cannot be accepted. Therefore, the reasons discussed above, I hold that the petitioner failed to prove that he was an employee under the respondents and he sustained previous injuries. My Lord, in this context, I would like to make two very important submissions, my Lord. My Lord, learned trial judge, my Lord, has dismissed the claim petition on the two very important grounds, amongst other grounds, my Lord. The first ground, my Lord, is that the appellant, my Lord, and PW3 have not lodged a police complaint, my Lord, to the nearest police station. That is not.
Yeah, there are two grounds. One is complaint is not lodged, and the second is if the said information regarding accident during employment was not even reported to the medical officer while undergoing treatment. Two grounds are there, not one ground.
Two important grounds.
There is no, they are not the relationship between employer.
That is a secondary. This is the only first two grounds.
My humble submission, my Lord, is that two grounds, my Lord, are not signed on under section 22, my Lord. In order to do a case under section 22, they are not essential ingredients. That is to report a complaint to the nearest police station.
That is not an essential ingredient. That is a one aspect. But the basic thing is that you suffered an injury in the accident. As early burden is on you.
Please, my Lord. My Lord, your Lordship.
Either quite natural. You should have reported to doctor who have treated you that it is because of fall in such a place.
It was reported, my Lord. Your Lordship may kindly peruse PW1 statement. That is, the medical officer was examined, and in PW1 deposition, he has clearly stated that the appellant, my Lord, has sustained injuries due to the fall from the tree. PW1 deposition.
Where?
In his deposition.
Where he fall?
That fact is silent.
See, that is the crux, because place when it is fall in a estate while trenching the tree branches, he is under employment in that event, that is okay. If he falls there itself during his employment, course of employment as a worker in a tea estate, estate, fine. But here, that is also one thing is missing as observed by the tribunal. Is there any evidence regarding relationship?
My Lord, in order to prove the case, my Lord, appellant examine PW3, that is co-worker, my Lord, working in the respondent number 1 estate. Also, may kindly peruse the deposition, my Lord, of PW3. My Lord, one more aspect, my Lord, respondents have not led, respondent number 1 has not led any evidence.
He has neither admitted that you are employee.
The Lordship may kindly peruse inquiries, two of the deposition, chief examination. Wherein, my Lord, in paragraph 2, Sadari Apagatavu. In page 2 of the PW3.
Who is PW? Because there is.
PW3, my Lord, is.
What is the name?
Mustafa is a co-worker working in respondent number 1 estate. Your Lordship, with your permission, I will read the deposition. ಮೇಲ್ಕಂಡ ಅರ್ಜಿ ಅಂಶಗಳನ್ನು ಈ ಪ್ರಮಾಣ ಪತ್ರದ ಒಂದು ಭಾಗವನ್ನಾಗಿ ಪರಿಗಣಿಸಬೇಕಾಗಿ ವಿನಂತಿ. ಈ ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರು ಅರ್ಜಿದಾರರು ನನಗೆ ಗೊತ್ತಿರುತ್ತದೆ. ಅರ್ಜಿದಾರರು ಮತ್ತು ನಾನು ಮತ್ತು ಇತರೆ ಕಾರ್ಮಿಕರುಗಳಾದ ಮೋಹನ್ ಪುಟ್ಟ.
One ನಿಮಿಷ, I didn't follow. Either he is a claimant.
He is a co-worker.
Either he is a claimant. How can he say that the recitals of this affidavit should be treated as part and parcel of the claim petition? What is his duty? He is supposed to support him by giving some evidence. He is saying that as if he is a claimant, treat it as part and parcel of the claim petition. Yen Swami.
But further, my lord, at the middle paragraph, middle my lord portion, ಅನೇಕ ವರ್ಷಗಳಿಂದ ಎರಡನೇ ಎದುರುದಾರರ ಅಡಿಯಲ್ಲಿ ಟಿಂಬರ್ ವರ್ಕ್ಸ್ ಆಗಿ ಕೆಲಸವನ್ನು ಬೇರೆ ಬೇರೆ ಕಡೆಯಲ್ಲಿ ಮಾಡಿರುತ್ತೀವಿ. ಅಂತೆಯೇ ದಿನಾಂಕ 8/11/2005 ನಾನು ಮತ್ತು ಅರ್ಜಿದಾರರು ಮೇಲೆ ಹೇಳಿದ ಕಾರ್ಮಿಕರುಗಳು ಎರಡನೇ ಎದುರು ಅರ್ಜಿದಾರರ ಅಡಿಯಲ್ಲಿ ಒಂದನೇ ಎದುರು ಅರ್ಜಿದಾರರ ಅಡಿಕೆ ತೋಟದಲ್ಲಿದ್ದ ಮರವನ್ನು ಕಡಿತಲೆ ಮಾಡುತ್ತಿರುತ್ತೇವೆ. ಆ ದಿವಸ ಅರ್ಜಿದಾರರು ಹಾಜರಿದ್ದು ಒಂದನೇ ಎದುರು ಅರ್ಜಿದಾರರಿಗೆ ಸೇರಿದ ಅಡಿಕೆ ತೋಟದಲ್ಲಿ ಎರಡನೇ ಎದುರು ಅರ್ಜಿದಾರರ ಆದೇಶದ ಮೇರೆಗೆ ಮರವನ್ನು ಕಡಿತಲೆ ಮಾಡುತ್ತಿರುವಾಗ ಅರ್ಜಿದಾರರು ಆಯತಪ್ಪಿ ಮರದ ಮೇಲಿಂದ ಕೆಳಗೆ ಬಿದ್ದಿರುತ್ತಾರೆ. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಹಾಜರಿದ್ದು ಇತರೆ ಕಾರ್ಮಿಕರು ಹಾಗೂ ಒಂದನೇ ಹಾಗೂ ಎರಡನೇ ಎದುರುದಾರರು ಅರ್ಜಿದಾರರ ಆದೇಶ ಮೇರೆಗೆ ಅರ್ಜಿದಾರರನ್ನು ಶೃಂಗೇರಿ ಧನ್ವಂತರಿ ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಿರುತ್ತೇವೆ. ಎಕ್ಸ್ರೇ ಅನ್ನು ತೆಗೆದು ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗೆ ಸಲಹೆ ನೀಡಿದ ಮೇರೆಗೆ ಅರ್ಜಿದಾರರನ್ನು ವೆನ್ಲಾಕ್ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲಾಯಿತು. ಸದರಿ ಅಪಘಾತವು ಎರಡನೇ ಎದುರುದಾರರ ಅರ್ಜಿದಾರರ ಆದೇಶದ ಮೇರೆಗೆ ಒಂದನೇ ಎದುರು ಅರ್ಜಿದಾರರ ತೋಟದಲ್ಲಿ ಮರಗಳನ್ನು ಕಡಿತಲೆ ಮಾಡುತ್ತಿರುವ ಸಮಯದಲ್ಲಿ ಉಂಟಾದ ಅಪಘಾತವಾಗಿರುತ್ತದೆ. ಒಂದನೇ ಎದುರು ಅರ್ಜಿದಾರರು ಕೆಲಸದ ವೇಳೆಯಲ್ಲಿ ಹಾಜರಿದ್ದು ಮರವನ್ನು ತೆಗೆಯುವ ಬಗ್ಗೆ ಆಗಾಗ್ಗೆ ನಿರ್ದೇಶನವನ್ನು ನೀಡುತ್ತಿದ್ದು ಮೇಲ್ವಿಚಾರಣೆಯನ್ನು ಮಾಡುತ್ತಿರುತ್ತಿದ್ದರು. ಅರ್ಜಿದಾರರಿಗೆ ಅಡಿಕೆ ತೋಟ ಮತ್ತು ಕಾಫಿ ತೋಟಗಳು ಎರಡು ಇರುತ್ತವೆ. ನಮ್ಮಗಳಿಗೆ ಎರಡನೇ ಎದುರು ಅರ್ಜಿದಾರರು ಪಟಾವಣೆಯನ್ನು ಮಾಡುತ್ತಿದ್ದರು. ಎರಡನೇ ಎದುರು ಅರ್ಜಿದಾರರು ಒಂದನೇ ಎದುರು ಅರ್ಜಿದಾರರಲ್ಲದೆ ಬೇರೆ ಇತರೆ ಅಡಿಯಲ್ಲೂ ಟಿಂಬರ್ ವ್ಯಾಪಾರವನ್ನು ಮಾಡುತ್ತಿರುತ್ತಾರೆ. ಎರಡನೇ ಅರ್ಜಿದಾರರ ಕೆಳಗೆ ನಾವು ಅನೇಕ ವರ್ಷಗಳಿಂದ ಕೆಲಸವನ್ನು ಮಾಡಿಕೊಂಡು ಬಂದಿರುತ್ತೀವಿ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ in page 4, cross examination my lord made by respondent number 1 advocate. ಅಪಘಾತವಾಗುವುದಕ್ಕೆ ಮೊದಲು ನಾನು 9 ವರ್ಷಗಳಿಂದ ನಾನು ಎರಡನೇ ಪ್ರತಿವಾದಿಯಲ್ಲಿ ಟಿಂಬರ್ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ. ಆ ಬಗ್ಗೆ ಪಳನಿಯವರು ನನಗೆ ಸಂಬಳ ಕೊಟ್ಟು ವೋಚರ್ಗಳಾಗಲಿ ಬೇರೆ ದಾಖಲೆಗಳಾಗಲಿ ನನ್ನ ಬಳಿ ಇಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿ ನನಗೆ ಪರಿಚಯಿಸ್ತರಲ್ಲ. ನಾನು ಕೃಷ್ಣಮೂರ್ತಿಯವರನ್ನು ಗುರುತಿಸಬಹುದು. ನಾನು ಒಂದನೇ ಪ್ರತಿವಾದಿಯವರನ್ನು 1 ವಾರ ಕಾಲ ಕೆಲಸ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ನೋಡಿರುತ್ತೇನೆ. However, my lord, in this context, learned trial judge, my lord, has.
What is the relationship between respondent number 1 and 2?
Lord, it has been contended by the appellant, my lord, that respondent number 2 is a timber contractor under respondent number 1 is. My lord, appellant, my lord, that claimant is a timber coolie. His work, my lord, is to cut the branches and cut the trees, my lord, and.
Where exactly accident has occurred according to you?
My lord, in respondent number 1 estate.
Where exactly? See, what is the extent of estate of the respondent number 1?
It has been mentioned, my lord, further in cross examination.
230.
Case number 1, goes with the judgment matter, serial number 50, position 3.
The appeal is allowed in part. The judgment and award dated 26/2/2019 passed by the second additional civil judge and 28th ACMM Court of Small Causes and MACT in MAC 1751 of 2017 is modified. The appellant claimant is held entitled for total compensation of rupees 5,92,858 as against 4,79,218 awarded by the tribunal. The enhanced compensation of rupees 1,13,640 shall carry interest at the rate of 6% from the date of petition. The respondent number 1 insurer is respondent number 2 insurer is directed to deposit the enhanced compensation with interest accrued thereon within 6 weeks. Yes. The other side.
They entered into a joint memo and a sum of 1,65,000. It has been closed.
No, I'm not concerned about withdrawal. Withdrawal can be happen. Question of returning the deposit amount. There is no agreement. There is no compromise to who should be entitled for that amount. You have mentioned in your memo, not compromise memo. If there is a compromise, the memo should be that the amount in deposit in MFS so and so shall be returned to a particular party. Things would have been different. Adilla nange. Statutory deposit ಅದಕ್ಕೆ ನಾನು ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದ್ರಿ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಡಿಪಾಸಿಟ್ ಬಗ್ಗೆ ನಿಮ್ಮಲ್ಲಿ ಏನಾಯ್ತು ಗೊತ್ತಿಲ್ಲ ನಮಗೆ just ask him to come or get a endorsement that it may be released in your favor. Dispose ಮಾಡಕ್ಕೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ. Releasing the statutory deposit is an issue. You can ask him to make an endorsement. I cannot change it. Orders ki change ಮಾಡಕ್ಕೆ ಬರಲ್ಲ final hearing ಇದ್ದಾಗ. ಅಲ್ಲಲ್ಲ whether it makes whether final hearing or orders, it makes no difference. No difference. I want or else you move an application for releasing that amount and get his NOC. That's all.
I'll file an application.
On the party, the NOC or council or the NOC new act, it statute deposit may be permitted to be withdrawn by the appellant only and tandubitre mugidoytu. Namge ಏನು problem illa. That is the only issue. Withdrawal is not an issue because you are appellant, you want to withdraw. We are not in any way concerned. ಅದಕ್ಕೆ whether it is including this amount or that
Excluding this amount.
ಅದು ನಿಮ್ ಅಲ್ಲಿ ಮೆಮೊ ಒಳಗ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ ಅದು. That is the issue. ನೀವು ಅದನ್ನ ಬರ್ದಿದ್ರೆ ಇಷ್ಟು ಪ್ರಾಬ್ಲಮ್ ಹಾಕಿರ್ಲಿಲ್ಲ. ಅದನ್ನ ನೀವು ಅವ್ರ ಒಂದು ಮೆಮೊ ಹಾಕಿ ಒಂದು ಅವ್ರದನ್ನು NOC ತಗೊಂಡ್ಬಿಟ್ರೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡ್ಬಿಟ್ರೆ ವಿಲ್ ಪಾಸ್. ಎಂದ ನೀವು ಯಾವೊಂದು ಹಾಕ್ತೀರಿ ಹೇಳ್ರಿ ಮೆಮೊ? ಅಷ್ಟು 2 weeks ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಹಾಕಿ. ಬುಧವಾರ 10 ದಿವಸ ಟ್ಯೂಸ್ಡೇ. ಅಲ್ಲ ಪಾಕೆಟ್ ಆಗಿದ್ದ ನಡೆದದ.
Continuation matter.
Yes.
My lord, as far as the question pertaining to the description of the property, my lord, belonging to the respondent number 1, and the exact place where the
One thing is certain, property belongs to respondent number 1, but you are not working under respondent number 1. You are working under respondent number 2 as per your own claim. So in what way respondent number 1 is responsible?
respondent number 2 is a timber contractor, my lord.
See, he may be timber contractor, but you are not an employee of respondent number 1.
Direct employee, my lord, but
He has outsourced that contract to one agency, that is respondent number 2. You are working under respondent number 2 as per your contention. They dispute it, let it be. So there is no relationship of employee and employer between you and the respondent number 1.
In paragraph 6 of my claim petition, I state that the applicant was employed by the opponents 1 and 2. Hence, both the opponents individually and severally liable.
That was your contention. Have you produced any material to show that you are also employed by respondent number 1? When they are two independent entities, how can you be employed by both of them?
My depositions have not specifically stated, my lord, that I have been employed by respondent number 1. But my lord, it has been, can be drawn from my inference may be drawn, my lord, that he is an indirect employee, my lord, working under.
See, he is only outsourced the contract. You are employee of, according to your specific contention, you are employed and respondent number 2 has entrusted the said work of cutting the timber in the estate of respondent number 1. So respondent number 1 is no way concerned with your employment. However, your employment, according to you, your employment is respondent number 2, and you are working in the estate of respondent number 1.
To that extent, my lord, I am seeking compensation from respondent number 1 as
How?
well. My lord, because that estate, the premise belongs to respondent number 1.
Where exactly has it happened?
My lord, your lordship may kindly peruse in page 4 of the cross-examination of PW3. Middle portion, my lord. Your lordship got it, my lord. In page 4 of PW3 cross-examination, my lord, 25 ಎಕರೆ ಕಾಫಿ 25 ಎಕರೆ ತೋಟ ಕಾಫಿ, ಕಾಳು ಮೆಣಸು ಮತ್ತು ಅಡಿಕೆ ತೋಟವಾಗಿತ್ತು. ಅದರಲ್ಲಿ ಕಾಫಿ ತೋಟದ ಮಧ್ಯೆ ಅಡಿಕೆ ಹಾಕಿದ್ದರು. ಒಂದನೇ ಪ್ರತಿವಾದಿಯವರಿಗೆ 25 ಎಕರೆ ತೋಟವೇ ಇಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯವರಿಗೆ ಕಾಫಿ ತೋಟ ಇಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಾನು ಅಡಿಕೆ ತೋಟ ನೋಡಿರುತ್ತೇನೆ. ಅಡಿಕೆ ತೋಟದಲ್ಲಿ 4 ಅಥವಾ 5 ಅಂತರಕ್ಕೆ ಮರಗಳನ್ನು ಬೆಳೆದಿರುತ್ತಾರೆ. My lord, this deposition, my lord, is in support of the admission made by the PW.
I am asking you, what is the place of extent? Place of extent is particularly this extent. High Court is not in a place of extent. Where exactly?
Middle of the 25 acres land.
Where is it?
In the admission it states, my lord, ಅದರಲ್ಲಿ ಕಾಫಿ ತೋಟದ ಮಧ್ಯೆ ಅಡಿಕೆ ಹಾಕಿದ್ದರು. That is a statement, my lord. It is in support. It is corroborating.
Try to understand. Don't try to twist it. Simple question is, where exactly the extent is occurred?
That, my lord, PW2 in this cross-examination has stated. That is, he has pulled from the Adike Tota, Adike Mara.
See, what is the extent of the Arekanat area?
That, yes, lord.
See, you have approached the court, you do not know anything. What is the extent of area? Where exactly the extent has occurred?
As per the PW3, it is a scattered plantation. Where, my lord, is 25 acres, all coffee plantation and tea and Arekanat trees and so on, my lord. It is very difficult for PW3 as well, my lord.
You claim to be worker. You claim that you have suffered grievous injury, and you say that you do not know exact space.
It's a timber coolie, my lord. Exact extent.
See, you have involved in cutting the timber itself.
Further, my lord, cross-examination in page 6, first 2 sentences. Lord, ನನಗೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಯವರು ಸುಮಾರು 25 ವರ್ಷದಿಂದ ಪರಿಚಯವಿರುತ್ತದೆ. ಎರಡನೇ ಪ್ರತಿವಾದಿ ಬಳಿ ನಾನು ಸುಮಾರು 9 ವರ್ಷಗಳಿಂದ ಕೆಲಸ ಮಾಡಿರುತ್ತೇನೆ. ನಾನು ಎರಡನೇ ಪ್ರತಿವಾದಿ ಬಳಿ ಕೆಲಸ ಮಾಡಿದ ಬಗ್ಗೆ ನನ್ನ ಬಳಿ ಯಾವುದೇ ದಾಖಲಾತಿಗಳು ಇರುವುದಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ದಾಖಲೆಗಳು ಎರಡನೇ ಪ್ರತಿವಾದಿಯವರ ಬಳಿಯೇ ಇರುತ್ತದೆ ಎಂದು ನುಡಿದರು. ದಾಖಲೆಗಳು ಹಾಜರಿ ಪುಸ್ತಕ, ವೇತನ ಪಾವತಿ ಪುಸ್ತಕ ಆಗಿರುತ್ತದೆ. My lord, further there is no suggestion from the side of the respondent counsel, my lord, to disprove this admission and disprove the contention and the submission made by the PW. And hence it has remained uncorroborated, my lord, and also they have not had any evidence to disprove this admission. The documents are.
Have you moved any application for summoning the documents?
We have not made any application seeking direction against the respondents to surrender the documents. However, my lord, the lordship permit at this stage.
See, you cannot go on improving your case before in an appellate court. What you are supposed to do, that's all I am asking you.
That application was not moved. That is a fact. But this admission has remained uncorroborated, and they have not led any evidence. Further, my lord, BW one, my lord, evidence, that is doctor medical officer evidence.
What is the admission you want to rely?
That is the deposition that the documents are still with the.
ಯಾವ್ದು admission ನನಗೆ ಅರ್ಥ ಆಗೋಂಗ್ ಹೇಳಿ. Which admission you want to harm? Because he completely denied your employment in the entire cross examination.
My lord, the document, custody of the documents has not been denied specifically by the respondent counsels. That is the only part which the appellant wants to rely on. And also the deposition of the medical officer.
When the alleged accident has occurred, according to you? According to you, when the accident has occurred?
It happened on 8/11/2005.
8/11/2005. You have admitted a suggestion that in 2005, he was working as a coolie. ಎರಡನೇ ಪ್ರತಿವಾದಿಗಳು 2005ರಲ್ಲಿ ಕೂಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿ.
2005 ನಲ್ಲಿ ಕೂಲಿ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿ. ಈಗ ಸಾಹುಕಾರರು ಆಗಿರುತ್ತಾರೆ.
ಈ ಸಾಹುಕಾರಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಹ್ಯಾಸ್ ಅಕರ್ಡ್ ಇನ್ 2005. ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಕೇಳಿದ್ದು.
2005 that is 8/11 in November, my lord, accident occurred. Prior to that, my lord, he was.
ನೀವು ಎಲಿಸಿಟ್ ನೀವು ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರಿ, ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬೇಕಾಗಿದ್ದು ನೀವು. ಈಗ ಶ್ರೀಮಂತ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತೀರಾ. That is in 2013 your evidence is recorded. 2013 ಒಳಗೆ ಅವನು ಶ್ರೀಮಂತ ಆಗಿದ್ದಾನೆ. 2005 ಒಳಗೆ ಕೂಲಿ ಇದ್ದ.
That is my humble submission, my lord, that respondents did not lead any evidence.
Sir, is it necessary to lead any evidence? Always. They can disprove your case by way of cross examination only.
However, in this case, my lord, there are certain points and there are certain.
What are those points? ಅದನ್ನ highlight ಮಾಡ್ಬಿಟ್ಟು ಉಳಿದಿದ್ದೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ ನೀವು.
The main point, my lord, is the custody of the documents.
That you are not sought summons, and it doesn't. There is no suggestion by you that your name appears there. And on the contrary, you admit that in 2005 he himself was a coolie.
There is a PW3 is admission that is a co-worker. There is admission, my lord, he is a coolie, my lord, timber coolie. However, he was promoted as a timber contractor in the 2005 itself.
He cannot. A coolie worker cannot be promoted. He will indulge in contracting. He question of promotion doesn't arise. And for Timber contract, what is the mandatory requirement? Have you obtained, whether he has obtained permission? License? If there are documents, then he should be licensed timber contractor. ಏನೇನು ಇಲ್ಲ.
Ask one chance may be given, my lord, to the claimant.
ಎದಕ್ಕೆ
Actually,
ಏನಂತ ರಿಮಾಂಡ್ ಮಾಡಿಲ್ರಿ, ಬರೇ ಇಲ್ಲಿ ಬಂದ ರಿಮಾಂಡೆಡ್ ಅನ್ಕೋತ ಕೂತ್ರೆ. ಈಗ 2000 ಯಾವ ವರ್ಷದ್ದು 2006 ಪೆಟಿಷನ್, we are in 2022. 16 years. Sir, 2006 ರಿಮಾಂಡ್ ಆಗಿ ಮತ್ತೆ ರೀನಂಬರ್ ಆಗಿದ್ದದು. ಒರಿಜಿನಲ್ ಪೆಟಿಷನ್ ಇಸ್ ಅಪ್ 2006. ಈಗಾಗಲೇ ಒಂದು ರಿಮಾಂಡ್ ಆಗಿ ರಿಟರ್ನ್ ಬಂದಿದೆ. ಅಗೇನ್ ಯು ವಾಂಟ್ ದಿ ರಿಮಾಂಡ್. ಈಗ ಮತ್ತೆ ಒಂದು ರಿಮಾಂಡ್ ಎದಕ್ ಮಾಡಿದ್ರು? ವೈ ದಿ ಮ್ಯಾಟರ್ ವಾಸ್ ರಿಮಾಂಡೆಡ್ ಅರ್ಲಿಯರ್? ಈಗಲ್ಲ ನಿಮ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಅವ್ರ ಕಡೆ ನೋಡೋದೇನು ಅರ್ಥ? ಸಿ ನಾನು ಸಿಂಪಲ್ ಕೇಳಿದ್ದು, ರಿಮಾಂಡ್ ಎದಕ್ಕಾಯ್ತು?
Paragraph 1 of the judgment clearly states that.
ನಾನು ನಿಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಅಲ್ಲಿ ಓದ್ಕೊಳ್ಳೋದಿದ್ರೆ ಐ ವಿಲ್ ರೀಡ್ ಇಟ್. ಯು ದೇರ್ ಇಸ್ ನೋ ನೀಡ್ ಫಾರ್ ಯುವರ್ ಅಸಿಸ್ಟೆನ್ಸ್. ಐ ಆಮ್ ವೆರಿ ಸಾರಿ. ವಾಟ್ ಪರ್ಪಸ್ ಇಟ್ ವಾಸ್ ರಿಮಾಂಡೆಡ್? ಇಷ್ಟೇ ಸಿಂಪಲ್ ಕೇಳಿದೀನಿ. ಪ್ಯಾರಾ 1 ರೀಡ್ ಸೋ ಅಂಡ್ ಸೋ. ಅದನ್ನ ಹೇಳಿದ್ರೆ ನಿಮ್ನೆ ಅದಕ್ಕೆ ಕೇಳ್ಬೇಕು ನಾನು. ವಾಟ್ ಅಸಿಸ್ಟೆನ್ಸ್ ಯು ಆರ್ ರೆಂಡರಿಂಗ್? ಫಾರ್ ವಾಟ್ ಪರ್ಪಸ್ ಇಟ್ ಇಸ್ ರಿಮಾಂಡೆಡ್? ನೋಡೇ ಇಲ್ಲ ನೀವು. And you want second remand again. 16 years ಆಯ್ತು ಇಲ್ಲೇ ಹೊಡೆದಾಡ್ತಾ ಇದ್ದಾರೆ. ನೋಡ್ಕೊಂಡು ಬನ್ನಿ ಸ್ವಾಮಿ. Fifth.
I seek apologies for the trouble.
ಏನ್ ಅಪಾಲಜಿ ಕೇಳಿದ್ರಿ? ಏನು ಇವ್ರ ಅಸಿಸ್ಟೆನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇನ್ ಆಗೋದು? ಯು ಮಸ್ಟ್ ಬಿ ನೋಯಿಂಗ್ ಫಾರ್ ವಾಟ್ ಪರ್ಪಸ್ ಇಟ್ ಇಸ್ ರಿಮಾಂಡೆಡ್, ವಾಟ್ ಆರ್ ದಿ ಗ್ರೌಂಡ್ಸ್ ಅರ್ಜ್ಡ್, why this court has remanded, what was the directions have been issued, and what is the subsequent finding of the tribunal. ಅದನ್ನ ಬಿಟ್ಟು ಎಲ್ಲ ಹೇಳ್ತೀವಿ ರಿಮಾಂಡೆಡ್. Why it is remanded? It is referred in para number 1. ಏನ್ ಬರ್ದಿದಾರಲ್ಲಿ? ಏನೇನ್ ಕಾರಣನೇ ಹೇಳಿಲ್ಲ. why it is remanded? ಕೋರ್ಟ್ನವರು ಅದನ್ನ ಸರ್ಚ್ ಮಾಡಬೇಕು. and you want second remand. Next.
35, one of the course HV. Number 35, one of the course HV.
No representation by either of the parties. Based after 2 weeks.
Number 36, Mahesh. Number 36, Mahesh. Number 38, Mr. Jabali. For R2.
ಯಾವ್ದು ಏನ್ ಕೇಸ್ ಇದು ಡೆತ್ ಡ್ಯಾಮೇಜ್ ಟು ದಿ ವೆಹಿಕಲ್. ಈಗೂ ಇದಾರ ಬರ್ತಾ ಇಲ್ಲ ಅವರು. ವರ್ಚುವಲ್ ಇದೀನಿ ಅಂತ ಹೇಳಿ ತೋರ್ಸಕಷ್ಟೆ, ಆನ್ ಮಾಡಿ ಹೋಗ್ಬಿಡು. ಹಾ ಹೇಳಿ ನೀವು. ಇಫ್ ಇಟ್ ಡಸಂಟ್ ಆರ್ಗ್ಯೂ ಐ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಆಫ್. ಐಡ್ಲಿಂಗ್ ದಟ್ ಈಸ್ ಕರೆಕ್ಟ್. ಹಿಯರಿಂಗ್ ಆಗಿದೆ ಇದು. ಹಾ ಹಾ ಐಡ್ಲಿಂಗ್ ಏನಿದೆ ಎವಿಡೆನ್ಸ್? ಇದು
carried on for 5 days. Totally about 9 days.
ಹೌದು 5 days ಗ್ಯಾರೇಜ್ ದಾಗ ಇದ್ದಾಗ 9 days ಐಡ್ಲಿಂಗ್ ಚಾರ್ಜಸ್ ಹೇಗೆ ಕೇಳ್ತೀರಿ? ಒಂದೇ ಪ್ರಶ್ನೆ. ಅಲ್ಲ ನೀವು ಅದನ್ನ ಉಡ್ರಾ ಪೊಸಿಷನ್ ತಗೊಳಕ್ ಡಿಲೇ ಮಾಡಿದ್ರೆ ಅಲ್ಲ ರೀ ಕರೆಕ್ಟ್.
5 days ಆದ್ರೂ it was in the garage.
This is a Volvo bus. What is the damage? Only rear portion indicator on the damage agade, corner body damage agade. Corner body and indicator. It requires 5 days.
Job card.
ಅಲ್ಲ P8 ಜಾಬ್ ಕಾರ್ಡ್ ಅದ ಟೋಟಲ್ ವರ್ಕಿಂಗ್ ವ್ಯಾಲ್ಯೂ ಹೇಳುತ್ತೆ. ಎಷ್ಟು ಮಂದಿನ ಎಂಗೇಜ್ ಮಾಡಿದ್ರಿ, ಸೈಮಲ್ಟೇನಿಯಸ್ಲಿ ಎಷ್ಟು ಮಂದಿ ವರ್ಕ್ ಮಾಡ್ಬೇಕು? ಕರೆಕ್ಟ್ ಸರ್. ಒಬ್ರು ಪೇಂಟರ್ಗೆ ಟೈಮ್ ತಗೊಳ್ಳೋದದ, ಟಿಂಕರಿಂಗ್ ಆದ್ಮೇಲೆ ಪೇಂಟಿಂಗ್ ಬರುತ್ತೆ, ಫಸ್ಟ್ ರಿಪೇರಿ ಬರುತ್ತೆ, ರಿಪೇರಿ ಆದ್ಮೇಲೆ ಟಿಂಕರಿಂಗ್ ಬರುತ್ತೆ, ಆಮೇಲೆ ಪೇಂಟಿಂಗ್ ಬರುತ್ತೆ. ಕರೆಕ್ಟಾ? ರಿಪೇರಿಗೆ ಎಷ್ಟು ದಿನ ಬೇಕು? ಎಲ್ಲಿದೆ? ಅಲ್ಲ ಅದನ್ನ ನೀವು ಬರ್ಕೊಂಡಿದ್ದು ನಿಮ್ದೇ ವರ್ಕ್ಶಾಪ್ ನಿಮ್ಮವ್ರ. ಸಿ ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಈಸ್ ಯು ಅಟೆಂಡ್ ಡಿಫರೆಂಟ್ ವೆಹಿಕಲ್ಸ್ ಅಟ್ ಎ ಡಿಫರೆಂಟ್ ಟೈಮ್. ಇಲ್ಲಿ ಒಬ್ಬರನ್ನ ಡೆಪೋಟ್ ಮಾಡ್ತೀರಿ, ಅವಾಗ ಇಲ್ಲಿ ಒಂದು ಐಟಮ್ ಬರೋದು ಲೇಟ್ ಆಯ್ತಾ ಬೇರೆ ವರ್ಕ್ ಅಟೆಂಡ್ ಆಗ್ತಾನೆ. ಅವರ್ ವೈಸ್ ಹೇಳಿದ್ರಿ. ಸೊ ವೆದರ್ ದೇ ಆರ್ ರಿಕ್ವೈರ್ಡ್ ಟು ವರ್ಕ್ ಆಲ್ ಅಲಾಂಗ್ ಸಪರೇಟ್ಲಿ.
Tinkering and painting is different. The remaining note, what you want.
ಇದು BS ಅಂದ್ರೆ ಏನು? ಪೇಂಟಿಂಗ್ ಆಫ್ ಎ ಕಾರ್ನರ್ ಆಫ್ ಬಸ್ 16 hours ಬೇಕಾಗತ್ತ? ನಾನು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇರೋದು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ರಿ. ಎಲ್ಲಕ್ಕೂ ಸ್ಟ್ಯಾಂಡರ್ಡ್ 16 hours ತೋರಿಸಿದ್ದಾರೆ ಅವರು. ಎಲ್ಲದಕ್ಕೂ ಸ್ಟ್ಯಾಂಡರ್ಡ್ 16 hours. ಅಂದ್ರೆ 16 hours ಎಲ್ಲ ಕೆಲಸ ಮುಗ್ದದಂಗ ಪ್ರಿಸಂಪ್ಷನ್ 1 day ತಗೋಬಹುದು. ನಿಮ್ ಇದ್ರ ಪ್ರಕಾರ ಇಲ್ಲ ಪೇಂಟಿಂಗ್ 16 ದಿನ, ಟಿಂಕರಿಂಗ್ 16 ಗಂಟೆ, ಪೇಂಟಿಂಗ್ 16 ಗಂಟೆ, ಅದು ಒಂದು ಕಾರ್ನರ್. ಈಗಂತೂ ಎಲ್ಲ ಕಂಪ್ಯೂಟರೈಸ್ ಪೇಂಟಿಂಗ್. ಇನ್ 1 or 2 hours ಫಿನಿಶ್. ಮುಂದ ಅದು ಆ ಹೀಟ್ ಚೇಂಬರ್ ಒಳಗೆ ಮಾಡ್ತಾರ. ಹಿಂಗಾಗಿ ಡ್ರೈ ಅಪ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಎಲ್ಲ ಹೀಟ್ ಚೇಂಬರ್ ಒಳಗೆ ಎವ್ರಿಥಿಂಗ್ ರೆಡಿ ಆಗಿ ಬಂದ್ಬಿಡ್ತದ ಅದು.
Spray painting. Spray painting won't take more than 5 minutes.
ಎಲ್ಲ 16 ಗಂಟೆಗೆ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದೀರಿ. ಅಲ್ಲ, ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಬಾಡಿ ವರ್ಕಿಗೆ ಟೈಮ್ ತಗೊಳ್ತದ, ಬಾಡಿ ವರ್ಕಿಗೆ ಟೈಮ್ ತಗೊಳ್ತದ. ಇಲೆಕ್ಟ್ರಿಸಿಟಿನೂ ಬಹಳ ಎಕ್ಸ್ಟ್ರಾ ಟೈಮ್ ತಗೊಳ್ಳಲ್ಲ, ಯಾಕಂದ್ರೆ ಎಲ್ಲ ರೆಡಿ ಇರ್ತದೆ. ಕನೆಕ್ಟಿವಿಟಿ ಯಾಕಂದ್ರೆ ನೀವು ಅವು ಹೇಗಿದೆ ಅಂದ್ರ ಪಾಟ್ ಇಂಡಿಕೇಟರ್ ಫಿಕ್ಸ್ ಮಾಡಿಬಿಡ್ತೀರಿ. ರಿಪೇರಿ ಇಲ್ಲ, ಈಗ ಯೂಸ್ ಅಂಡ್ ಥ್ರೋ. ಬಾಡಿ ರಿಪೇರಿ ಆ ಏರಿಯಾದ ಅಷ್ಟೇ ರಿಪೇರಿ ಅಷ್ಟೇ, ಉಳ್ಕಿದೆಲ್ಲ ರಿಪ್ಲೇಸ್ ಮಾಡ್ತೀರಿ. ಅದು ರಿಪ್ಲೇಸ್ಮೆಂಟ್ ಮಾಡಿದಾಗ ಬರೀ ಇನ್ಸರ್ಷನ್ ಪಿನ್, ಬೇರೆ ಏನು ಕೆಲಸ ಇರೋದಿಲ್ಲ. ಕನೆಕ್ಟಿವಿಟಿ, ಸ್ಪೇರ್ ಪಾರ್ಟ್ಸ್ 1 ತಿಂಗಳು ಬರಲ್ಲ ನಿಮಗೆ ಓಲೋ ಕಂಪ್ನಿ ಕಡೆಯಿಂದ. ಅಲ್ಲ, 1 ತಿಂಗಳ ತನಕ ಬರಲ್ಲ, ಅದಕ್ಕೆ 1 ತಿಂಗಳು. ಅಂಡ್ ವಾಟ್ ಅಬೌಟ್ ಸ್ಪೇರ್ ಬಸ್? ವೈ ಯು ಆರ್ ನಾಟ್ ಕೆಪ್ಟ್ ಎ ಸ್ಪೇರ್ ಬಸ್? What is the mandate of the law? A spare bus always should be available. Agar it is a mechanism, ಅದು ಯಾವಾಗ ಫೇಲ್ ಆಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ. ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಸ್ಪೇರ್ ಬಸ್ಸು ಎನ್ ರೂಟ್ ಓಡಿಸ್ತಾ ಇರ್ತೀರಿ. ಸ್ಪೇರ್ ಬಸ್ಸು ಎನ್ ರೂಟ್ ಓಡಿಸ್ತೀರಾ? ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಸ್ ಸೆಕೆಂಡರಿ. ಸ್ಪೇರ್ ಬಸ್ ಎಲ್ಲಿದೆ ನನಗೆ ಹೇಳಿ. Because the tribunal has considered that aspect also. ಯಾಕಂದ್ರೆ ರೆಗ್ಯುಲರ್ಲಿ ರಿಪ್ಲೇಸ್ಮೆಂಟ್ ಆಗ್ತಾ ಇರುತ್ತೆ, ಸರ್ವಿಸ್ ಆಗುತ್ತೆ. ಒಂದ್ ಯಾವ್ದೋ ವೆಹಿಕಲ್ ಬ್ರೇಕ್ ಆಗುತ್ತೆ, ಅದ್ರ ಸಲುವಾಗಿ. ಕರೆಕ್ಟ್ ಸರ್, ಅದಕ್ಕೆ ಹೇಳಿದ್ದೆ ನಾನು. ವೆರ್ ಇಸ್ ಯುವರ್ ಸ್ಪೇರ್ ಬಸ್? ಯಾವ್ದು ಯೂಸ್ ಮಾಡಿದ್ರಿ ಅದಕ್ಕೆ ರಿಪ್ಲೇಸ್ಮೆಂಟ್? ಬಿಕಾಸ್ ಯು ಆರ್ ಕ್ಲೇಮಿಂಗ್ ಐಡ್ಲಿಂಗ್ ಚಾರ್ಜಸ್. ಐಡ್ಲಿಂಗ್ ಚಾರ್ಜಸ್ ಅಂದ್ರೆ ಸ್ಪೇರ್ ಬಸ್ ಇನ್ ಪ್ಲೇಸ್ ಆಫ್ ಸ್ಪೇರ್ ಬಸ್ ಅಲ್ಲಿ ಬೇರೆ ಬಸ್ ಓಡಿಸಿರಕ್ಕೆ ಬೇಕು. ಮತ್ತೆ ಅದಕ್ಕೆ ವಾಟ್ ಇಸ್ 72 ಹೇಳುತ್ತೆ. ಸ್ಪೆಷಲ್ ಅಕೇಶನ್ ಏನು ಇಂತಾವ್ ಏನ್ರಿ ಬ್ರೇಕ್ ಡೌನ್ ಆದ್ರೆ
I'm in the other court, my lord. I'll come back. Kindly be passed.
Rule 72 ಅಲ್ಲ. Section 72 deals with permits. ಏನ್ ಹೇಳ್ತದೆ? vehicles to be kept as a reserve by the holder of the permit to maintain operation. That is breakdown ಆಗ್ತಾ ಇರುತ್ತೆ ಅನ್ನೋದು ಉದ್ದೇಶ. And to provide special circumstances, ಏನ್ರಿ ಕಾಂಟಿಂಜೆನ್ಸಿ ಬಂತಂದ್ರೆ ಇಲ್ಲಿ ಏನ್ ಕಾಂಟಿಂಜೆನ್ಸಿ ಇಲ್ಲ, ಸ್ಪೆಷಲ್ ಸರ್ವಿಸ್. ಅಡಿಷನಲ್ ಟ್ರಪ್ ಸ್ಪೆಷಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಅಲ್ಲದು.
It is covered by the ruling of this court, my lord, in MFA.
ಕೊಡಿ ವಕೀಲ್ರ, please don't quote it. It is not the duty of court to go and search it. You should tender it.
2009 ACJ page.
ಕೊಡಿ ಸರ್, ಕೊಡಿ. ನೋಡ್ತೀವಿ, will definitely will consider it. Place it.
It's available in the court.
Sir, every time in the available ittandre there is no need, sir. It is your duty to, when you are relying, you should place it. It is pertaining to temporary permits, sir. ಏನಿದೆ special occasions, you know. In case of temporary permit, special occasion. ಏನ್ ಹೇಳಿ? Sir, that was regarding when a temporary permit is issued. Then, sir, see, spare vehicle is required to be maintained mandatorily. You have not done it. And you want this vehicle idling agate anta heli idarda idling charges ಕೊಡ್ತಾ ಇದ್ದೀರಿ. Sir, mandate says it should be idle. ನೀವು ಯಾರು ಇಡಲ್ಲ ಬೇಡ. What law says? Because under legal presumption you are coming to claim for idling charges. ನಾವು ಇಡೋಲ್ಲ, ನಾವು ಸಿಕ್ಕಾಪಟ್ಟೆ ರನ್ ಮಾಡ್ತೀವತ್ತಂದ್ರೆ what is the special occasion? Where is the evidence? Sir, ಅದು ಸರ್ ಎಲ್ಲ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರಿ. ಆಕ್ಟ್ ಒಳಗೆ ಎಲ್ಲಿದೆ ಹೇಳ್ರಿ? ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಳಕ್ಕೆ ಹೋಗ್ರಿ, ನಿಮ್ಗೆ ಬೇಡ ಅಂತಾರ. ಅದ್ರ ನಾಟ್ ಓನ್ಲಿ ಸ್ಪೇರ್ ಬೇಸಿಸ್, ಓನ್ಲಿ ನಿಮ್ ಫಿಟ್ನೆಸ್ ಅಂತ ಅಲ್ಲ. ವಾಟ್ ಈಸ್ ದಿ ರೂಲ್ ಸೇಸ್ ಇಟ್? ಏನ್ ಹೇಳುತ್ತೆ ನೋಡಿ ಸ್ವಲ್ಪ. ನಾಟ್ ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಲುವಾಗಿ ಅಷ್ಟ ಅಲ್ಲ, ಸ್ಪೆಷಲ್ ಒಕೇಶನ್ಸ್ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇನ್ನೊಂದು ವರ್ಡ್ ಅದ, ಅದನ್ನ ಹೇಳಕ್ ರೆಡಿ ಇಲ್ಲ ನೀವು. To maintain the standard operation and special circumstances. Special circumstances, so ನೀವು ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹೋಗ್ತೀರಿ, ಸ್ಪೆಷಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಅಲ್ಲ ಅದು. Then you should prove it. See, ನೀವೇ ಹೇಳಿ ಸರ್, ನೀವು ಒಂದು ವೆಹಿಕಲ್ ಮೇಂಟೈನ್ ಮಾಡೋದಿಲ್ಲ, ಎಕ್ಸ್ಟ್ರಾ ಇದ್ದ ಎಲ್ಲ ವೆಹಿಕಲ್ ನ ರೋಡ್ ಮ್ಯಾಗ ಓಡಿಸ್ತೀರಾ. ಒಂದು ವೆಹಿಕಲ್ ಬ್ರೇಕ್ ಡೌನ್ ಆಯ್ತಂದ್ರೆ ಆಲ್ಟರ್ನೇಟಿವ್ ವೆಹಿಕಲ್ ನಿಮ್ಮಲ್ಲಿ ಬರಲ್ಲ. ಆಸ್ ಪರ್ ರೂಲ್ ಬ್ರೇಕ್ ಡೌನ್ ಆದ್ರೆ ದಿಸ್ ಆಸ್ ಎ ಸ್ಪೇರ್ ಇರೋದು ಎದಕ್ಕೆ? ಬ್ರೇಕ್ ಡೌನ್ ಯಾವ್ದಾರ ವೆಹಿಕಲ್ ಆತಂದ್ರೆ ಇಟ್ ಶುಡ್ ಬಿ ಯೂಸ್ ಅನ್ನೋ ಉದ್ದೇಶಕ. ಬ್ರೇಕ್ ಡೌನ್ ಅಂತ ಹೇಳಿಲ್ಲ, ಅವ್ರ ಸ್ಪೇರ್ ಎದಕ್ಕೆ ಇಟ್ಟಾರೆ? ಹೇಳಿ ಕೊಡಿ, ನಿಮ್ದೇನು ಏನಿದೆ, ಎಲ್ಲಿದೆ? ಆಂಧ್ರ ಪ್ರದೇಶ ಹೈಕೋರ್ಟ್ದು
by relying on the Andhra Pradesh High Court, no power to award it.
ಏನದ ಇದ್ರಲ್ಲಿ? ಅದು ಒಂದಂತರೂ ನಿಮ್ ವಿರುದ್ಧ ಅದ ಡೈರೆಕ್ಟ್ ಆಂಧ್ರ ಪ್ರದೇಶದ್ದು. ಕರೆಕ್ಟ್. ಇದು ನಮ್ಮ ಹೈಕೋರ್ಟ್ದು ಐಡ್ಲಿಂಗ್ ಚಾರ್ಜಸ್ ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಫ್ಲೂಯಿಡ್ ಸ್ಟೇಟ್ ಅಂತ ಹೇಳಿ ಅಬ್ಸರ್ವೇಷನ್ ಅದ. ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ? ಹಾ, ಎಲ್ಲಿದೆ ರೀ ಅನ್ರಿಪೋರ್ಟೆಡ್? ಅಲ್ಲ, ಅನ್ರಿಪೋರ್ಟೆಡ್ ಈಸ್ ಅದೇ ನೀವು ಏನು ಇಲ್ಲ ಆನಂದ ಸಾಹೇಬ್ರದ್ದು ಅದು ರಿಪೋರ್ಟೆಡ್ ಇದೆ. ಇದು ರಾಮಾಜಿ ಸಾಹೇಬ್ರದ್ದು, ರಾಮಕೃಷ್ಣ ಅವ್ರದ್ದು, ಇನ್ನೊಂದು ಆಂಧ್ರ ಪ್ರದೇಶ ಹೈಕೋರ್ಟ್ದು, ಇನ್ನೊಂದು ಆನಂದ ಸಾಹೇಬ್ರದ್ದು 9718 of 2012. ಮೂರೇ ಇದಾವ. ನೀವು ಕೊಟ್ಟಿದ್ದ ಮೂರು ಕೋಟ್ ಮಾಡ್ತಾ ಇದೀವಿ ನಾವು. ಏನಿದೆ ಇದರಲ್ಲಿ? ಏನಿದೆ ಇದರಲ್ಲಿ ಬಸ್ ವಾಸ್ 5 months, ನಿಯರ್ಲಿ 6 months ಡ್ಯಾಮೇಜ್ ಆಗಿತ್ತು. ದೇ ಆರ್ ನಾಟ್ ಅಕ್ಸೆಪ್ಟೆಡ್. ಆ ಪೀರಿಯಡ್ ದಾಗ ನೀವು ಬೇರೆ ಬಸ್ ಓಡಿಸಿದ್ರಿ, ಓಕೆ, ಬಟ್ ದಿ ಸೆಕ್ಷನ್ 72 ವಾಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಇನ್ ದಿಸ್ ಅಪೀಲ್. ಮತ್ತೆ ಅದಕ್ಕೆ 5 months ಇತ್ತು. That is a serious thing. Nature of the injury, the damage was considerable.
Did not award any compensation for ability only on the ground that is of damage that some other person by same.
Correct, sir. Sir, same will do. Spare bus shall not run for months together. That is also a settled law. The spare bus emergency ಗೆ ಯಾಗ ಸ್ಪೇರ್ ಬಸ್ ಒಂದು ಬಸ್ಸಿಗೆ ಇನ್ನೊಂದು ಸ್ಪೇರ್ ಇರಲ್ಲ. ಸ್ಪೇರ್ ಬಸ್ ವಿಲ್ ಬಿ ಟೋಟಲ್ ಇದಕ್ಕೆ ಸ್ಪೇರ್ ಬಸ್ ಇಟ್ಟಿರ್ತೀರಿ ನೀವು. ಕರೆಕ್ಟ್ ಸರ್. ಅಟ್ ದಿ ಸೇಮ್ ಟೈಮ್ ಯು ಶುಡ್ ಬಿ ರೀಸನೇಬಲ್ ಅಲ್ಲ. ನೀವು 16 ನಿಮ್ದು ಒಂದ್ ಹೇಳ್ತೀನಿ, ಟಿಂಕರ್ ಎಲ್ಲಾ 16 ಗಂಟೆ ಬೇಕು ನಿಮ್ಗೆ ಎಲ್ಲ. What is the reasonable according? You should have been fair enough.
For 5 days.
Yes, what you have to say, sir?
Lord, according to the Lord, the evidence produced by them, that is the 22,948 my lord has been given for repairing of the damages.
Yes.
They are not entitled for loss of revenue because under section 165 of the Motor Vehicles Act, it does not come under the purview of the same, only the damages to the vehicle.
But How you
Third-
overcome the division bench edition of this court?
Yes.
Justice Chidanand Ullar and Justice Jagannathan, MFA 4377 of 2001.
Blood in
Guiding
respect-
charges were given for 5 months.
Blood, that is, my lord, MFA 22,143 of 2009, my lord, His Lordship Justice Arvind Kumar has held.
Sir, I am talking about division bench edition. It is MFA 4377 of 2001, delivered on 20th July 2006.
There,
By-
KSRTC was not the, my lord, the party.
It was KSRTC versus United India Insurance Company. It is also KSRTC only.
Loss of revenue, my lord, is not included.
ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್, ಅದಕ್ಕೆ ನಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಎಡಿಷನ್.
May I read, my lord,
Taking the average earning at rupees 2,450 per day after giving allowance for the expenses like fuel, etc. If we work out the amount under particular head of 5 months, 23 days, it comes 4,23,850 idling charges. Said amount has to be awarded to the appellant in addition to what has been given by the tribunal on third.
My lord, there, my lord, spare bus, my lord, was not thing considered. Here, my lord, there is a provision for spare bus. There will be no loss of revenue for the KSRTC.
Even
When
then, even here, though there was a spare bus, or there was an argument regarding flying a bus, alternative bus, that was not accepted by the division bench.
But my respectful submission, my lord, it does not come under the purview of section 165.
Yes, but for 10 days you have claimed 9 days. ನಿಮ್ದು ಎಲ್ಲಾರ್ಗೂ 16 ದಿನ 16 ಗಂಟೆಗಳ ಕಾಲ ಕೊಡ್ಸಿದ್ದೀರ. ಎಲ್ಲರಿಗೂ 16 ಹೋಲ್ ಸೇಲ್. ಬಣ್ಣ ಹಚ್ಚಂಗೂ 16 ಗಂಟೆ, ರಿಪೇರಿ ಮಾಡಂಗೂ 16 ಗಂಟೆ, ಎಲೆಕ್ಷನ್ಗೂ 16 ಗಂಟೆ, ಟಿಂಕರ್ 16 ಗಂಟೆ, ಎಲ್ಲರಿಗೆ. ಅಂದ್ರೆ ಇಟ್ ಈಸ್ ನಾಟ್ ಟ್ರಸ್ಟ್ ವರ್ದಿ. If it varies, the technical body repairs ge excess torche, painting kadim torchidra reasonable irtittu, tinkering law kadim torchidra reasoning irtittu. But this is not acceptable. ಏನ್ ಮಾಡೋಣ? ನೀವು 15 ದಿನ ಇಟ್ಕೊಡ್ರಿ, ಬೇಡನಲ್ಲ. ನಾನು ನಿಮ್ಗೆ ಕೇಳಿದ್ದು ಇಷ್ಟು ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಇಂದ ನೀವು ಇಷ್ಟು ವರ್ಕ್ ಪೀರಿಯಡ್ ಆಗಿದ್ದಕ್ಕೆ ಏನ್ ತೋರಿಸ್ತಾ ಇದ್ದೀರಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಮತ್ತೆ ಅದನ್ನ ಹೇಳಿ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಲ್ಲ. ದಿಸ್ ವಾಸ್ ದಿ ವರ್ಕಿಂಗ್ ಅವರ್ಸ್ ರಿಕ್ವೈರ್ಡ್. ಅಲ್ರಿ, ಇದು ವರ್ಕಿಂಗ್ ಅವರ್ಸ್ ಕರೆಕ್ಟ್, ಆದ್ರೆ ಎಲ್ಲರಿಗೂ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ವರ್ಕಿಂಗ್ ಅವರ್ಸ್. ಅಂದ್ರೆ ಎಲ್ಲರೂ ಆಲ್ಮೋಸ್ಟ್ 2 ದಿನ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲರೂ 2 ದಿನ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ ಎಲ್ಲಾರ್ದು 2 ದಿನ ಒಳಗೆ ಎಲ್ಲಾರ್ದು ಮುಗಿಬೇಕಾಗಿದ್ರೆ ನಿಮ್ ಪ್ರಕಾರ. ಯಾಕಂದ್ರೆ 8 hours ಡ್ಯೂಟಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಎವ್ರಿಬಡಿ ಹ್ಯಾಸ್ ವರ್ಕ್ಡ್ ಆನ್ 2 days. ನೀವು 50 ಜನ ಮಾಡ್ಕೊಡ್ರಿ ಸರ, ನಾನು ಬೇಡ ಅಂತ ಹೇಳಲ್ಲ. ಪ್ರಶ್ನೆ ಪ್ರತಿಯೊಬ್ರು 8 ಗಂಟೆ ಕೆಲಸ, ಅಂದ್ರೆ 2 days ಎವ್ರಿಬಡಿ ವರ್ಕ್ಡ್. ಒಬ್ಬೊಬ್ಬರಿಗೆ ಒಂದೊಂದ್ ದಿವಸ ಅಂತ ಕೌಂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಹಾ, ಟೋಟಲ್ ಸೈಮಲ್ಟೇನಿಯಸ್ಲಿ ವರ್ಕ್ ಆಗುತ್ತೆ, ರಿಪೇರಿ ವರ್ಕ್ ಅದು. ನೋ ಸರ್. This appeal.
But my one last submission, Lord.
Please.
Evidence may kindly be looking, my lord, they have not produced any document to show as to the loss of revenue. Each bus will have, my lord, a log. They have not produced that.
Correct.
Yes. Therefore, my lord, they have not proved alleged loss of revenue. Even considering the, my lord, IME report, the damages revealed in the IME report would not take, my lord, so much, my lord, days to put it back in.
100%, sir. I'm not
Yes.
going to allow them 9 to 10 days because their logbook exhibit P8 itself disclosed that it was done mechanically. They put the date, but at least considering the nature of the gravity and quality of the bus, that is now bus adu Volvo bus. It requires sometimes 2 to 3 days are minimum required. But at the same time, ನೀವು ಎಷ್ಟು ಕ್ಲೇಮ್ ಮಾಡಿದಿರಿ? 9,600 per day. ಅದ್ರ ಬಗ್ಗೆ ಏನು ಎವಿಡೆನ್ಸ್ ಇದೆ? ಮತ್ತೆ ಏನ್ ನೋಷನಲ್ ಇದಕ್ಕೆ ನೋಷನಲ್ ಇನ್ಕಮ್? ಅವ್ರದಂತೂ ನಿಮ್ದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ ಅವ್ರ ಕ್ಲೇಮು. ಏನು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಸರ್ ಆನಂದ್ ಸಾಹೇಬ್ರದ್ದು?
Only damages has been awarded.
Loss of 500 revenue per day. ಅಲ್ಲ ಅವರು ಲುಕಿಂಗ್ ಟು ಇಟ್ ಈಸ್ ದಿ ಡಿಸ್ಕ್ರಿಷನ್ ಎಕ್ಸರ್ಸೈಸ್. ಅದು ದಟ್ ಕೆನಾಟ್ ಬಿ ಗ್ರೌಂಡ್. ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾಗಿದ್ದ ನೀವು ಅಲ್ವಾ? ಮುಂದೆ ನೀವು ಲಾಗ್ ಬುಕ್ ನಮ್ದು ರೆಗ್ಯುಲರ್ಲಿ ಇಷ್ಟು ಫಿಲ್ ಅಪ್ ಆಗುತ್ತೆ, ಇಷ್ಟು ರೆವಿನ್ಯೂ ನಮಗೆ ರೆಗ್ಯುಲರ್ಲಿ ಈ ರೂಟ್ ಒಳಗ ಇಷ್ಟು ರೆವಿನ್ಯೂ ಬರ್ತಾನೆ ಇತ್ತು, ಎವರೇಜ್ ರೆವಿನ್ಯೂ ಇಷ್ಟಿತ್ತು ಅಂತ ಹೇಳಿ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾ? ಅದನ್ನ ಪ್ರೂವ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ. ದೆನ್ ಎಲ್ಲ ಪ್ರಶ್ನೆಗಳು ಬರ್ತಾವಲ್ಲ. ಸರ್ ಅವ್ರು ಅದಕ್ಕೆ ತಗೊಳ್ಳಿ ಎವರೇಜ್ ತಗೊಂಡ್ರು ಅವ್ರು ಇಟ್ ವಾಸ್ ಓನ್ಲಿ ಗೆಸ್ ವರ್ಕ್. ಇದು ಓನ್ಲಿ ಗೆಸ್ ವರ್ಕ್. ನಿಮ್ದು ನಾನ್ ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೇನೆ, ಲಾಗ್ ಬುಕ್ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ? ಎವರೇಜ್ ಇನ್ಕಮ್ ತೋರಿಸ್ಬೋದಾಗಿತ್ತ? ಒಂದ್ ತಿಂಗಳದ ಹಿಂದಿಂದು ಇಷ್ಟು ನಮ್ ರೆಗ್ಯುಲರ್ಲಿ ಇಷ್ಟು ರನ್ನಿಂಗ್ ಆಗ್ತಿತ್ತು, ಇಷ್ಟು ಇದಾಕಿತ್ತು ಅಂತ ಹೇಳಿ ತೋರಿಸಿದ್ರ ಮತ್ತೆ this appeal is filed by the corporation research under section 173 subclause 1 of any act, claiming compensation, challenging the judgment and awarding MIC 937 of 2013 on the file of Additional Small Court Court and Senior Civil Judge Mysore, dated 2nd December 2017, seeking enhancement. There is no serious dispute regarding factual aspects of the matter that on 27/1/2012, the case at Shibas bearing KA09F4028 was proceeding from Mysore towards Nanjangud and near Chikkayana Chitra paper mill, The lorry bearing KH 075188 loaded with sugar cane was driven by its driver in a rash and negligent manner and dashed against the bus, resulting in the accident. As a result, the right side rear portion of the bus was damaged. The police have registered a criminal case against the driver of the offending lorry, and the vehicle was damaged, and case at corporation has spent rupees 22,948 for its repairs, and vehicle was kept idle for 9 days, and as such claimed compensation of rupees 86,400. The tribunal, after appreciating the oral as well as documentary evidence, has awarded rupees 22,948 regarding damage to the vehicle and denied the claim of the corporation regarding payment damage because of idling charges for 9 days. Being aggrieved by this judgment and award, the corporation has come up with this appeal. Third, the arguments advanced by the learned counsel for appellant corporation and learned counsel for respondent insurer peruse the records. The learned counsel for appellant corporation would contend that because of the damage caused, the corporation was unable to ply the said bus on regular route, and as such the vehicle was kept idle for 9 days, and as such idling charges were sought to the tune of rupees 86,400, amounting at the rate of 9,600 per day. Next one. Per contra, the learned counsel for insurance company would contend that there is no provision under section 165 of MU Act to claim idling charges, and hence he would seek for dismissal of the claim petition, dismissal of the appeal. Having heard the arguments and perusing the records, there is no dispute of the fact that the SRC bus was damaged on the right side rear end as it was hit by the offending lorry. The records also disclose that the lorry driver was prosecuted, and the tribunal found that the accident in question is because of actionable negligence on the part of the driver of the lorry. This finding was not challenged. The tribunal has awarded sum of damages to the tune of rupees 22,948 with interest at the rate of 6% regarding damage to the vehicle only, and denied the idling charges. Now the claimant, corporation is insisting for payment. Is before this appellate court seeking idling charges for 9 days. The next one. The corporation has placed reliance on Exhibit P8, which is the details pertaining to vehicle damage. The total cost is shown to be 22,948, and accordingly, same was awarded by the tribunal. However, on perusal of the actual man hours, it is evident that there were 7 workers attended the repair work for body repair, tinkering, painting, and other miscellaneous work, and each one is shown to have worked for 16 hours, that is for 2 days. It is hard to accept that each laborer has worked for 16 days as the nature of the work varies and it disclosed that the actual man hours shown in Exhibit P8 is not supported by any material evidence. Next. The Learned Counsel next. The tribunal has rejected the claim for idling charges on the ground that there is no provision in any act. The Learned Counsel for Respondent Corporation Insurance Company has also drawn attention of the court to Section 165 of MA Act. There is no reference of payment of idling charges. However, there is no bar under any statutory provision for granting idling charges also. ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಶ್ರೀ ಸ್ವಾಮಿ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ ನಾನು. ನೀವ್ ಯಾಕೆ ಇಷ್ಟು ಟೆನ್ಷನ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದೀರಿ? ನಾನು ಇನ್ನ ನಿಮ್ ಸೈಟೇಷನ್ ಬಂದೇ ಇಲ್ಲ, ಯಾವುದೇ ಪ್ರೊವಿಷನ್ ಡಿನೈ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದೀನಿ ಅಷ್ಟೇ ನಾನು. Apart from that, the Learned Counsel for Appellant has placed reliance on a decision of on a division bench edition of this court in MFA 4377 of 2001, dated 28th July 2006, wherein this court has granted idling charges for 5 months, 23 days at the rate of rupees 2,450 per day. A similar view is also taken by this court in MFA 9718 of 2012, in the judgment dated 10th June 2014, wherein under the head of loss of revenue, rupees 5,000 per day was awarded for 15 days. Hence, the tribunal has placed reliance on edition of Andhra Pradesh, a division bench edition of Andhra Pradesh High Court reported in 2009 ECJ 1723 for rejecting the idling charges. However, in view of the decision of this the division bench edition of this court, the decision of the Andhra Pradesh High Court cannot be made applicable to the facts and circumstances of the case in hand. But at the same time, though the corporation has sought idling charges by loss of revenue for 9 days, no evidence is placed to show that prior to the accident in the said route wherein the damaged bus was moving, the corporation used to generate so much revenue. The corporation has not produced log sheet to ascertain the average loss of revenue. Even under section 170, under section 72 of the MU Act, the corporation has also not maintained a spare bus. Considering these aspects and considering the man hours disclosed at 16 hours for each and every employee who attended the bus as per Exhibit P8, it appears to be on higher side. Only Exhibit P8 can be considered to show that each laborer has attended the bus for 2 days. Considering these aspects, the Exhibit P8 for considering the loss of revenue for 9 days cannot be accepted. Apart from that, the corporation has not produced any material evidence to show the average revenue generated in the particular route wherein the damaged bus was moving. However, in view of the decision reported in 9718 MFA 9718/2012, wherein in respect of Rajahamsa bus, a income was taken as 5,000 per day. Considering the fact that this is a Volvo bus, the income can be taken at 6,000 per day. Considering the nature of damages, it can be taken at nature of damages. 3 days idling charges can be considered, and hence under the head of idling charges for loss of revenue, the corporation is entitled for 18,000. Hence, the corporation is entitled for a total compensation of rupees 22,948 under the head of damage to the vehicle and 18,000 under the head of loss of revenue. As such, the appeal needs to be allowed in court, and accordingly I proceed. Allowed in part also as against entire fee is 6% interest.
Number 39, Suresh Kapoor. Number 39, Suresh Kapoor.
No representation, list after 1 week.
Number 14,
You have not filed power, sir. You have not filed power in 40.1. 40.1, 40.2 ಎರಡದ್ರೂ ಹಾಕಿಲ್ಲ. ನೋಡ್ರಿ ಅಲ್ಲ ಓಕೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಬೆಟರ್ ಅಂತ. ಸರಿ. The Learned Counsel for Petitioner absent. As per request of the Learned Counsel for Respondent, read the matter on 39.
Number 42.
And for the appellant.
Yes, Nikhil. M. Venkatesh.
For respond number 3.
I am appearing for respondent, my lordship.
Yes, sir.
My lord, this is a claimant appeal.
Lord, this is my appeal filed by the claimant for enhancement of the compensation.
Yes.
It's a case of injury. Lord,
Yes.
accident of in the year 2015.
Yes.
And the appellant was is traveling in a motorbike from Tokkotu to Kuttar to attend his office.
Whether he was a rider or pillion rider?
He's a rider.
Rider of the motorcycle, my lord.
Yes.
And on the accident note, the charge sheet was filed against the respondent, and the tribunal is awarded 2 lakhs. Not the award amount is not 2,03,360 rupees.
ಆಯ್ತು ಕೆಲ್ರ. What was the nature of the accident? Head-on collision? No, no.
Head-on collision.
The opposite vehicle is Tata AS. From it is came from the opposite side and dashed, and then the charge sheet was laid against them. And initially he was shifted to case at the hospital.
I took it. Have you produced the sketch of the scene of offense?
There is no liability dispute, Lord, and there is.
ನಾನು ಕೇಳಿದೆ ಸ್ವಾಮಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಗೊತ್ತಿಲ್ಲ ನನಗೆ ಕೇಳಿದೆ. It is my duty. You are seeking enhancement. My duty is to verify the records. ಅದಕ್ಕೆ ಕೇಳಿದೆ ಆಕ್ಸಿಡೆಂಟ್ ಯಾರ್ದೇನ್ ತಪ್ಪದ ನೋಡೋಣ ಅಂತ ಹೇಳಿ. ಅದು ತಪ್ಪದ ಅಂತಂದ್ರೆ ನೋಡಲ್ಲ.
Sorry. Sketch is marked at exhibit P6.
P6,
Please.
Also.
Towards which the two-wheeler was moving? Is it head-on collision or knocking from backside?
Head-on collision. Para facts at page number 10, not para, second para.
Yes. Heli. Next. What is the nature of injuries?
Lord, as per the wound certificate, Lord, he has sustained 4 grievous injuries.
Para 13, page 8, my lord.
Sir, injury ಏನದ ಅಂತ ಕೇಳಿದೀನಿ ಅದ್ರಾಗ ಓದಿದ್ರೆ ನಾನು ನೋಡ್ತೀನಿ ಅದು ಬೇಡ in general ಹೇಳಿ fracture of the tibia fibula ಏನ್
Yes, Lord, there are fracture, Lord, fracture of 4th and 5th digital phalanxes of right hand and fracture of subthoracics and fracture of right femur and fracture of both bones of the right legs are grievous in nature. That is the finding at para 13 of the judgment. And wound certificate is marked in exhibit P3.
So it disclosed that right femur, right tibia and fibula and right 4th and 5th right hand 4th and 5th phalanxes.
Yes.
Sorry.
And tribunal is awarded 70,000 rupees on that head, the pain and suffering.
Yes.
And he was hospitalized for more than 72 days. Lord.
Yes.
That is at para 18 of the judgment. Lord. Discharge summary is marked at exhibit P78, 77, 78 and 79.
Yes.
And the doctor has examined as PW2 and given an opinion that he has 30% disabled.
Yes.
On his right leg. And the trial court tribunal has taken it as a 10%.
Yes. What is the illegality?
The pain illa Swami.
Lord, he is Lord, the findings given by the trial court is that he is working as a security officer in Infosys. Because of the disability, he cannot move around, Lord, as nature of his work is doing. By this accident, Lord, his movements were totally restricted. And in the cross-examination, there is a specific suggestion that can he do the work after this accident? He said that while as a sitting, only by sitting, he can do the work. He cannot walk.
Whether he was removed from Infosys because of these accidental injuries?
That was not forthcoming in the evidence.
Then when he was working in Infosys, he is disabled from working. He should have been removed.
That employer is not.
But then when you are claiming compensation,
Please.
if he is not continued in service, in fact, he is not entitled for any compensation under the head of loss of future earning.
That was.
If he continued.
Lord, as per the evidence, Lord, there is no suggestion so far.
Our suggestion ಬೇಡ ನೀವು ಹೇಳಿದ್ರೇನ್ರಿ our suggestion ಬೇರೆ our suggestion ಹೇಳ್ತೀರಿ ನೀವು ಹೇಳಿದಿರಾ ನನ್ನ ಕೆಲಸದಿಂದ ತೆಗೆದಿದ್ದಾರೆ ನಾನು ಕೆಲಸ ಮಾಡಕ್ಕೆ ಅಯೋಗ್ಯಗಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ಏನ್ರಿ ಎವಿಡೆನ್ಸ್ ಇದೆನಾ ನಿಮ್ದು ನಿಂತು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ ಕೂತ್ ಮಾಡಕ್ ಆಗುತ್ತೆ ಓನ್ಲಿ ಕೂತ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಕೂತ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಯೋಗ್ಯದಿ ನಿನ್ನ ಹೊರಗೆ ಹಾಕ್ತಾ ಇದೀವಿ ಅಂತ ಏನ್ರಿ ಲೆಟರ್ ಕೊಟ್ಟಿದಾರ ಅವರು
ಅಲ್ಲ ಮೈ ಎವಿಡೆನ್ಸ್ ಸ್ಪೆಸಿಫಿಕಲಿ ಡಿಪೋಸ್ ದಟ್ ಐ ಲಾಸ್ಟ್ ಮೈ ಜಾಬ್ because of
where is the document where is the document to show that first you are serving in Infosys?
Lord, I have produced the salary slip. I examined my employer and they don't put up to any suggestion that I was removed from the service or I'm not continues in the service.
Sir, you cannot remove from service in a mechanical way.
But they are not suggested me to
Sir,
my employer. My in affidavit I am specifically treated that I was lost my job after the accident.
You are not an employee of the Infosys as claimed by you.
Correct, Mela. Correct.
You are not an employee of Infosys as claimed by you.
I am a security officer in the.
You are a security workman employed by a independent agency.
Yes,
which has engaged in providing services to the Infosys. Please. But you are arguing as if you are an employee of Infosys.
But I am saying that because of loss of the future income, because of this, Lord, my movements were restricted. I could not do the work. That is my argument, Lord. I am not seeking that because of this accident I lost the job. But Lordship has put a suggestion that because of this accident, whether he continued the same work.
Have you gone through the cross-examination of PW3?
Please, Lord.
Note a cross-examination of PW3.
ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಂಧಿಸಿದ ನಮ್ಮ ಸಂಸ್ಥೆಯಿಂದ ನೇಮಕಾತಿ ಆದೇಶ ನೀಡಲಾಗಿತ್ತು. ಈ ಬಗ್ಗೆ ನಮ್ಮ ಕಚೇರಿಯ ದಾಖಲೆ ಇದೆ. ಸದರಿ ನೇಮಕಾತಿ ಆದೇಶದಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ ಎಷ್ಟು ಸಂಬಳ ಎಷ್ಟು ಭತ್ಯೆ ಎನ್ನುವ ಬಗ್ಗೆ ವಿವರ ನಮೂದಿಸಲಾಗಿತ್ತು. ಆದ್ದರಿಂದ ನೌಕರಿ ಕಾಲಾವಧಿಯನ್ನು ನಮೂದಿಸಿರಲಿಲ್ಲ. ಅದರಲ್ಲಿ ಅವರ ವಯಸ್ಸು ನಮೂದಿಸಲಾಗಿತ್ತು. ನಮ್ಮ ಸಂಸ್ಥೆಯಲ್ಲಿ 60 ವರ್ಷಕ್ಕೆ ನಿವೃತ್ತಿ ಇದೆ. ಅರ್ಜಿದಾರರಿಗೆ ಈಗ ಎಷ್ಟು ವಯಸ್ಸು ಎಂದು ನನಗೆ ನೆನಪಿಲ್ಲ. ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಳದ ಪಾವತಿಸಿದ ಬಗ್ಗೆ ಹಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮ್ಮ ಸಂಸ್ಥೆಯಲ್ಲಿ ದಾಖಲೆ ಇದೆ. ಎಕ್ಸಿಬಿಟ್ ಪಿ 82 to 84 ನಲ್ಲಿ ಕಾಣಿಸುವ ರೀತಿಯಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಳ ಪಾವತಿಯಾಗಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ.
On that issue, my lords, may I kindly go to
ನಿಮಗೆ ಬರ್ತೀನಿ ಅವ್ರದ್ದು ಮುಗಿಲಿ ಯಾಕೆ
ಸರಿ ಸೋಮ್.
yes ವಕೀಲ್ರ. He never said that they have removed him from service. The evidence of PW3 simply states that from the date of accident, he stopped attending the work.
Please. But in my pleadings, Lord, in the affidavit, I specifically pleaded that after this accident, I lost my job.
Losing the job is different. Losing job means you must be removed from the service.
Please.
discontinuation of the job by yourself does not amount to loss of job. And PW3, who you are a witness, does not say that they have removed you, but you say that he says that you stopped attending the work.
Please.
And no corresponding documents have been produced by PW3, though he admits that what is your income, roll call, everything, nothing was produced.
Please. Then the doctor specifically say that he can't do the work because of the accident. He can do the work by sitting and he cannot move.
Even your doctor evidence disclosed that the petitioner, that is the claimant, suffers only 10% disability to the whole body. And he is completely recovered. The bones are united, everything he has stated.
Not in the evidence he stated only about 30%.
ನೋಡಿ ಸರ್,
The cross
ಅರ್ಜಿದಾರರ ಸಂಪೂರ್ಣ ದೇಹಕ್ಕೆ ಶೇಕಡ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 2 ಆಫ್ PW2.
this whole body it has taken.
ಅರ್ಜಿದಾರನ ಸಂಪೂರ್ಣ ದೇಹಕ್ಕೆ ಶೇಕಡ 10ರಷ್ಟು ದೈಹಿಕ ನ್ಯೂನತೆ ಇದೆ. ಅವರಿಗೆ ಆಗಿದ್ದ ಮೂಳೆ ಮುರಿತ ಕೂಡಿಕೊಂಡಿದೆ ಮತ್ತು ಅವರು ಗುಣಮುಖರಾಗಿದ್ದಾರೆ ಎಂದರೆ ನಿಜ.
But in the first in the cross examination first portion,
ಸರ್ ಇದನ್ನ ಎಲಿಷಿಯೇಟ್ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ರೆಫರೆನ್ಸ್ ಇಗ್ನೋರೆನ್ಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನು ಡಿಫರೆಂಟ್ ವೇ ಆಫ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇರುತ್ತೆ ಅದು. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಆನ್ ಆರ್ಟ್ ಅಲ್ವಾ?
ಅವರು ಕುಳಿತುಕೊಂಡು ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಆಗಿ ಕೆಲಸ
ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿದ್ರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಓನ್ಲಿ 10% ಟು ದಿ ಹೋಲ್ ಬಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
ಬಟ್ ನೇಚರ್ ಆಫ್ ವರ್ಕ್
10% ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ದವರು. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ದವರು?
10% ತಗೊಂಡಿದ್ದಾರೆ.
10% ತಗೊಂಡಿದ್ದಾರೆ ಆಸ್ ಪರ್ ದಿ ಎವಿಡೆನ್ಸ್ ಗಿವನ್ ಬೈ ದಿ ಡಾಕ್ಟರ್ ಹಿಮ್ಸೆಲ್ಫ್.
ಬಟ್ ನಮ್ ಸ್ಯಾಲರಿಯನ್ನ 16 into 3 ಅಂತ ಮಲ್ಟಿಪ್ಲೈಯರ್ ತಗೊಂಡಿದ್ದಾರೆ. ಪ್ಯಾರಾ 24
ಏನು?
My admitted salary, I produced the document, is 82 to 84. The para 23.
28,000 and salary idru, it gives a different the tribunal has given reasons. OT charges include nim regular salary estiide? Regular salary is 16,120 only.
Please,
ಮತ್ತೆ
ಆ ಹೆಡ್ ಅಲ್ಲಿ ಕೊಟ್ಟೇ ಇಲ್ಲ ನನಗೆ ಯಾವುದು ಅವಾರ್ಡ್
ಏನ್ ಕೊಟ್ಟಿಲ್ಲ ಹೇಳಿ, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ.
ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಬಗ್ಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಎದಕ್ ಕೊಟ್ಟಿಲ್ಲ?
Pain and suffering, there are 4 grievous injuries. Pain and suffering 70,000 was award.
ಬಾಳ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ.
70
ಬಾಳ ಕೊಟ್ಟಿದ್ದಾರೆ ವಕೀಲ್ರೆ.
72 days I was hospitalized.
ಅದಕ್ಕೆ sufficient ಕೊಟ್ಟಿದ್ದಾರೆ.
Lord, it is a 4 grievous fracture injuries.
That is a different aspect ವಕೀಲ್ರೆ.
Lord, kindly see the loss of income during the treatment has given 48,000. Future medical expenses 5,000 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. And loss of amenities ಅಂತ 20 ಕೊಟ್ಟಿದ್ದಾರೆ. Future loss of income ಏನು ಕೊಟ್ಟೇ ಇಲ್ಲ 1 ರೂಪಾಯಿ.
ಅಲ್ಲ ಅದನ್ನ ಹೇಳಿ, ಫ್ಯೂಚರ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. That is a different aspect.
Please. ಅಲ್ಲ ಇದು this pain and suffering is 70,000 is very low.
70,000 is more than sufficient, sir.
Lord, it's a grievous is
ಎಲ್ಲ ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿಗೆ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕೊಡ್ತೀವಿ. ಸಿಂಪಲ್ ಇಂಜುರಿ ಏನು ಕೊಡಲ್ಲ. ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಹೆಡ್ ಕೆಳಗೆ
72 ದಿವಸದ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ದ. Loss of income during the period of treatment also. 38,000. Attendance charge is not given for 78 days.
ಹಾ ಎಸ್ ವಕೀಲ್ರೆ, ಈಗ ಹೇಳಿ ಸರ್ ನೀವು. ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಇನ್ಕಮ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಒಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ನಿಮ್ ಕಡೆ ಬರ್ತೀನಿ. ಡಿಸಬಿಲಿಟಿ 10% ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರು, ಬಟ್ ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಇನ್ಕಮ್ ಕೊಡ್ಲಿಲ್ಲ. ಅಂದ್ರೆ ಡಿಸಬಿಲಿಟಿ ಕನ್ಸಿಡರ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಏನಿತ್ತು? And it is not your case that he continued in the said service.
No, you are not as per my affidavit. Not here.
ನಾನು ನಿಮ್ನ ಕೇಳ್ತಾ ಇಲ್ಲ ವಕೀಲ, ಅವ್ರನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಹ್ಯಾವ್ ಪೇಷನ್ಸ್.
ಮೈ ಲ್ಯಾಡ್, ಈ ಜಾಬ್ ಡಿಸ್ಕಂಟಿನ್ಯೂ ಆಗಿದೆ ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲೂ ಡಿಫೆನ್ಸು ಇಲ್ಲ, ಪ್ಲಸ್ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ಲಿಲ್ಲ ಸೊಮ್ಮೆ. ಇವರು ಇನ್ಫೋಸಿಸ್ ಅಲ್ಲಿ ಏಜೆನ್ಸಿಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು. ಈಸ್ ಅನ್ ಎಕ್ಸ್ ಸರ್ವಿಸ್ ಮ್ಯಾನ್, ಇಂಜುರಿ ಆಗಿದೆ, ಕೊಟ್ಟಿರೋದು ಕಡಿಮೆ ಇದೆ, ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು, ಅದು ನಾನು ಒಪ್ತೇನೆ. ಬಟ್ ಇವ್ರು ಪೇ ಸ್ಲಿಪ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ಎಕ್ಸಿಬಿಟ್ P82 to 84 ದಯವಿಟ್ಟು ನೋಡಿ ಯಾವ ಪೀರಿಯಡ್ ಇದು ಅಂತ. ಆಕ್ಚುಲ್ ಆಗಿ ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಬಂದು 15/1/15. 3 ತಿಂಗಳು, 5 ತಿಂಗಳು, 6 ತಿಂಗಳು ಕೆಳಗಡೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ಇವಾಗ ಡ್ಯೂಟಿ ಮಾಡ್ತಾ ಇದ್ನಾ ಇಲ್ವಾ ಅನ್ನೋದು ಕೂಡ ದೇರ್ ಇಸ್ ನೋ ಪ್ರೂಫ್ ಅಡ್ಯೂಸ್ಡ್ ಬೈ ದಿ ಕ್ಲೈಮೆಂಟ್ಸ್. 6 ತಿಂಗಳ ಹಿಂದೆ ಪೇ ಸ್ಲಿಪ್.
ಒಂದ್ ನಿಮಿಷ ನೋಡೋಣ.
ಪ್ಯಾರಾ 23 ಮೈಲಾಡ್, ಪೇಜ್ ನಂಬರ್ 14.
ಅಲ್ಲ, ಔಟ್ ಬೇಡ.
ಹಾ ಸರಿ ಸುಮ್.
What is the date of accident?
15/1/15.
15/1/2015.
ಹೌದು ಸ್ವಾಮಿ.
ವಕೀಲ್ರ,
Please.
ನವೆಂಬರ್ 2014 ಕೊಟ್ಟಿದಾರಲ್ರಿ?
Yes, Lord.
Pay slip for the month of November 2014.
How?
At exhibit P84. 83 is for October 2014. 82 is for September 2014. 6 ತಿಂಗಳ ಮುಂಚಿಂದ ಯಾವ ಬೇಸ್ ಮ್ಯಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೀರಿ? ಜನವರಿದಂತ್ರ ಪೇ ಸ್ಲಿಪ್ ಬರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. ಡಿಸೆಂಬರ್ದ ಒಂದೇ ಪೇ ಸ್ಲಿಪ್ he could not produce it.
ಹೌದು.
Then how can you argue?
ಸೆಪ್ಟೆಂಬರ್, ಅಕ್ಟೋಬರ್, ನವೆಂಬರ್ ಹಾಕಿದ್ದಾರೆ ಹೊರತು ಡಿಸೆಂಬರ್
ಹಾಕಿಲ್ಲ.
ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದಾರ ಇಲ್ವಾ? ಆ ಕಂಪನಿಲಿ ಇದಾರ ಅಥವಾ ಬೇರೆ ಏಜೆನ್ಸಿಲಿ ತಗೊಂಡ್ರ ಇವರು? ಏನು
ಅದನ್ನ ಬಿಡಿ,
ನೀವು ಸಜೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅವರಿಗೆ.
ನಿಮ್ದು ಕೇಸ್ ಅಲ್ಲಲ್ಲ, ಸರ್ವಿಸ್ ಕಂಟಿನ್ಯೂ ಆದಾಗಿದ್ದಾನಂತ PW2 ಸಜೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲಲ್ಲ.
ಮೇ ಬಿ ಮೈಲಾಡ್, ಐ ಡೋಂಟ್ ಥಿಂಕ್.
ಸರಿ ಹೇಳಿ.
ಅಮ್ಯುನಿಟೀಸ್ ಬಗ್ಗೆ ಕೊಟ್ಟಿರೋ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದೆ. ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಕುಡ್ ಎನ್ಹಾನ್ಸ್ ಆಸ್ ಪರ್ ನಾರ್ಮ್ಸ್ ಮೈ ಲಾರ್ಡ್.
ಅಮ್ಯುನಿಟೀಸ್ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಸ್ ಇಟ್ ಈಸ್ ಆನ್ 72 days ಲೇಡ್ ಔಟ್ ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿದ್ದಾನೆ.
ಬಟ್ ಒಂದ್ ಇಶ್ಯೂ ಮೈ ಲಾರ್ಡ್, 72 ದಿವಸ ಇನ್ಪೇಷಂಟ್ ಆಗಿದೆ ಅಂತ ಎಲ್ಲೂ ಒಂದು ರೆಕಾರ್ಡ್ ಹಾಕ್ಲಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. ಡೇಟ್ಗಳು ಹಾಕಿದಾರಲ್ಲ ಜಡ್ಜು, 72 ದಿವಸ ಇನ್ಪೇಷಂಟ್ ಆಗಿದ್ದ.
ಕೌಂಟ್ ಮಾಡಿ ಡೇಟ್ಸ್ ಕೌಂಟ್ ಮಾಡಿ ಎಷ್ಟು ದಿನ ಆಗುತ್ತೆ?
3 ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ ಹಾಕಿದೀವಿ. 3 ಡಿಸ್ಚಾರ್ಜ್.
ಅಲ್ಲ, ಡೇಟ್ಸ್ ಕೌಂಟ್ ಮಾಡಿಬಿಡಿ, ಸಿಂಪಲ್ ಆಗುತ್ತಲ್ಲ.
ಸರಿ ಸರ್, ಆಯ್ತು ಸರ್.
ಸೊ ಅಲ್ಲ, 72 days ಆಗ್ಬೇಕಾದ್ರೆ ಮಿನಿಮಮ್ 3 ರಿಂದ 4 ತಿಂಗಳಂತೂ ಅವನ್ಗೆ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ಲಿಕ್ಕೆ ಕಷ್ಟ ಆಗಿರ್ಬೇಕು.
ಇರುತ್ತೆ ಸ್ವಾಮಿ, ಇರುತ್ತೆ ಸ್ವಾಮಿ. ಹೌದು
Then
ಸ್ವಾಮಿ, ಇರುತ್ತೆ.
4 months laid up period ಅಂತೂ ಕೊಡ್ಲೇಬೇಕು.
ಕೊಡಿ ಸ್ವಾಮಿ, 3 months ಕೊಡಿ ಮೇಲೆ.
ಅಲ್ಲ 72 ದಿವಸ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾನ 3 months ಕೊಡೋದ ತಪ್ಪಾಗಲ್ವನ್ರಿ? ಇಷ್ಟ್ಯಾಕ್ ಕನ್ಫ್ಯೂಸ್ ಆಗತ್ತೀರಿ?
90 days ಆಗುತ್ತೆ ಮೇಲೆ.
ಅದೇ 90 days ಅಂದ್ರ ಹಾಸ್ಪಿಟಲ್ ಡಿಸ್ಚಾರ್ಜ್ ಆದ ಕೂಡಲೇ 15 ದಿವಸ ಹೊಡ್ಕೋತ ಹೋಗಿ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ಬೇಕ.
ಸರಿ ಆಯ್ತು ಮೈಲಾಡ್, 4 ತಿಂಗಳದ ಕೊಡಿ ಮೈಲಾಡ್. ಐ ಆಮ್ ನಾಟ್ ಕಮಿಂಗ್ ಟು ದಿ ಕೋರ್ಟ್. ಅಷ್ಟ ಅಮ್ಯುನಿಟೀಸ್ ಸ್ವಲ್ಪ ಎನ್ಹಾನ್ಸ್ ಮಾಡ್ಬೇಕು.
ಮುಂದ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ 10% ಡಿಸಬಿಲಿಟಿ ಆಗಿದ್ದದ. Actually, he should have led proper evidence. Mistake lies with him.
ಹೌದು ಸ್ವಾಮಿ.
ಅವರು ಸರಿಯಾಗಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಅವ್ನು ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದಾರ ಅಂತ ಹೇಳಿ ಕನ್ಸರ್ನ್ ಕಂಪ್ನಿಯಿಂದ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ ಥಿಂಗ್ಸ್ ವುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಡಿಫರೆಂಟ್. 100% ಬೆನಿಫಿಟ್ ಸಿಗ್ತಿತ್ತು ಅವ್ರಿಗೆ. ನೀವು ಕ್ರಾಸ್ ಮಾಡ್ಲಿಲ್ಲ. ಏಕ್ ಸರ್ವಿಸ್ ಮನ್ ಅದಾನ, ಅವ್ನಿಗೆ ಏನ್ ಕಡಿಮೆ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅದನ್ನ ನೀವು ಮಾಡ್ಲಿಲ್ಲ.
ಇಲ್ಲ, ಕರೆಕ್ಟ್. ತಪ್ಪು ನನ್ ಕಡೆನೂ ಇದೆ, ಇಲ್ಲ ಅಂತ ನಾನು.
ಇಬ್ಬರು ಕಡೆ ತಪ್ಪಿದೆ.
ನನ್ ಕಡೆನೂ ತಪ್ಪಿದೆ ಸ್ವಾಮಿ. Court might take, I think court will consider and suitable enhancement kindly be granted, my lord. Because 2 lakhs is on a lesser side. I agree with the petitioner.
16,000 count ಮಾಡಿದ್ರೆ ಮಂತ್ಲಿ ಇನ್ಕಮ್ 10% ಡಿಸಬಿಲಿಟಿ ಬರುತ್ತೆ.
1600 into 12 into
45 is into 14 ಬರ್ತದ.
ಇಲ್ಲ, 60 years my lord. ತಪ್ಪು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು. ಅದ್ರ ಬೇಕಾದ್ರೆ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ.
69 years.
69 years.
59 years.
59 years.
ರಾಂಗ್ ಹೇಳಿದರು. 60 ವರ್ಷ ತಗೊಂಡಿದ್ರು ಸ್ವಾಮಿ ಕ್ಲಾರ್ನೆಟ್ ಜಡ್ಜ್. ಎಲ್ಲ ಫಾಲ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬಿಫೋರ್ ಲರ್ನಿಂಗ್.
59 years ಅಂದ್ರೆ ಮಲ್ಟಿಪ್ಲೈರ್ 60 years ಅಂದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ?
9 ಬರುತ್ತೆ ಸ್ವಾಮಿ. 56, 60, 9 ಬರುತ್ತೆ ಮೈಲಾಡ್. $1,72,800 ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಅಷ್ಟೇ ಬರುತ್ತೆ ನೋಡಿ ಸ್ವಾಮಿ.
ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಮೈಲಾಡ್ 10% ತಗೊಂಡಾಗ 16,000ಕ್ಕೆ.
ಯಾಕಂದ್ರೆ ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸ್ಲಿಲ್ಲ. ಹಿ ಇಸ್ ಎ ರಿಟೈರ್ಡ್ ಸರ್ವಿಸ್ ಮ್ಯಾನ್.
ಹೌದು.
ನೀವು ಕ್ಲೇಮಂಟ್ ಸರಿಯಾಗಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸ್ಲಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
Co-employee was also examined as PW.
ಈ ಕೋ ಎಂಪ್ಲಾಯ್ ಹೇಳ್ತಾನ ಅಂತ ಹೇಳಿ ಇವ್ರು ಕೊಡಕ್ ಆಗೋಲ್ಲ. ಎಂಪ್ಲಾಯರ್ ಹೇಳ್ಬೇಕು he was discharged ಅಂತ ಹೇಳಿ. Even otherwise in 1 year he would not have been continued in the service alwa. If his age is taken, he admits that the period of service is 60 years. Matter ends there. Therefore, ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ನು ಡ್ಯೂಟಿಗೆ ಹೋಗಿಲ್ಲ.
ಏಜೆನ್ಸಿ ಅವರು
ಅದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಇನ್ 1 ವರ್ಷದಿಂದ ಏಟ್ ಗಳಿಸ್ಬೇಕು, ನನಗೆ ಎಕ್ಸ್ ಸರ್ವಿಸ್ ಮ್ಯಾನ್ ಪೆನ್ಷನ್ ಬರುತ್ತೆ, ಯಾಕೆ ಟೆನ್ಷನ್ ತಗೋಬೇಕು ಅಂತ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ಲಿಲ್ಲ ಅವನು.
ಹೌದು ಸ್ವಾಮಿ. True, my lord. That is the true fact. My lord, one submission, my lord. I may permit to leave. I have to go to some other.
ಅಟೆಂಡ್ ಮಾಡಿ. Thank you. Thank you.
Aye, soon.
This appeal is filed under section 173 sub-clause 1 of the new act, challenging the judgment and award passed by the third additional district judge and MACT 4 Mangalore in MAC 1413 of 2016, dated 27th January 2018. Next, there is no serious dispute regarding factual aspects leading to the case. Admittedly, on 15/1/2015 at 6:10 a.m., the claimant appellant was traveling in a motorcycle bearing KA 19/R3852 from Thotkattu to Kattur for attending his work in Infosys Mangalore near Babu Katte School, Pandit House, Peramnur, Mangalore. The Tata is bearing KA 19A 5249 came from opposite direction in a rash and negligent manner by moving wrong side and dashed against the vehicle of the petitioner, resulting in the accident. The immediately petitioner was shifted to Netaji Yellappa Memorial Charitable Hospital, Thokattu in Mangalore, and later on he was shifted to K. Segade Charitable Hospital, Derlakatte, Mangalore. Petitioner has suffered the fracture of 4th and 5th of right phalanx and fracture of right femur and right tibia and fibula. He was inpatient for more than 72 days in the hospital, and as such, the claimant filed claim petition under section 166 of the NU Act, claiming compensation of rupees 10 lakhs or 25 lakhs. After appreciating the oral and documentary evidence, the tribunal has awarded a total compensation of rupees 2,03,360 with interest at the rate of 6% per annum. Being aggrieved by this judgment and award, the claimant is before this court seeking enhancement. Heard the arguments advanced by the learned counsel for appellant and learned counsel for respondent insurer. There is the reports. Next. Learned counsel for appellant would contend that the petitioner has suffered fracture of right femur, right tibia and fibula, and 4th and 5th of right phalanx, and tribunal has awarded meager compensation under the head of pain and suffering and loss of amenities. He would also contend that no compensation was awarded under the loss of future income, and the compensation awarded under the head of later period is also on lower side. He would further contend that the disability taken was also on lower side, and as such, he would seek for enhancement. Per contra, the learned counsel for respondent insurer would support the judgment and award passed by the tribunal. Having heard the arguments and perusing the reports, it is evident that in the extent dated 15/1/2015, the claimant has suffered grievous injuries. In fact, he suffered 5 fractures. The records at Exhibit P 77 to 79 and Exhibit P 17 and other corresponding documents disclose that he was inpatient for 72 days. PW2 has given disability to the extent of 30% to the right lower limb and 10% to the whole body. There is no serious dispute of the fact that the claimant was aged about 59 years as on the date of the accident. The tribunal has awarded rupees 70,000 under the head of pain and suffering, which is just and proper and does not call for any interference. Further, tribunal has also awarded medical expenses and incidental expenses to the tune of rupees 60,000, which is based on documentary evidence and does not call for any interference. Under the head of loss of amenities, tribunal has awarded rupees 20,000, which appears to be on lower side considering the nature of the injuries sustained by the petitioner regarding right fracture of right femur, right tibia and fibula, and 2 fingers of the right hand. Hence, under the head of loss of amenities, claimant would be entitled to 30,000. Next. Further, towards medical expense, future medical expenses, tribunal has awarded only rupees 5,000, which appears to be on lower side considering the nature and gravity of injuries and further treatment required as per the evidence of PW2. Hence, under the head of future medical expenses, claimant appellant would be entitled for 15,000. The records disclose that claimant was appellant was inpatient for almost 72 days. The salary certificate at exhibit P82-84 disclosed that he was drawing salary of rupees 16,120. Though he was inpatient for nearly 2.5 months, he ought to have been prevented from attending his normal duty for at least 4 months, and hence loss of income during laid-up period awarded by the tribunal at 48,360 appears to be on lower side, and I propose to award it for 4 months, that is 16,120 into 4. Next further. The tribunal has not awarded any compensation under the head of loss of future income. No doubt the claimant was ex-serviceman and he was aged about 59 years. However, the medical evidence disclosed that he has suffered disability to the extent of 10% to the whole body. The evidence of PW3 disclosed that the claimant would have continued in his office for up to 60 years, that is only for a period of 1 year. Admittedly, claimant is an ex-serviceman. Hence, after 60, he would not have earned 16,120 as claimed by him, and he would have been discharged from his service on attaining age of superannuation. He was required to work privately at a meager salary. Hence, considering his age, though he was earning rupees 16,120 at the age of 59 years, the notional income is required to be taken at 9,000. Considering that in a period of 1 year, he is bound to retire and 4 months laid up period is already granted to him. Considering his age, multiplier 9 is applicable, and as such, loss of income would be 9,000 into 12 into 10 into 100 divided by 100. 1,74,009. As such, claimant would be entitled for total compensation under various heads as under pain and suffering 70, medical 60,000, loss of income during laid up period 64,000 till rate, future medical expenses 15,000, loss of amenities 30,000. Hence, claimant would be entitled for 4 lakhs also. As such, appeal needs to be allowed in part, and accordingly I proceed to copy for him. The appeal is allowed in part. the claimant is held entitled for total compensation of funds as against the enhanced compensation shall carry interest at the rate of 6%. The insurance company, respondent to insurance company is directed to deposit the entire enhanced compensation with accrued interest therein within a period of 6 weeks from today. The entire enhanced compensation with accrued interest shall be released in favor of the claimant. Yes.
43 again, 44, any for MS?
ಯಾರ್ ಪರವಾಗಿ ಹೇಳ್ತಾ ಇದ್ರಿ? As per request of the learned counsel for appellant, list after 1 week, 2 weeks.
Almost 45 and 46 are as well. Number 47. And
Three grounds, madam.
One ನಿಮಿಷ. Claimant's appeal for enhancement.
Insurance company absolved on the ground, he had no.
ಅಲ್ಲ ನೀವು ಏನೇನೆ ಲಯಬಿಲಿಟಿನೂ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ, ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
Yes, I am not going to press. That's so serious about it.
ನೆಗ್ಲಿಜೆನ್ಸ್ ನಾಟ್ ಸೀರಿಯಸ್ ಎಷ್ಟು ಹಾಕಿದ್ದಾರೆ? ಓಕೆ. ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಎಷ್ಟು? 2016 9,500 ತಗೋಬೇಕಾಗಿತ್ತು, 8,000 ತಗೊಂಡಿದ್ದಾರೆ. What is the age of the deceased? PM report ದಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ 40 ತಗೊಂಡಿದ್ದಾರೆ. 40 ತಗೊಂಡು, there is no dispute. So
Party actually, the prosper actually 40% up to 40 years. I did only 25% towards the prosper.
ಇಲ್ಲ 25% ಕರೆಕ್ಟ್. ಅದು ಬಿಲೋ 40 ಇದ್ರೆ 40,000 40%, 40 to 45 25% ಇದೆ. That is also cannot interfere, but income is on lower side.
Other heads.
Future ತಗೊಂಡಿದ್ದಾರೆ.
Okay. What commensurate? There are 5 claimants.
40,000 ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. Parents, minor children and widow. Okay. So 2 lakhs 230 ಆಗಬೇಕು ಅಷ್ಟೇ. 230 ಬರಬೇಕು. In place of 70 ಕೊಟ್ಟಿದ್ದು ಟ್ರಿಬ್ಯುನಲ್ ದವರು 70 ಕೊಟ್ಟಿದ್ದಾರೆ, 230 ಆಗಬೇಕು. Okay.
Driving license drive all types of 4-wheelers. Heavy transport, heavy, but we had no driving license drive 2-wheeler.
ಅದಕ್ಕೆ 20% ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
Triple riding ಬಿಟ್ಟು. One of the, this is one of the claim rate. I'm not on that point. 20% I'm not going to press. Only 2 grounds. First is regarding thing of liability. Second is not.
ಹೇಳ್ರಿ. Now you are the rider, Fill and rider. Policy, act policy na? Then why the claim petition against respondent number 2 is dismissed?
No driving license. Motorcycle. Motorcycle also driving license illa andu one driver. He had license to drive 4-wheelers or other types of 4-wheeler, but no driving to drive 2-wheeler. Page number 19, para number 27.
ರಿಯಲ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಈಗ ಪೇಂಟ್ ರಿಕವರಿ ಬರುತ್ತಲ್ಲ ಅಷ್ಟೇ ಅಲ್ವಾ? ದಟ್ ಈಸ್ ದೇರ್ ಇಸ್ ನೋ ಅದರ್ ಇಶ್ಯೂ. ಈಗ ನಾವು ಇಟ್ ಈಸ್ ಸೆಟಲ್ಡ್. Any other thing? Nothing. This appeal is filed section 173, sub clause 1 of any act by the claimant challenging the judgment and award passed by MACT Bangalore City SCCH 14 in MAC 4798 of 2016 dated 12th October 2018 seeking enhancement. The brief factual matters leading to the case are that on 5/4/2016 at 8 p.m., the deceased was proceeding as a pillion rider on motorcycle bearing KA 53EH4251, which was driven by G. Ravi along with another pillion rider, that is Suresh, towards their village. The rider rode it in a rash and negligent manner and lost control. As a result, the vehicle skidded and the occupants were knocked down, and the claimant Muruman Satidara and the rider as well as the deceased Ramkrishna succumbed because of the injuries. The extent is in because of rash and negligent riding on the part of the rider late Ravi. The claimants, being the widow, minor children, and parents of the deceased, filed claim petition under section 166 of any act claiming compensation of rupees 20 lakhs with interest thereon. Next. After assessing the oral and documentary evidence, the tribunal has held that claimants would be entitled for total compensation of rupees 14,20,000. However, it has fastened 20% contributory negligence on the part of the deceased and hence awarded a total compensation of rupees 11,36,000 with interest at the rate of 6% per annum. Further, since the rider was not possessing valid and effective driving license, the liability was fastened on respondent number 1 owner. Next, being aggrieved by this judgment and award, the claimants are before this court by way of appeal. Next, heard the arguments advanced by the learned counsel for appellant. You are for insurance company, no? The arguments advanced by the learned counsel for appellant and learned counsel for the respondent number 2 insurer. Perused the records. The learned counsel for appellant would contend that the tribunal has committed an error by fastening 20% liability on the claimant, on the deceased himself, on the ground that it was a triple riding. He would further contend that the tribunal has also erred in taking the income on lower side and not awarding proper compensation under the head of consortium. As such, he further argues that the tribunal has also committed an error by fastening the liability on the owner instead of insurer, as claimant would be third party. Hence, he would seek for enhancement of the compensation by fastening the liability on respondent number 2 insurer. Next, per contra, the learned counsel for respondent number 2 insurer would support the judgment and award passed by the tribunal. However, he would contend that in case the liability is fastened on the insurance company, an order regarding pay and recovery needs to be passed considering the breach of policy conditions. Next, having heard the arguments and perusing the reports, it is evident that deceased along with rider and another pillion rider were proceeding on a two-wheeler and it was a triple riding. The rider lost the control. As a result, the vehicle fell and both the rider as well as the husband of claimant appellant number 1 succumbed because of the injuries sustained in the road traffic accident. Considering the triple riding, the tribunal has fastened 20% contributory negligence on the part of the deceased himself. Though initially this contribution, this 20% contributory negligence was disputed by the learned counsel for appellant claimant, however, during the course of the arguments, he fairly submit that he is not pressing that point in view of the fact that it was a triple riding. Hence, the finding of the tribunal regarding fastening the liability or contributory negligence to the extent of 20% on the deceased himself does not call for any interference. Next. The tribunal has taken the income of the deceased at 7,500 per month. 7,500 ತಗೊಂಡಿದ್ದಾರಲ್ರಿ?
25%.
Hello. Has taken the income of the deceased at 8,000 per month. Admittedly, the extent has occurred in the year 2016. This court is consistently taking the income, notional income, in respect of the extents occurred in the year 2016 at the rate of 9,500 per month. Hence, tribunal has committed an error in taking the income on lower side. Considering age of the deceased as 40 years, tribunal has rightly added 25% of future prospects. If 9,500 is taken as notional monthly notional income, and if 25% is added, the loss of income, the monthly income would work out to 11,875. There are 5 dependents on the deceased, and hence the tribunal has rightly deducted 1/4 towards his personal expenses. Hence, loss of income, future loss of income dependency would work out as 11,875 into 12 into 15 into 15 into 3/4. 16 lakhs 3,125 would work out as 16 lakhs 3,000 31 16 lakhs 3,000 3,125 as against 13 lakhs 50,000 awarded by the tribunal under the head of loss of dependency. Next, the tribunal has awarded rupees 40,000 as consortium to claimant number 1 alone, but in view of the decision reported in Pranay City as well as Magma and Satvinder Singh, each claimant would be entitled for 40,000 under the head of loss of consortium, and hence the claimant should be entitled for 2 lakhs under the head of consortium. Further, claimant should be entitled for 15,000 under the head of loss of estate and 15,000 under the head of funeral expenses. Hence, claimants would be entitled. In normal circumstances, claimants would be entitled for total compensation of rupees 16,3,125. 18,33,125 as against 14,20,000 as decided by the tribunal. Next, as the deceased has contributed 20% to the extent out of total compensation of 18,33,125, 20% is required to be deducted. As such, claimants would be entitled for total compensation of rupees 14,66,500 as against 11,36,000 awarded by the tribunal. I cannot. Enhanced is 6%. Enhanced is 6%. But awarded in NIM appeal, I cannot reduce it. Enhanced is 6%. That is standard. The tribunal has exonerated the liability of respondent number 2 insurance company on the ground that the deceased rider was not possessing valid DL. However, this issue has been covered in the decision reported of the Pappu. And as such, the tribunal and the insurance company is liable to pay the compensation with a liberty to recover the same from owner respondent number 1. As such, appeal needs to be allowed in part, and accordingly, I proceed to pass the following order. The appeal is allowed in part. The claimant should be held entitled for total compensation of 14,66,500 as against 11,36,000 awarded by the tribunal. Next, the enhanced compensation of rupees 3,30,000 30,500 shall carry interest at the rate of 6% per annum from the date of petition till realization. The insurance company is directed to pay the entire compensation awarded to the claimant with directed to pay the entire directed to deposit the entire compensation awarded within a period of 6 weeks from today, with a liberty to recover the same from the respondent number 1 owner. The disbursement, deposit, disbursement, and apportionment shall be as per the terms of the award of the tribunal.
Number 48, Yogesh DK. Number 48, Yogesh DK.
ನಿಮ್ ಕಲಿಗ್ ಇಲ್ಲಲ್ರಿ list next week and learned counsel for appellant absent list next week. On the ground of delay in filing claim. Petition. Under the WC Act section 10 of WC Act, claim petition. Section WC Act kalaga. 2 years. Claim petition has to be filed. We have filed an IA for condemnation of delay. IA is at page number 141 means. Page number 146 of the. Is at page number 146. Unnumbered para number. Para number 3. Unnumbered. Yes. I am taking treatment as inpatient and outpatient in various hospitals and clinics. Given to this date due to closure of labor office to Durga, typically will not be due to confusion where the petition to be filed for compensation, I unable to understand properly where the petition is filed. Due to my confusion, I unable to understand properly where the petition is filed. Due to my confusion and also closure of labor court at General Bank since long time, I am able to file my petition well in time. Else, the delay is caused. Filing the petition is not intentional and it is one of the labor courts were closed during that time. And jurisdiction has been withdrawn from the labor court and it has been assigned to the senior judge. There is a long delay in issuing notification also. There was a clear confusion, labor courts were closed and they are not receiving. And that too, yes. Are you sure that there is a long delay? Agar immediately labor court close aad takshana additional district judges were nominated as a labor courts, not civil judges. Additional district judges were nominated as a labor courts. WC. That the finding of the trial court is at page number 12, para number 12. That's page number 11. The provisions of delay. So the first of half portion of section 10 has been extracted, para number 11. And the proviso has not been considered liberally. Proviso to section 10. Provided further that if a workman who having been employed in employment for a continuous period. Yeah, because there are number of provisions. Which proviso you are reading? Yeah, provision provisos bada section.
provided that first provision.
Yes.
Provided where the account is in contracting of a disease in respect of section 2 in the month lost provision.
Section. Last proviso. Yes. Provided further that the commissioner.
Any claim to compensation in any case not withstanding the notice has not been given or the claim has not been given in a due time as provided in the subsection. If he is satisfied that will you slow to give the notice or prefer the claim as the case may be was processed. This proviso has not been properly considered. There are only prescriptions has been considered. And the prescriptions of section 10 has been considered.
Yes.
And the finding of the trial court is claim petition was filed in the year 2014. Assent is on 22/4/2011. Claim petition was filed on 7/11/2014. And there is a 3 years 6 months. 3 years 6 months. 3 years 6 months 15 days. That's absolutely 1 year 6 months 15 days.
Yes.
Finding of the tribunal, my lord, is trial court is that the documents produced for treatment does not disclose that he was in the taking the treatment does not always mean that it should be indicated for all the long period. Yes, sustained.
What was the nature of injury?
It's a fracture of left femur. And he was a workman. And a signature of the and is not having the knowledge of legal proceedings.
Not a ground.
Proviso may leniently consider my lord.
Allah, not a ground. Legal provision knowledge illa another ground illa because he will not file personally. All along he will move through counsel only.
But it's not the only ground.
Allah, that is a different aspect we will consider. But if that is to be considered, the matter requires to be remanded only if court comes to a conclusion that is required. What is the other side?
The other side, Badmilla actually was the protected. Last time also we did
No.
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
The learned counsel for third, the learned counsel for appellant, the learned counsel for respondent is absent. Which the matter? Tomorrow. To hear counsel for respondent.
ನಾವು ಹೇಳಬಾರದು ವಕೀಲರುಗಳಿಗೆ ಏನಾಗಿದೆ ಪೊಲೀಸ್ ಎಫ್ಎಂಡ್ ಆಕ್ಟ್ ನಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು ಇಲ್ಲಿ ನೋಡ್ತೀರಾ
ನಾವು ಅದನ್ನ ನಾವ್ ಹೇಳಿದ್ರೆ ತಪ್ಪಾಗತ್ತ ಅಫೆಂಡಿಂಗ್ ಆಗತ್ತೆ ಅಲ್ಲ ನಾವ್ ಹೇಳಿದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಟೇಕನ್ ಇನ್ ಅಫೆಂಡಿಂಗ್
ಪಾಠ್ಯ ಮೆರೋನ ಸ್ವಲ್ಪ ಬಂದು ಮುಗಿಸ್ಕೊಂಡು ಹೋಗೋದು ಸೋಲ್ಬೋದು ತಿಳ್ಬೋದು ಇದು ಹಾಕ್ಬೇಕು ಅಂತ
ಈ ನಮ್ಮಲ್ಲಿ ಉಳಿದಿದ್ದೆಲ್ಲ ಅವೇ
ನಮ್ಮ ವಕೀಲರುಗಳಿಗೆ ಆ ಥರದೊಂದು ಲೆಟರ್ಜೆಟಿಕ್ ಮೈಂಡ್.
Pass over matter. Number one, pass over. AM Vintage. ಇನ್ನು ಕೊಡಬೇಕು ಎಲ್ಲಿ ಕನ್ಸರ್ನ್ ಪೇಜ್ ಮಾತ್ರ ಕನ್ಸರ್ನ್ 2 ಪೇಜ್ ಮಾತ್ರ ಫುಲ್ ಪೇಪರ್
It is noticed that the paper publication is not in full and the entire paper is also not, it is noticed that though the paper publication is produced, it is only pertaining to particular page. In the entire paper, the newspaper is not produced. The learned counsel is directed to produce the entire copy of the newspaper.
Number 21.
The learned counsel for appellant absent. ಬೆಳಿಗ್ಗೆ ಅವರೇ ಕೀಪರ್ ಬೆಳಿಗ್ಗೆ ಪಾಸ್ವರ್ಡ್ ನೀವು ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು ಅವ್ರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು ಅವರೇ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು. Even in the first call also there was no representation, at least after 1 week.
Number 36. Comments. Number 36. Comments.
The learned counsel for appellant. You respondent, huh? The learned counsel for appellant and respondent absent, no representation, at least after 2 weeks.